Segregated the days on which the petitions will be listed.
Sir, Monday up to 2018 matters, B group and final hearing. Tuesday, 2019 and 20, B group and final hearing. Wednesday, 2021 and 22, B group and final hearing matters. Thursday, 23 and 24, B group and final hearing matters. Friday, others and judicial officers and staff of the High Court matters.
This is how we are done. You please pass over the memos. It will be listed on that particular days. First thing ಇಟ್ಕೊಳ್ಳಿ ಮೆಮೊ ಹೆಂಗ್ ಇಟ್ಕೊಳ್ಳಿ ಇವಾಗ ಹೇಳಿ ನೀವು ವರ್ಚುವಲ್ ಹಿಂಗೆ ತಳ್ತಾ ಇದಾರೆ ಮೆಮೊನ ಕೈಲಿ ಇಟ್ಕೊಳ್ಳಿ ಏನು ಐ ಆಮ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ರನ್ ಅವೇ ಆಯ್ತು ಕೊಡಿ ಆಯ್ತು ನಾಳೆಗೆ ಬಂದ್ರೆ ಏನಾಗುತ್ತೆ ರಿಲೀವ್ ಆಗುತ್ತೆ ಆಯ್ತು ಪೋಸ್ಟಿಂಗ್ ಕೊಡ್ಸೋಣ ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ ಎಷ್ಟು ನಾಳೆಗೆ ಹಾಕಿ 2024. To say the I told still number 51. 51, the learned counsel for the petitioner has filed a memo to withdraw the writ petition. The memo is taken on record and the petition is dismissed as withdrawn. Yes, please. 56.1. Same order, 56.1. I told you.
2021 matter.
Yes. Hand over all the memos. We list it on those particular days. Which are, yes.
Urgent means page wise. Page number 7, serial number 29 to 33. Page number 8, serial number 34 to 37.
Serial number 35, my lord. I'm appearing for respondent number 2. In this matter, my lord, I was required to secure the records from the university pertaining to the selection of petitioner to the post of assistant commissioner. My lord, may I request 3-4 days time, my lord.
Was it listed earlier?
Last week list agit.
No adjournment.
My lord,
Yes, sorry.
I could not secure the record for the reason, my lord.
I gave you 2 adjournment on the last date.
Only to secure the record.
Do whatever you want, but 2013 no adjournment.
Only 3 days accommodation.
Sorry. Next.
My lord,
I'll hear the petitioner's counsel and decide the case. I will not wait. These old matters cannot wait even for a single day.
Ivat records partha. Kindly have it
Do
there.
whatever you want. I'll dispose of these cases. 2013, it can't wait even for one day. It shouldn't wait. This is
sorry,
career.
Page number 9, serial number 38 to 44. Page number 10, serial number 45 to 50. Page number 11, serial number 52 and 53. Page number 12, serial number 54 to 56. Page number 13, serial number 57 to 60. List number 1 for non-compliance first time, serial number 1. Nijalingappa, BC.
2 weeks.
Serial number 2, K. Shobha.
2 weeks.
Serial number 3, Rakesh B. Bhatt.
2 weeks.
Serial number 4, Narayan Bhatt.
2 weeks.
Serial number.
Are there only 2 responses? How many responses are there? So accepts notice for respondent number 2. Office is directed to show. What about office objections?
My lord, this office has raised an objection to produce the full seniority list.
Hmm.
But it may not be necessary. I have only produced the relevant portion.
ಎಲ್ಲಿದೆ?
My lord, it is at annex.
Office objection, the office objection serial number 1 is overruled by accepting the submission of the learned counsel for the petitioner that the relevant portion of the seniority list annexure K is produced. Full stop. ಯಾವತ್ತು ಬೇಕು?
Any day convenient, your lordship.
2025 ತಾನೇ ಬರ್ಲಿ, ನಿಧಾನ ಬರ್ಲಿ.
ಇಲ್ಲ, ಇದರಲ್ಲಿ only for mandamus, my lord.
Mandamus for what?
Consider my representation for promotion.
ಇಲ್ಲ ಅದು ವೇಕೆನ್ಸಿ ಇದೆಯಲ್ಲ ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡೆ.
ಲಿಸ್ಟ್ ಆನ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ? ಯಾವತ್ತು ಬೇಕು? Take whatever date. Yes, put on date.
26th,
Srinivasa K.
26th March. Serial number 5, Srinivas K.
Subjection is not only regarding non-filing of this synopsis in chronological order and certain dates have been left out. I will file them order yesterday in the evening, during the course of the day. My lord.
Copy to be served to Bescom.
Please.
Hmm.
Any standing counsel.
Yeah, what is the relief sought for?
Relief sought, my lord, is to petitioners, my lord, or appointed prior to, my lord, 7/5/2007.
Hmm.
My lord, they have, my lord, they have to be covered under the, my lord, old pension scheme. As per the, my lord, the notification issued by the respondent K
But
petition.
these are covered matters.
Yes, my lord, in similar cases, the Istanbul court has already disposed of several cases.
List code here. Panel advocate list. AJ is directed to accept notice for respondent number 1. HV Devaraju is directed to accept notice for respondent. Either Devaraj KPTCL.
Yes, yes, he appears for both K petition and.
2, 3, 4, 5, 6, 7. Yes. The learned counsel for the petition undertakes to comply the office objections.
Please.
Same is noted.
Serial non-compliance 4 times, serial number 6, Kalimullah.
1 week time, my lord. Last occasion I took time, my lord. I could not, file was not traced. That's why I
2 weeks time is
I
granted to do the needful.
Orders matters, M Narayan Bhatt, serial number 7.
Reporting complaints for law. Yen putri adeno. What is this reporting complaint?
Lord, reporting compliance.
ಏನಾಗಿದೆ ಅಂದ್ರೆ
Hmm.
ಪರ್ಮಿಷನ್ ಕೊಟ್ರೆ
ಏನಿದು?
permission ಮಾಡಿ. We have returned it to the state government. The state, your lordships have said responded, sir. I'm not saying that your lordships, I mean, stay in this person after disposal may not, I'm not taking. We have only communicated to the state government in respect of compliance of the order of this honorable court. They are also equally responsible.
Hmm.
I am only requesting, my lord, that we have done our job of communicating to them because A and B in the now ಬರೋದಿಲ್ಲ. ಅದು government ಅವ್ರು ಕೊಡ್ಬೇಕು.
Yes, government.
Government, if they take the responsibility, my lord.
ನೀವು ನೋಡೋದಲ್ಲ ಯಾವ ಕಮ್ಯುನಿಕೇಟ್.
ನಾನ್ ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀನಿ ಅವ್ರು.
They learned counsel for the respondent number
ನಾನು respond.
number 2 na Mysore Medical College. Mysore. The respondent number 2 submits that the respondent number 2 has escalated the issue regarding complaints of the order passed by this court. And it is the state government that has to take a decision. Full stop. The learned AGA submits that he would seek instructions regarding complaints of the order. So hence list after 2 weeks. List on date put. 2 weeks admal date.
26th March,
Machum.
serial number 8, Balraj AC.
Yes, Balraj. Yes, Balraj.
Annexure you final select list, my lord, to the post of social security.
ಏನಿದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ IA 1 and 2 ಏನಿದು?
Even,
Including.
amend,
A1 including.
selected candidates were made parties, madam.
This is for some amendment, IA 2 of 17. Office objections on IA. Respondent number 3 be deleted from the array of parties. IA 1 of 2017 is filed by the petitioner for deletion of respondent number 3 from the array of parties. In view of the application, in view of the application filed by the petition is allowed at the risk of the petitioner. Yeah, ಆರ್ಡರ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಲ್ವಾಗಿದೆಯಲ್ಲ.
ಅದೇ 12/6/23 ಆರ್ಡರ್ ಆಗಿದೆ.
ಅದು ಹೊಡೆದಾಕ್ಬಿಡಿ. IA 1 of 17 is already allowed by this court. And therefore, what about IA 2 of 17?
It too, my lord, that is for amendment.
Hence, no orders are warranted on the application IA 1 of 2017. List on Yavat, when do you want it?
Next week,
Yavat on date, could see Srinivasa?
it can be dispersed of now itself, my lord, because 2012 selection, all appointment, everything is completed.
It has become infructuous.
Infectious illa, but we are challenging the select list, my lord, final select list, my lord, saying that candidate
2012 selection list you challenged in 2015.
15, my lord. They were not issued with, subsequently, 2 more additional lists were published. My condition that the persons who has scored lesser marks were given, were included in the select list. My name was deleted. However, now they have filed an objection saying that the weightage which was to be conferred on me, at that I am not eligible for 1 year. Only for 3 years I am eligible, not for 4 years. So on that score, my lord, my percentage will become lesser, my lord. And candidates who are selected will be more.
It doesn't survive, but put it. The petitioner has challenged the final selection list bearing number so-and-so dated 17/3/2014, published by the respondent number 2, insofar as it relates to the inclusion of the name, insofar as it relates to the respondent number 3. The petitioner has also sought for writ in the nature of mandamus to direct the respondents to consider his representations dated 14/7/2014 and 9/1/2015 and to include his name in the full select list. Next para. The petitioner contends that the petitioner that he was working as a teacher.
He was working as principal, my lord, on outsource basis, my lord, from 2007.
Teacher ಅಂತ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿ para 3 ನಲ್ಲಿ not as principal.
Next year.
The petitioner contends that he was appointed as an assistant teacher in social studies and later was placed as in-charge principal through outsourced agency at Morarji Desai Residential School, Davangere. Full stop. He continued till the year 2014. When the respondent issued a recruitment notification. Full stop. The petitioner participated in the recruitment process, but was not selected. He thereafter filed a writ petition before this court for regularization of his service. Full stop. This court disposed of the writ petition directing dispose of the writ petition granting weightage for the past services rendered by the petitioner through the outsourced agency. Full stop. The petitioner contends that the governing council of the respondent number 2 took a decision to absorb the persons working as principal and teachers in Morarji Desai and Kittur Rani Chennamma residential schools on contract basis. Accordingly, a notification was issued on 7/5/2011 by which 459 persons were absorbed. Full stop. Absorbed pursuant to the Karnataka Residential Education Institution Society bracket absorption of persons working as principals and teachers in Morarji Desai and Kittur Rani Chennamma residential schools on contract basis into the establishment of Karnataka Residential Education Society bracket special regulation 2011. The petitioner contends that his name was left out, though he fulfilled all the conditions prescribed in the rules. Full stop. Later, the respondent number 1 published another notification dated 21/1/2011 specifying the cadre and recruitment rules. In the said rules, weightage of 5% was given to each person for every completed year of service, subject to maximum 40% as a one-time measure. The petitioner submits that the respondent number 1 had invited applications from eligible candidates to fill up the post of teacher in various subjects by a notification dated 27/4/2011. Full stop. He contends that some teachers who are working on contract basis through agencies while WP number 20204-20366/2011 and connected petitions, where this court directed the respondent number 1 to regularize the principals and teachers appointed on contract basis and also declared that they were entitled for service weightage. This was challenged in Writ Appeal 5127/2017, where the division bench upheld the direction issued by the learned single judge. Petitioner contends that the respondent number 2 published a weightage list of candidates on 7/7/2014, where the name of the petitioner was not found. The petitioner submitted representations and requested the respondent number 2 to include his name. However, the respondent number 2 announced the final select list, selecting candidates who had lesser percentage than him. The petitioner is therefore before this court challenging the selection. Full stop. Next paragraph. The learned counsel for the petitioner reiterated the above contentions and contended that the petitioner was entitled to service weightage, and if granted, he had a fair chance of being selected. He also contends that many candidates who had secured lesser percentage were selected, and therefore the impugned selection has to be set at naught, and the petitioner is entitled to be declared as selected. Full stop. Next paragraph. The writ petition is opposed by the respondent number 2, who contends that the petitioner was not entitled to weightage as principal. Why?
As per the cutoff list.
40%.
No, principal category 1, 66.50. Your 60 cutoff mark.
How much has he secured?
He secured
63. 63.3.
No. He
Oppose.
issued as under the examination 48.3.
Wait.
Plus weightage?
Given 67.33 and three service you have given 5%. It total, my lord, 63.3.
So yes, how much is the, what is the, how much is it secure? 48.3.
48.3.
And for 3 years service, 15%. ಎಷ್ಟಾಗುತ್ತೆ ಅಲ್ಲಿಗೆ?
63.3.
3 ಆಗುತ್ತೆ. What is the cutoff?
Cut off 67.33.
ಏನ್ ಮಾಡಬೇಕಾಯ್ತು? The petitioner was not entitled to be selected as he had secured 48.3% marks in the selection. And he was granted weightage for weightage at the rate of 5% for 3 years of service. And therefore, the total marks secured by the petitioner was 63.3%, while the cutoff percentage for selection to the post of principal was 67.33%. What is it total? 67.33% cutoff.
Principal, my lord, 66.15.
66.15.
66.15.
Full stop.
Studies, my lord, 67.33.
And in respect of teacher who had qualified in social studies, the cutoff marks prescribed was 67.33. He therefore contends that the petitioner was rightly not selected. Full stop. Next para. The learned counsel for the petitioner did not dispute the fact that the petitioner had secured only 48.3% of the marks, and that that he was granted weightage of for the 3 years of service that he had put in as a principal. Full stop. Therefore, the total percentage of marks that the petitioner secured was 63.3%, which was less than 66.15% prescribed for the post of a principal and 67.33% prescribed for a teacher in social studies. Full stop. Therefore, there is no error committed by the respondents in selecting the respondent number 3 or any other candidate who had secured more than what the petitioner had secured. Under the circumstances, no interference is warranted in this writ petition. Hence, the writ petition is dismissed. Please.
Serial number 9, MP Srikanth.
Copy served on the advocate for petitioner. To the learned counsel for response 4 and 5. Copy serve ಮಾಡಿದ್ರೆ?
Lordship, yes, your lordship, in 10/2/2025,
ಎಲ್ಲಿದೆ? ಹೆಂಗ್ ಮಾಡಿದಿರಿ?
acknowledgement.
ಬರ್ಕೊಳ್ಳಿ. The petitioner has placed on record an acknowledgement for having served copy of the writ petition to the learned counsel for the respondents 4 and 5. ಯಾರು? ನಾಗರಾಜಪ್ಪ. The same is taken on record. Full stop. List for preliminary hearing in B group on date. Put. Nandish Patil.
Lordship, I appear for the respondent number 2 in 10.1, Lordship. On last date of occasion, Lordship has directed me to serve a copy to the respondents, and I have forwarded the copy to the director to serve on the respondents, Lordship.
Yes.
I'm just waiting for the acknowledgement to file, Lordship. If short accommodation is given, I'll ensure that it is filed, Lordship, for serving the copy.
Being served on, madam.
The respondent number 3.
Last time your lordship said permitted me to serve it.
Barkul. The learned counsel for the petition has placed on record acknowledgements for having served copy of the writ petition to the respondent number 3. The same is taken on record. Since the notice of the writ petition is served on the respondent number 3, office is directed to show the name of respondent number 3 as served in the cause list. List on the
Next week, any date may be given.
date for 2023 note. Thursday.
Please. Okay.
Yes. Rama Reddy.
Obliged, Lordship.
Number 11.
Memo filed to the learned counsel for the petitioner to withdraw the writ petition. Yeah. Liberty ಏನಕ್ಕೆ? Why you want liberty, mister?
I have filed this writ petition seeking a direction to appoint me on the compassionate road against the health
No,
department.
correct, but then why you seek liberty? Take an order on merits.
The-
Either you want liberty.
I will withdraw the movement.
File a better memo then. File a simple memo. Response 3 and 4 have instructed me to withdraw this writ petition filed against the government.
Yes, yes.
Hence, I have instructed my advocate to withdraw the vote and will promise made with the response 3 and 4. ಹಂಗೆಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ. Correct ನೀವು ಇಲ್ಲ ಆರ್ಡರ್ ತಗೊಳ್ಳಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ.
Right now, I will my.
The Land Council has filed a memo to withdraw the writ petition. In view of the, has filed a fresh memo on it. Fresh memo, has filed a fresh memo today to withdraw the writ petition. The memo is taken on record and the petition is dismissed as withdrawn.
Serial number 12, Viresh. Mahesh.
Petitioners in the Mysore University as well as Mandya University. Plot facts are this plot. These petitioners plot
ಯಾವ್ದು IA 2
IA for direction plot.
correct IA 2
Copies served plot last time.
office objections, copy to be served on respond number 2.
It was served plot. He was present before the court, before court
Abhishek
only
K.
was served.
Who is Abhishek?
Millards, I appear, Millards.
Yes. What is pay the salary? If you have extracted work, why don't you pay the salary?
Millards, that is with respect to Mandya University. Now, Millards, what has happened? Mysore University, Millards, bifurcated it to 3 different universities. Now, the petitioners before your lordships is Millards, stating that, Millards, since the bifurcation, the salary is not paid. They are not the employees of Mysore University anymore, Millards. Till they work along with us, we have paid the salary. It is not their contention that we have not paid it.
Till what date have you paid the salary?
Millards, till 9/9/2023, Millards, we have paid a salary. That's they are not disputing also.
9/9?
2023, the academic year of Millards 22-23 ended there. Annexure C, Millards,
This
is the
comes with
bifurcation.
Now, does this come under the Mandya University?
Now, Millards, all these petitioners come under the Mandya University.
Yeah, who appears for Mandya University?
Oh, H.C. Shuram appears.
Transferring one clarification, Milord. September, Milord, actually Mandya University, Milord, this PG center was transferred to Mandya University with effect from 5/11/22. Now, just now, my learned friend admitted that he has paid salary only up to September.
No, but the process has to complete, Allah.
Yes,
There
Milord.
could be a formal order transferring, but the
Yes,
process.
Milord. Before, up to that, Milord,
Anyway, they say that up to September 23, they are paid.
October, November, December, they have to pay Mysore University.
No, if you have extracted work, pay the salary.
That's what I am confused with. They are not transferring after the establishment of the Mandya University in 2019. In 2022, as per annexure J, may not maintain the C. They are not transferred the leave of their service to lordship. There was a break in service, they stopped there. Then afterwards, since more than 6 to 7 months will be the date of passing this order. They have taken the work, they have not given the attendance, University of Mysore. Thereafterwards, they are transferred to the Mandya University without transferring the leave. Therefore, we are unable to take them.
Correct. See, salary is paid for the work done. Where have they worked?
There is no budget allocation to Mandya University. Now, since there is no budget allocation to Mandya University, the leave itself was not transferred. Mainly see annexure J for moment page 73.
Yes.
Our lien transfer ಮಾಡಿದ್ರೆ ಕೂಡ plus proceeds they are looking since 2009-2010 lordship. University, unlike other university, they would have transferred their lien also to the Mandya University. We would have sought for voluntary allocation because of the lien transfer to our university. They simply passed this order. Annexure J, page 73.
Now, where is the order bifurcating Mysore University? into-
Yes, annexure B, your lordship may kindly see. Annexure B is the order, my lord, including, my lord, this PG center to Mandya University.
ತೋರ್ಸಿ ಓದಿ.
50. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ
No,
ಅಂಶಗಳ
in page
ಹಿನ್ನೆಲೆಯಲ್ಲಿ
In page 15 of what?
50.
50.
My read petition, my lord.
Yes.
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ 22-23ನೇ ಸಾಲಿನ ಆಯವ್ಯಯದಲ್ಲಿ ಘೋಷಿಸಲಾದಂತೆ ಸಾಂಪ್ರದಾಯಿಕ ವಿಶ್ವವಿದ್ಯಾನಿಲಯಗಳಿಗಿಂತ ಭಿನ್ನವಾಗಿ ತಂತ್ರಜ್ಞಾನದ ಗರಿಷ್ಠ ಬಳಕೆಯೊಂದಿಗೆ ಹೆಚ್ಚುವರಿ ಮಾನವ ಸಂಪನ್ಮೂಲ ಉಪಯೋಗಿಸದೆ ಲಭ್ಯವಿರುವ ಸಂಪನ್ಮೂಲಗಳನ್ನು ಬಳಸಿ ಚಾಮರಾಜನಗರ, ಬೀದರ್, ಹಾವೇರಿ, ಹಾಸನ, ಕೊಡಗು, ಕೊಪ್ಪಳ ಮತ್ತು ಬಾಗಲಕೋಟೆ ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಸ್ಥಾಪನೆಗೊಂಡಿರುವ ವಿನೂತನ ಮಾದರಿಯ 7 ವಿಶ್ವವಿದ್ಯಾನಿಲಯಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮತ್ತು ಪ್ರಸ್ತುತ ಏಕಾತ್ಮಕ ಸ್ವರೂಪದ ವಿಶ್ವವಿದ್ಯಾಲಯ ಆಗಿರುವ ಮಂಡ್ಯ ವಿಶ್ವವಿದ್ಯಾಲಯವನ್ನು ಸಂಯೋಜಿತ ವಿಶ್ವವಿದ್ಯಾಲಯವನ್ನಾಗಿ ಪರಿವರ್ತಿಸುವ ಸಂಬಂಧ ಆರ್ಥಿಕ, ಭೌತಿಕ ಹಾಗೂ ಮಾನವ ಸಂಪನ್ಮೂಲಗಳ ಕುರಿತಂತೆ ಈ ಕೆಳಕಂಡ ಷರತ್ತುಗಳನ್ನು ವಿಧಿಸಿ ಆದೇಶಿಸಿದೆ. ಮೈಸೂರು ವಿಶ್ವವಿದ್ಯಾಲಯ ಚಾಮರಾಜನಗರ, ಹಾಸನ, ಮಂಡ್ಯ. ಆ ಮಂಡ್ಯಕ್ಕೆ ಸರ್ ಎಂ ವಿಶ್ವೇಶ್ವರಯ್ಯ ಸ್ನಾತಕೋತ್ತರ ಕೇಂದ್ರ ಮಂಡ್ಯ. This is included from Mysore University. Now, conditions your lordship may ಖಂಡಿಸಿ. ನೂತನ 7 ವಿಶ್ವವಿದ್ಯಾಲಯಗಳು ಪ್ರಸ್ತುತ ಇರುವ ಸ್ನಾತಕೋತ್ತರ ಕೇಂದ್ರಗಳಲ್ಲಿಯೇ ಕಾರ್ಯನಿರ್ವಹಿಸತಕ್ಕದ್ದು. ನೂತನ 7 ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಸ್ಥಾಪನೆಗಾಗಿ ಯಾವುದೇ ಜಮೀನನ್ನು ಖರೀದಿಸುವಂತಿಲ್ಲ ಹಾಗೂ ಹೊಸ ಕಟ್ಟಡಗಳನ್ನು ನಿರ್ಮಿಸುವಂತಿಲ್ಲ. ಈಗಾಗಲೇ ಮಾತೃ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳಲ್ಲಿ ಮಂಜೂರಾಗಿರುವ ಹುದ್ದೆಗಳಲ್ಲಿ ಅವಶ್ಯ ಹುದ್ದೆಗಳನ್ನು ಈ 7 ವಿಶ್ವವಿದ್ಯಾಲಯಗಳಲ್ಲಿ ಬಳಸಿಕೊಳ್ಳುವುದು ಹಾಗೂ ಯಾವುದೇ ಹೊಸ ಹುದ್ದೆಗಳನ್ನು ಸೃಷ್ಟಿಸುವಂತಿಲ್ಲ. ಈ ಉದ್ದೇಶಕ್ಕಾಗಿ ಯಾವುದೇ ಹೊಸ ಹುದ್ದೆಗಳನ್ನು ಸೃಷ್ಟಿಸುವ ಬಗ್ಗೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವಂತಿಲ್ಲ. ನೂತನ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳು ಮತ್ತು ಸಂಬಂಧಪಟ್ಟ ಮಾತೃ ವಿದ್ಯಾಲಯಗಳಿಗೆ ಹಂಚಿಕೆಯಾಗಿರುವ ಪ್ರಾದೇಶಿಕ ಅಧಿಕಾರ ವ್ಯಾಪ್ತಿ ಮತ್ತು ಈ ಪ್ರಾದೇಶಿಕ ಅಧಿಕಾರ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡುವ ಸಂಯೋಜಿತ ಕಾಲೇಜುಗಳ ಆಧಾರದ ಮೇಲೆ ಬೋಧಕ, ಬೋಧಕೇತರ ಹುದ್ದೆಗಳನ್ನು ನಿರ್ದಿಷ್ಟ ಅನುಮತದೊಂದಿಗೆ ಮರು ಹಂಚಿಕೆ ಮಾಡಲು ಸಂಬಂಧಪಟ್ಟಂತೆ ಆಯಾ ಮಾತೃ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳಲ್ಲಿ ಕುಲಸಚಿವರು, ಆಡಳಿತ ಇವರು ಈ ಆದೇಶ ಹೊರಡಿಸಿದ ದಿನಾಂಕದಿಂದ 15 ದಿನಗಳೊಳಗಾಗಿ ಸರ್ಕಾರಕ್ಕೆ ಅಗತ್ಯ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸತಕ್ಕದ್ದು. ಕ್ರಮ ಸಂಖ್ಯೆ 4ರಂತೆ ಕ್ರಮವಹಿಸುವವರೆಗೆ ಪ್ರಸ್ತುತ ನೂತನ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಕೇಂದ್ರ ಸ್ಥಾನವಾಗಿ ಪರಿವರ್ತನೆಗೊಂಡಿರುವ ಸ್ನಾತಕೋತ್ತರ ಕೇಂದ್ರಗಳಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಬೋಧಕ, ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಗಳು ಆಯಾ ಸ್ನಾತಕೋತ್ತರ ಕೇಂದ್ರಗಳಲ್ಲಿಯೇ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸತಕ್ಕದ್ದು. That means, my lord, persons, those who are working in the PG center, they have to continue. Now, my lord, Mysore University Annexure C, ink page 53, my lord, issued notification transferring our services to Mandya University. That your lordship get it, my lord, ink page 54.
Yes.
ಸ್ನಾತಕೋತ್ತರ ಕೇಂದ್ರಗಳಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಬೋಧಕ, ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಗಳು ಆಯಾ ಸ್ನಾತಕೋತ್ತರ ಕೇಂದ್ರಗಳಲ್ಲಿಯೇ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸತಕ್ಕದ್ದೆಂದು ಆದೇಶಿಸುತ್ತಾರೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪ್ರಸ್ತುತ ಮೈಸೂರು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಸ್ನಾತಕೋತ್ತರ ಕೇಂದ್ರಗಳಾದ ಚಾಮರಾಜನಗರ, ಹಾಸನ ಮತ್ತು ಮಂಡ್ಯ ಕೇಂದ್ರಗಳಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಉದ್ಯೋಗಿಗಳನ್ನು ಹುದ್ದೆ ಸಮೇತ ಸದರಿ ವಿನೂತನ ಮಾದರಿಯ ನೂತನ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳಲ್ಲಿಯೇ ತಮ್ಮ ಸೇವೆಗಳನ್ನು ಮುಂದುವರಿಸಲಾಗಿದೆ ಹಾಗೂ ಸದರಿ ನೂತನ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಬೋಧಕ ಮತ್ತು ಬೋಧಕೇತರ ಉದ್ಯೋಗಿಗಳ ವಿವರ ಈ ಕೆಳಕಂಡಂತಿದೆ. ಇಂಕ್ ಪೇಜ್ 55 3 ಸ್ನಾತಕೋತ್ತರ ಕೇಂದ್ರಗಳಲ್ಲಿ ಕೆಳಗಡೆ ಬಾಟಮ್ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ತಾತ್ಕಾಲಿಕ ಅಧ್ಯಾಪಕೇತರರ ವಿವರ. ಇನ್ ದಿಸ್ ಲಿಸ್ಟ್, my lord, our names are there, my lord. In spite of this order, my lord.
Where is your name?
Yes, my lord.
ನಿಮ್ಮ ಹೆಸರಲ್ಲಿದೆ.
First, Krishna Shetty, my lord, serial number 13. ಎಲ್ಲಾರ್ದು ಇದೆ actually. ಎಲ್ಲಾರ್ದು ಇದೆ.
Serial number 3, my lords, 8, 9, 10, 13, 18, 19, 20.
Then how did you pay the salary up to September 23?
My lords, this order came to be passed, my lords, with the university on
9/11/22.
Please, my lords. Then, my lord, we had cleared. They didn't have any problem with the Mysore University. Post facto, my lords.
How did you pay the salary in September 23? When you transferred these people to Mandya University, how did you pay salary?
You have taken work by lot after at that time. You have taken the work from them for a year.
Yes, when will you transfer the lien?
My lords, That was not the case, my lord. In that case, my lord, let them pay give the representation. We'll consider, my lord, because
What
my
about the
instruction-
salary? How will they survive, mister?
my lords,
Somebody
their
is-
main case is, my lords, now they have removed from the Mandya University. This was not an issue earlier also in the earlier round of litigation. They did not raise this one. Anyways, I'll take instruction to that extent, my lords.
No, when will you get instructions? Next week?
Day after tomorrow only I'll take an instruction,
Day
my
after.
lords.
Learn counsel for the respondent number 2 seeks time to secure instructions whether the lien of the petitioners could be transferred to Mandya University and also whether the respondent number 2 is liable to pay the salary from September 2023 till date. Yes, list.
My lords,
Yes,
on 13th, my lords,
13th.
Yes.
13th is a holiday,
14th, my lords.
14th.
Obliged.
Good. Learn counsel for the connected matter. Learn counsel for the response 1 and 2 as placed on record. The synopsis, Synopsis, the same. Rajendra Kumar Sunge. Please hand over a copy. The same is taken on
In
record.
fact, my lord, our services were transferred to Mandya University
Nadit,
as
no,
per
no.
Annexure C.
14th, no.
Yes.
Yes. Badri Vishal.
The petitioner is called in question, transfer of, my lords.
Who is this respondent before?
If your lordship sees page 15, that is the impugned order.
Yes.
Serial number 1, 5 and 7 are purported to be transferred to the petitioner institution through this order. Now at serial number 1 is respondent number 4. Lords, maybe the service is not complete because he's retired already. So I can file a memo to that effect, my lords, that against him.
What is challenged?
The challenge is this, where they have transferred these 3 my lords into the petitioner institution. Now, insofar as these posts are concerned, my lords, the management in 2017 itself has already filled. Now, the matter is also covered, my lords, by, may I just pass on the judgment by the Dharwad bench, my lords? That any such transfers should be in consultation, my lords, with the management is what it says. At page 18 of the order, my lords, paragraph 12. May I read, my lords?
Yes.
In the case at hand, it is not that the petitioner has violated any policy of the state qua reservation or admission to students. Therefore, it is plain and simple. The state cannot press clause 9A, either subclause 1 or 2 to achieve what they are wanting to achieve now. Conditions of grant in terms of the code mandates and the recruitment rules of 2001, which are quoted supra, indicate that the transfer of employees can be only after both the management of the institution have been consulted. In the subject case, the government order does not leave any discretion to the petitioner, but orders transfer of employees as aforesaid observed.
Yes.
The power to issue directions cannot mean that the power could be used to issue directions to the institution to take the teachers who are now rendered excess into the institution without its consent, as it undoubtedly generates depletion of morale of other teachers of the institution and give rise to hopes of seniority of the persons who are coming in, notwithstanding that they would be at the bottom of the list. Therefore, the matters of transfer should be only by consultation and not forcing upon any institution, much less engineering colleges or medical colleges, as the case could be. Though there is no bar to depute, it is a consultative process to be followed by the state, as the rules 2001 say so. Now, keeping that, my lords, at para 16, in light of the preceding analysis, the petition deserves to succeed, albeit in part, with the direction that the transfer of employees can only happen as a consultation process and can never be a decision unipartite.
Yes. again.
They are the
transferees,
my lords, into the institution. They can.
What about R6 NR Patil?
R6 also has been served.
Is he represented by counsel?
Please.
Raghavendra Gayatri.
Please.
The respondent number 4, Learned Counsel for the petitioner submits. The respondent number 4 has now retired, and therefore the respondent number 4 be deleted from the array of parties. So in view of the aforesaid submission, comma, the respondent number 4 is ordered to be deleted from the array of parties. Counsel for the petitioner is directed to make appropriate entries in the cost title, indicating that the respondent number 4 is deleted. Yes. List on ಯಾವ
Any day, subject to.
ನಿಮ್ಗೆ ಹೇಳಿ ಎನಿ ಡೇಟ್ ಅಂದ್ರೆ ನಾಳೆಗ ನಾಳೆ ಅದಕ್ಕೆ ನೀವು ಡೇಟ್ ಕೇಳಿದ್ರೆ ಎನಿ ಡೇಟ್ ಅನ್ಬಿಡಿ, ನೀವ್ ಹೇಳಿ ಯಾವ ಡೇಟ್ ಬೇಕು ಅಂತ. ಟೇಕ್ ವಿಚ್ ಎವರ್ ಕ್ಯಾಲೆಂಡರ್ ಇಸ್ ದೇರ್. 18th.
Great.
Serial number 14, okay, Sridhar. Serial number 14.
Yes, Sridhar. ಏನು?
Petitioner minute.
ಹಾ
With regard to payment of balance 2 lakh
ಹಾ
uh,
yes, what happened?
cost is concerned. The cost 2 lakh is paid, my lord. I have sent a receipt.
So that
Within a week, I will file that memo receipt, my lord. 2 lakh has been paid.
orphanage has got 5 lakhs.
5 lakh ಆಯ್ತು, ಮೊದಲು 3 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದು, ಈಗ 2 ಲಕ್ಷ ಸರಿ ಹೋಯ್ತು.
Yes.
ಈ ಮೆಮೊ ಇದನ್ನ ನಾನು ಒಂದು ವಾರದಲ್ಲಿ ಹಾಕ್ತೇನೆ.
This is some orphanage ಅಲ್ಲ?
ಹಾ ಕೊಟ್ಟಾಯ್ತು. ಅಲ್ಲಿ
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲಿ ಇಲ್ಲಿದೆ, ರಸೀದಿ ನನ್ನ ಕೈಯಲ್ಲಿದೆ. ಇದನ್ನ ನಾನು ಕೋರ್ಟಿಗೆ ಕೊಡ್ಬೇಕಷ್ಟೇ.
The Learned Counsel for the petitioner submits that the balance of cost of rupees 2 lakhs is already paid. What about elections?
ಅಲ್ಲ, ಎಲೆಕ್ಷನ್ ಅವರ ಎಲೆಕ್ಟ್ ಆದ್ರು, ರಿಸಲ್ಟ್ ಆಯ್ತು, ಅದು
ಆಯ್ತಾ?
ಮುಗ್ದೋಯ್ತು. ಹಾ
ಹಾ ಆಯ್ತು ಬಿಡಿ.
ಅಲ್ಲ, ಅದನ್ನ ಮೇಲಾಡ್ ಐ ಆಮ್ ಮೇಕಿಂಗ್ ದಟ್ ಸಬ್ಮಿಷನ್ ಮೇಲಾಡ್ ದಟ್ ಇಶ್ಯೂ ಆಲ್ ಇಶ್ಯೂಸ್ ಮೇ ಬಿ ಡಿಸೈಡೆಡ್ ಇನ್ ದಿ ಸೂಟ್ ಅಂತ ತಾವು ಹೇಳಿದ್ರೆ ಸಾಕು. ಬಿಕಾಸ್ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್
Learned Counsel for the petitioner submits that the balance cost of rupees 2 lakhs is already paid and undertakes to place the receipt on record.
ಒಂದು
It
ವಾರದಲ್ಲಿ
also contains that the elections, ಎಂತದಕ್ಕೆ elections to the post of
ಡೈರೆಕ್ಟರ್ ಫಾರ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಸೋಸಿಯೇಷನ್ ಆಫ್
director
ದಿ
of
ಎಂಪ್ಲಾಯೀಸ್.
elections to the post of the director of the district association was conducted as per the order passed by this court, and that the petitioners were selected.
ಅಲ್ಲ ಪಿಟಿಷನರ್ ಅಲ್ಲ,
Respondents, respondent number,
ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 4 and 5 ಅಂತ ಹೇಳಿ.
respondents slash
Defendant number-
defendants 4 and 5 in the suit have been elected.
ಅಂಡ್ ಆಲ್ ಅದರ್ ಇಶ್ಯೂಸ್ ವಿಲ್ ಬಿ.
Stop. If the
21 ಕೇಸ್.
full stop. In view of the above, comma, there no further orders need be passed. However, the Learned Counsel for the petitioner is directed to place on record the receipt for having deposited the cost of rupees 2 lakhs. Full stop. It is open for the defendants 4 and 5 to take appropriate measures in the suit if they are not satisfied by the results of the election.
ಮೈ ಲಾರ್ಡ್, ಆಲ್ ಅದರ್ ಇಶ್ಯೂಸ್ ಮೇ ಬಿ, ನಂದು
And all other issues
ಇಶ್ಯೂಸ್ ನಂದು ಕ್ಲೈಮ್ ಇದೆ.
are kept open to be urged in the suit. Yes.
ಆಮೇಲೆ ಬೇಲಬಲ್ ಇದಕ್ಕೆ ಅದನ್ನ ಚೂರು ರಿಕಾಲ್ ಆಗ್ಬೇಕು.
Available warrant ಏನಕ್ಕೆ ಬಂತು?
ಅಲ್ಲ, ಅದು ಇಶ್ಯೂ ತಾವು ಮಾಡಿದ್ರಿ
ಆಗೋಯ್ತಲ್ಲ, ಡೇಟ್ ಮುಗಿದೋಯ್ತಲ್ಲ.
ಆಗಿದೆ, ಅದು ರಿಪೋರ್ಟ್ ಇಲ್ಲಿ ಕಾರ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಬರ್ತಾ ಇದೆ, ಅದಕ್ಕೆ ತಾವು ರಿಕಾರ್ಡ್ ಅಂದ್ರೆ ಆಗೋಗುತ್ತೆ. ಪ್ಯಾರಾ 15 ನಲ್ಲಿ ನಾನು ಏನಲ್ಲಿ ಹೇಳಿದೆ.
Since the order dated so-and-so is complete, comma, the warrant issued, bailable warrant issued to the petitioner is recalled. Yes.
ಮಚ್ ಅಬ್ಲೈಸ್.
Serial number 15, Vijay Kumar.
List after service of notice to respondent number 4. Yaar idhar R4,
This matter does not survive for further consideration.
Learned Counsel for the, only, why don't you hand over a memo?
Please, my lord.
The Learned Counsel for the petitioner has filed a memo stating that the writ petition does not survive for consideration. In view of the memo, the
The
petition is
impugned order
dismissed.
which was passed transferring third respondent is, my lord, has been withdrawn.
Please.
Is dismissed, yes.
Obliged.
He is dismissed as having become infructuous. Yes, Shilpa Rani.
I'm appearing for the
16.
petitioners, my lord. Petitioner working as a guest lecturer is more than 10 years, my lord.
Hmm.
Then the similar placed guest lecturers have approached this honorable court, my lord.
Hmm.
The stay has been granted by this honorable court.
Umnabad.
The similar placed teachers has been approached, my lord, and the similar case has been filed before this honorable court only, my lord. It may be connected along with the,
So what is this maintainability of writ petition before principal bench?
that is the be there, my lord. Petitioners are working before the respondent number 5 is before be there, my lord.
Hmm. So why did you file the writ petition here?
My lord, similarly placed, like guest
Correct,
lecturer.
ma, ಅಲ್ಲೇ ಹಾಕೋಬೇಕಿತ್ತಲ್ವಾ?
1 to 3 before Bangalore only, my lord.
Madam, we have created a bench there only for people like the petitioners.
My lord, here, my respondent 1 to 3 is here only, my lord.
But the petitioners are all teachers employed on contract basis, huh?
Contract basis, my lord. More than
Contract
10
basis
years
at
they are
government
working, my lord.
first grade college, Humnabad. Full stop. They have
Continue of their service, my lord.
sought for quashing the notification dated 2/1/2025, inviting applications from eligible candidates for the post of teachers. They
Guest
also
lecturer.
sought for a mandamus, written the nature of mandamus. To declare the action response 1 to 5 as contrary to the law declared in Manish Gupta and another versus President Jan Bhagidari Samiti. They also sought for a direction not to discontinue the services of the petitioners as guest lecturers. Full stop. Next paragraph. The office has raised an objection regarding maintainability of this petition before the principal bench of this court. As the petitioners are all lecturers at Humnabad, government first grade college. And that the petitioners were bound to file the petition before the bench at Kalburgi. The learned counsel for the petitioner submits that the respondents are all situated at Bangalore and therefore the writ petition is maintainable at Bangalore. Next para.
And similar cases also pending before this bench only.
Stop. She also contends that similar questions are considering in various writ petitions which are pending consideration before the principal bench. Next para. The
WP number 1396 of 2025, my lord. It may be connected along with that, my lord.
that
And
is okay,
similar are
madam,
may
but
be
you have to go
transferred.
before, we'll transfer it to Kalburgi, Barpur. The benches at Kalburgi and Dharwad are created for the purposes of division of work. Full stop. Therefore, comma, the petitioners ought to have approached the bench at Kalburgi. Full stop. No doubt there is no embargo against this principal bench to entertain the writ petition, but yet in order to maintain regularity, comma, this petition deserves to be transferred to the bench at Kalburgi. So consequently, office is directed to transfer this petition to the bench at Kalburgi. For statistical purposes, this petition is treated as closed in the principal bench.
Number 70, Tilak Raj, SB.
Non-complaints of office objections. Yes. What are the office objections?
The office objection is relation to dispensation of the original or
To be
certified
filed.
copy of the impugned order, my lord.
Uh,
My lord, I am for the petitioner, my lord.
Let him
The-
submit, madam. I'm not going to run away from the court. I am here up to 1:30. So wait for your time, turn.
like dispensation of the certified copy of the impugned annexure, my lord.
You have filed an IA.
Well, the IA is not filed and that's the objection raised.
Hmm.
I'm told, my lords, that a note is written saying that the impugned order is a gestate
The
copy.
counsel for the
Therefore,
petitioner undertakes to comply the office objection. What are the on facts, you know?
my lords, facts, my lords, the notification was published, my lords, calling for application for the post of chairman of pollution control board. Now, my lords, the person who is appointed under the impugned annexure, my lords, is a person who is the present member of the legislative assembly. My lords, one, does not possess the qualifications. Two, he is debarred from holding the post of MLA as well as the chairman of the pollution control board.
In
Now, my
office
lords,
of profit.
yes.
Hmm.
My lords, just page 43. But similar petition, my lords, are pending as a public interest litigation before the roster bench. But this, my lords, if your lordships were to look at the prayer, my lords, I have sought not only for quashing off the appointment of the present incumbent, but also for a direction, my lords, to redo the selection process. Therefore,
Who are you?
my lords, I was one of the aspirants. Annexure B is my application, my lords.
Annexure? B,
B, page number 26. Pursuant to the notification, I have made an application. If I was a stranger to the selection process, it would simply be a writ of quo warranto, which in my respectful submission, would border PIL. But today, my prayer before your lordships is to redo the selection process and also to consider me. And therefore, it's classified as a service residuary matter. In a public interest litigation, which is pending before the roster bench, there he is a complete stranger and he has filed it as against all the members of the legislative assembly.
Same petitioner has filed a PIL also.
Not this petitioner, some other person, and that is pending as a PIL. Now, insofar as I am concerned, I am an aspirant to the post, and I have challenged only insofar as this is concerned. My only submission to your lordships is formally notice may be issued to the government and the pollution control board. Thereafter, your lordships may decide, whether this has to be heard along with the roster bench.
So this is a service matter.
Purely service.
It may relate to pollution control board.
I think there's a small distinction there.
Letter.
Very well.
The letter complete.
Decision bench of the Honorable Chief Justice especially constituted to take up the matters arising under Pollution Control and Environmental Protection Act and rules pending and fresh in PIL, with appeals and bill petitions for preliminary hearing orders and hearing, whole single bench and division bench matters on priority basis.
Can you just pass the notification?
No, but what is the issue pending before the division bench? Say, could be the same notification, but what is the larger issue which involves the public, general public? The letter complete.
Before the Chief Justice, my lords, I appear for the Pollution Control Board. So, Adhari, there are two writ petitions.
Who does she represent?
That's state government.
State government.
Please.
Yes. Yes, anything else, madam?
AG is
Is that all?
Please, my lord, preliminary objections to the maintainability.
Anything else?
That's all.
Yes.
I'm just clarifying the position, my lords, insofar as what has been contested there is a challenge to the notification, my lords, dated 5/2/2025, my lords, which is also the subject matter before my lords. My lords, in addition to it, my lords, the writ of quo warranto is also sought there in that writ petition. Sorry. My lords, it's the same grounds. So, my lords, we're just bringing it to my lords' notice We have no other objection to any other thing, but we are just bringing to my
No, the
lord's
best
notice.
thing is you file an application before the division bench
We do that, my lords.
for withdrawing this writ petition.
ಅದು ಅವ್ರು ಹಾಕಿದ್ದು.
Yaru.
We are the contesting parties there.
Fair enough. You can file an application before the division bench to withdraw this file from this court.
Yes, yes.
Instead of coming before this court and saying that
That
the
is-
matter is pending before the division bench.
We are just bringing to my
File an
lords.
application before the
We'll,
division bench.
we'll do the needful.
Al Madi.
Shmada.
Because this relates to a recruitment, so therefore this court is seized of the matter. This relates to recruitment, and the petitioner is also claims to be an applicant to the post. So therefore, it is essentially a service dispute between the petitioner and the respondent. AG has directed to accept notice for response 1 and 2. Mr.
Mahesh Chaudhary.
Enta Maheshu?
A. Mahesh Chaudhary.
A Mahesh Chaudhary for R3.
Chaudhary, I remember him as Chaudhary.
A Mahesh.
Mr. Mahesh Chaudhary is directed to accept notice to respondent number 3. R4 here,
Yeah, nobody is represented.
issue emergent notice to R4.
Great.
Yavat bek. You please move a memo before the division bench.
We'll do that, my lords.
Great.
Hearing on serial number 18.
For the petitioner.
Yes, please.
That's a case where implication notice has been served. IA has to be formally allowed. The college, the petitioner, college not has.
They are impleading.
The other college has been made.
No, who? What is this application? for?
Petitioner, one more college.
Notice ಹೋಗಿದ್ಯಾ?
Notice ಹೋಗಿ serve ಆಗಿದೆ.
Service ಆಗಿದೆ, service ಆಗಿದೆ. Formal ಆಗಿ IA has.
IA 1 of 23 is filed by the petitioner to implead an additional respondent in the writ petition. Full stop. The petitioner contends that during the pendency of this petition, he was transferred from KLS Gogte, College of Commerce, Belgavi to Srimati K.S. Jagalur Arts and Dr. S.M. Sheshagiri, Commerce Women's College, Dharwad. Full stop. He therefore has filed this application to implead the principal of Srimati K.S. Jagalur Arts and Dr. S.M. Sheshagiri, Commerce Women's College. Full stop. In view of the aforesaid, the respondent, the proposed respondent is a necessary party in this writ petition. Hence, IA 1 of 23 is allowed. The learned counsel for the petitioner is directed to amend the cost title. Learned AG is directed to accept notice for.
ಆಗಿದೆ ಸ್ವಾಮಿ, ಗವರ್ಮೆಂಟ್ ರಿಪ್ಲೈ ಎಲ್ಲ ಆಗಿದೆ. ಮ್ಯಾಟರ್ ಎಂಬಿ ಲಿಸ್ಟೆಡ್ ಫಾರ್ ಬಿ ಗ್ರೂಪ್ ಆರ್ ಹಿಯರಿಂಗ್.
ಆಯ್ತ್ರಿ, ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಲ್ರಿ?
ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ, ಇವತ್ತೊಳಗೆ ಕಳಿಸ್ತೀನಿ ನಮ್ಮ ಜೂನಿಯರ್.
Learned AG is directed to accept notice for.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಹಾಕಿದ್ರೆ ಇವತ್ತು ಮಾಡಿ.
Respond before. Yes, list on, when do you want it? Take whatever, yav 2022 matter. List for preliminary hearing in B group on
Next Monday.
next Monday.
March. Serial number 19.
19.
19 may not. I have out of the two petitioner, one wants to withdraw the petition because he has been promoted, my lord.
Workol yaru memo file madi.
Another petitioner and
File a memo.
Memo is already filed in this matter.
But a memo is filed by the petitioner number 1 to withdraw the writ petition. In view of the above, the petition, insofar as petition number 1 is dismissed as withdrawn. Counsel for the petitioner is directed to make appropriate entries in the cost title indicating the withdrawal of the writ petition insofar as petition number 1 is concerned. What about other applications? Impleading error?
that remain. IS may be now those who IS were filed at the time of interim order. Now matter has to be heard, my lord. There is no need.
You have filed some application.
IS.
You have filed some application for impleading some person. Who is that? Huh? Yes, Rangana Joyce, ನೀವು list ನೋಡಲ್ಲ
My lord.
You don't see the list.
IA for impleading of persons who were subsequently promoted during the pendency of the petition. Because I had.
ಬೇಕಾ?
ಬೇಕು.
ಯಾರು?
Lord P. Manjunath.
ಮಂಜುನಾಥ್ ಅಂತ.
P. Manjunath, assistant accountant.
IA 2 of 21 is filed by the petitioner to implead the proposed respondent number 7, who purportedly was promoted after the petition was filed. Stop. The petitioner contends that the proposed respondent number 7 has to be heard and therefore is a necessary party. Full stop. Notice of this application is served on the proposed respondent number 7. Hence, IA proposed respondent number 7, who has not appeared and has not filed any objections against his impleadment. Hence, IA 2 of 21 is allowed, and the proposed respondent number 7 is ordered to be impleaded as respondent number 7. Counsel for the petitioner is directed to make appropriate amendments in the cost title of the writ petition. Stop. List on date put. What about IA 3 of 21? 14th March.
It may be heard at the time of hearing.
IA 3 of 21 and 1 of 21 shall be heard at the, along with the writ petition.
Serial number 20.
Shall be heard and disposed of along with the writ petition.
Serial number
Yes,
20.
Prashant.
Appearing for the petitioners, madam.
Last week it was there.
Dismiss for non-prosecution.
Matter ಜೊತೆ connect ಆಗಿ ಬಂತು. Earlier, my lord, same petitioner had filed a writ petition in the year 2012. That was dismissed, my lords, and which is available at annexure K, my lords.
The 14/11/2022, what happened on that day?
ಅಲ್ಲ ಅವತ್ತಿಂದ ಅಡ್ಜರ್ನ್ ಆಯ್ತು, ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆ ಅಂತ ಹೇಳಿ. ಅಲ್ಲ ಅದು ಆಫೀಸ್ ಒಬ್ಜೆಕ್ಷನ್ ಇತ್ತು, ಕಂಪ್ಲೈ ಆಗಿಲ್ಲ ಅದು.
But let me recall this order. IA 1 of 24.
ಅಲ್ಲ recall the last. Same relief, what is sought in the present petition was also sought in the year 2012, my lords, by a writ petition. That has been dismissed, which is available at annexure K.
We will restore the writ petition, again dismiss it. We'll kill him twice. Yes, for good.
Regular counsel is held up in another.
IA 1 of 24 is filed. What is the application listed today?
He's held up in another court.
What is the application
For
listed?
for condemnation of delay. For condemnation of delay is what.
Condemnation. ಅದು ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು. ಡೋಂಟ್ ವೇಟ್ ಫಾರ್ ಎ ಸೀನಿಯರ್ ಟು ಕಮ್.
ಇಲ್ಲ ಮೇಡಮ್, ನಾನು ರೆಗ್ಯುಲರ್ ಕೌನ್ಸಿಲ್ ಅಲ್ಲ, ಅವ್ರ ರೆಗ್ಯುಲರ್ ಕೌನ್ಸಿಲ್. ಅದಕ್ಕೆ
IA 2 of 24 is filed for condemnation of delay in filing the application to recall the order dated 4/11/2022. Full stop. Next para. The registrar of this court, acting under Rule 17 of Chapter 12 of the Karnataka High Court rules, dismiss the writ petition for non-compliance of office objections. Full stop. The petitioner has filed an application to recall the said order. There is a delay in filing the said application. The cost shown for the delay is produced and the same is accepted. Hence, IA 2 of 24 is wrote, and the delay in filing the application to recall the order dated 4/11/22 is condoned. In view of the order passed on IA 2 of 24, IA 1 of 24 is also allowed, and the order dated 4/11/22 is recalled. The writ petition is restored to file. Same ಇದು order 20.1 ಅಲ್ಲೂ ಮಾಡಿ. List for preliminary hearing on, when do you want it?
Anytime next week.
22 matter ಕೊಟ್ರೆ ಯಾವತ್ತೋ ಒಂದಿನ.
12th March. 21.
Lord, I appear for the petitioner, my lord. Lord, I have filed for IA for early hearing. The reason is, my lord, junior has been promoted contrary to the C&R rules. Would your lordship fix a date for final hearing, my lord?
IA 2 of 23 is filed for early hearing since the petition is not admitted. IA 2 of 23 is not maintainable and the same is rejected. However, list the petition for preliminary hearing in B group on
Monday, my lord.
Next Thursday.
Thursday.
28th March.
Obviously.
Serial number 22. It's LR applications.
Madam, idella applications allowed. Counsel for the petitioners directed to amend the cost title. Please. Yes.
Serial number 23, Ravi Shankar K.
IA 1 of 24 is filed for early hearing since the petition is not admitted. IA 1 of 24 is dismissed. List the petition for preliminary hearing and B group on
First
From mandamus.
Thursday.
20th March.
Much.
Serial number 24, Muralidhar
Yes,
KB.
Rakshita, can this be disposed of? What is the mandamus sought for?
What is that? They
What
want
are they
to
on?
be employed to the post of temporary gangman. Discontinued in the year 99 itself, my lord.
Discontinued.
99 itself is discontinued.
Ah.
Subsequently, PPTCL came up with a scheme in 2005-6, wherein the temporary gangmen who had completed 6 years of continuous service, my lord, benefit was given and they were converted as probationary mazdoors. In terms of that scheme, my lord, he preferred a application representation. But that benefit can't be given to the present petitioner because 99 itself, his services were discontinued, my lord.
Lord, sir, I was selected as on temporary basis in the year 1999. Thereafter, for a period of 1 year, I have excited. Because of the ill health in the family, I have discontinued. Thereafter, I have continued my services till 2005. I have made an application vide annexure C, my lords.
2005, 2022 representation.
Alala, I have been continuously following up with the department, my lords. There is no lapse on my part, my lords. The only thing is, nowhere has the respondent cited why I have been rejected. They have just been pushing it to pillar and post citing, take a call, take a call. Nobody has taken a specific call why I have been rejected.
Correct, mister. If your services are discontinued from the year 1990.
My application is there, my lords.
His application 99 on 31/3/1999, my lord.
He was discontinued from
Discontinued.
service.
No order is forthcoming. No, it's not like that, madam.
Question, no.
My lords, my representation says I have filed an application as of 7/4/1999 in pursuance of official memorandum. In the first place, I was selected. Second place, there was an reissuance of another temporary. Even there, I have selected. My lords, no order is forthcoming from the respondent side, my lords.
So whatever considered.
They can just consider my application whether I've been selected or not. They have not rejected my application.
For written the nature of mandamus directing the respondents, which respondent?
It's the respondent number 2 and 3, my lord.
Respondents 2 and 3 to consider his representation dated 10/9/2022 regarding regularization of his service.
Not regularization, my lord. He states that re-employment, annexure F, page 32, my lord. Last 3 lines. ತಮ್ಮ ನಿಗಮದಲ್ಲಿ ತಾತ್ಕಾಲಿಕ ಗುತ್ತಿಗೆ ಆಧಾರದಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸಲು ಕೆಲವು ಖಾಲಿ ಇದ್ದು ತಾವುಗಳು ದಯಮಾಡಿ ನನಗೆ ತಾತ್ಕಾಲಿಕ ಮಾಪಕ ಓದುಗ ಅಥವಾ ಗ್ಯಾಂಗ್ಮೆನ್ ಹುದ್ದೆಗಳಿಗೆ ಕೆಲಸ ನಿರ್ವಹಿಸಲು ತಾವು ಅನುಮತಿ ಕೊಡಬೇಕು ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ಳುತ್ತೇನೆ. Page 32.
This was the scheme which I have.
Next.
F, my lord, page 32.
10/9/22 by which he is sought for appointment on temporary basis to the post of meter reader or gangman.
Gang.
Full stop. Next para. The petitioner contends that he joined the services of the respondent in the year 1998-99 as a temporary meter reader / gangman on contract basis. Full stop. He claimed that the respondent issued an official memorandum dated 13/7/1999 and extended the service of the petitioner. He claimed that he worked as a gangman until 2001, but due to an emergency in the family, he could not continue in the job for a period of 2 years. He thereafter approached the respondent in the year 2003 and requested permission to rejoin Full stop. The petitioner contends that the respondents was pleased to recommend through inter-office communications However, recommend the case of the petitioner through inter-office communications. However, the respondents did not take any steps for appointment on contract basis. The petitioner's application, petitioner's representations were kept pending. Full stop. He contends that the respondent has been appointing employees on ad hoc/temporary basis. And though there was a recommendation of the respondent authorities to consider the case of the petitioner, the same is not done. Petitioner therefore submitted a representation dated 10/9/2022 requesting the respondents to appoint him to the post of meter reader or gangman on temporary basis, and that the same is not considered till date. Learned counsel for the petitioner submits that the petitioner was employed on contract basis from the year 1998-99, and that he continued from then on till the year 2001. He contends that several other persons similarly placed were regularized, and therefore the petitioner is also entitled to be treated alike. He submits that there are several posts which are vacant, several posts of meter readers and gangmen which are vacant, and that the petitioner may be considered for appointment on temporary basis, appointment to the said posts on temporary basis. The learned counsel for the respondents, however, contended that the petitioner's services were petitioner discontinued.
On 31/3/1999.
The petitioner stopped reporting to work from the year 1999.
1999.
Therefore, he is not entitled to any indulgence. He also contends that the respondents are not taking any persons on temporary basis, and therefore no direction can be issued to the respondents to consider the representation of the petitioner. Next paragraph. If the petitioner has submitted a representation to the respondents, they owe a duty to the petitioner to respond. Full stop. The representation of the petitioner was filed on 10/9/2022.
That's prior
And
to that.
therefore, the petitioner was bound to.
Annexure C is of the year 2006.
Full stop. The respondents were therefore bound to consider the representation. Since the same is not considered for more than 2 years, it is appropriate to direct the respondent number 2 and 3 to consider the representation of the petitioner and pass appropriate orders. Consequently, this writ petition is allowed. The respondents 2 and 3 are directed to consider the representation of the petitioner dated 10/9/2022 and pass appropriate orders within a period of 3 months from the date of receipt of a copy of this order.
Not one observation in accordance with law, otherwise.
In accordance with law. Yes, in accordance with.
Grateful.
Muralidhar KB.
KB Muralidhar.
Appearing for
Petitioner is working as physical education director, my lord.
Hmm.
Though, my lord, here,
Yes.
physical education,
Today's time. is
salary has
file
not
my
been paid from
Why
past
are you
years.
silencing her, mister?
Please.
She is saying something. Wait for her. Muralidhar, idella you people should not develop this habit.
Please.
You should lead by example. She is saying something, you jor ni voice raise do you think I'll not hear her?
Today's time may be kindly be granted to file my statement of
Learned
objections.
counsel for the respondent number 2 and 3 seeks time to file statement of objections. List on date.
19th March.
August.
Much obliged.
25, Lokesh B.
As a contract employee, termination of contract employment is a stigmatic in nature. During the pendency of this petition is
he was removed.
he was removed.
On
The
what
order of
ground?
termination is stigmatic. without conducting any inquiry, he has been terminated.
What is the stigma, mister?
I take in suspect,
What is
without
the
conducting any
stigma?
inquiry.
What is the stigma attached?
It's misappropriation of funds.
ಹಾ, ಎಲ್ಲಿ ಹೇಳಿದಾರಂತ?
It is at annex A, my lord.
ಎಲ್ಲಿ
Because inquiry was conducted against only a accountant, not against him. By considering her statement, he has been terminated.
Lokesh, you know your file. I do not know your file.
Please, my lord.
So give the facts properly.
He was working as a TPM, Taluk program manager. There was an inquiry was initiated against the MBK, the main bookkeeper, one Pankaja, my lord. Not against him. Inquiry committee was appointed. They have conducted an inquiry, and inquiry report was submitted. Inner statement, while giving statement before the inquiry committee, he has stated that it is at page number 26, my lord. The inquiry. During the inquiry, he disclosed that on his instructions only, I have dispersed the amount in favor of so and so persons. It is at page number 27.
Amendment, carry out the amendment.
Please, my lord, please.
IA 125 is filed by the petitioner to amend the writ petition to seek for an alternate relief.
And also respondent number 4 has to be amended, my lords. There is no chief executive officer for Taluk.
Please.
Executive officer.
Perusal of the relief sought for in the application for amendment shows that the same is very innocuous and does not change the nature of the writ petition or the relief sought for. In that view of the matter, IA 125 is allowed and the petitioner is permitted to amend the writ petition. What about R4?
R4, chief executive officer for Taluk Panchayat. Adu EO anta hakbeku.
EO anta ma.
Learned counsel for the petitioner is also directed to amend and correct the designation of the respondent number 4 as
EO
executive officer instead of chief executive officer.
Notice to sir.
We have it on next Monday, my lord. It's a matter of
Based on ಯಾವತ್ತು ಬೇಕು?
Any day, my lords. Respondent number 4 is the contesting respondent.
B group ಕೊಡಿ ಯಾವತ್ತು?
Obliged.
17th. Sunil Kumar H.
26. Sunil Kumar petition.
Yes.
Please. Lord, this petition, my lord, the petitioner had challenged the dismissal order, which is conducted, which is passed without even conducting inquiry as mandated under the BESCOM regulations, my lord. The coordinated bench of this honorable court, my lord, in a similar matter with regard to some of the employees also, has passed an order stating that the dismissal order is set aside and liberty is given to them to initiate an inquiry, and they then take an action in accordance with.
Matter is covered against me.
Barcode. The petitioner is challenged an order of an order bearing number so and so, dated so and so, passed by the respondent number 2, by which the services of the petitioner, by which the petition was dismissed from service. Petitioners were dismissed from service. The petitioners also sought for an order to reinstate their service, reinstate them into service along with all consequential benefits. The petitioners were appointed as junior linemen. Full stop. A junior lineman under the disability category. Full stop. The respondents, doubting the certificates issued to establish the disability suffered by the petitioners, passed an order dismissing the petitioners from service. The same is challenged before this court in this writ petition. The learned counsel for the petitioner submits that the petitioners were appointed through the due process of law, and therefore the respondents were bound to conduct proceedings as stipulated under the CCA rules,
BESCOM regulations,
under the BESCOM regulations. And since the same is not done, the impugned orders dismissing
CCA,
this.
it's KEB Employees CCA Rules 1987.
KEB Employees CCA Rules 1987.
87.
and therefore the impugned orders are liable to be set aside. He also contends that in similar circumstances, a coordinate bench of this court in WP number 28108 of 2024 had set aside a similar order of dismissal. Stop. He therefore contends that this writ petition may also be disposed on same terms. Next, by learned counsel for the respondents do not dispute the fact that the contentions urged in this writ petition are squarely covered by a judgment of a coordinate bench of this court in WP number 28108 of 2024. Consequently, this writ petition is disposed of, is allowed, and the impugned orders dismissing the services of the petitioner is set aside, is quashed and is quashed. The respondents are directed to reinstate the petitioners into service. However, the consequential benefit will depend upon the outcome of the inquiry that may be conducted by the respondents. The respondents are at liberty to proceed in accordance with law.
Your Lordships, there are charge memos. There are 6 separate charge memos in relation to each petitioner. Those are at Annexure B13, C11, D11, E12.
The respondents are at liberty to proceed further in terms of the charge memo issued to each of the petitioners.
Please.
The inquiry shall be concluded within a period of 6 months from the date of receipt of a copy of this order. Reinstatement is there
4 weeks.
Reinstatement is granted.
Within 4 weeks.
4 weeks is granted.
4 weeks is granted.
The reinstatement of the petition shall be given effective within 4 weeks from the date of receipt of a copy of this order.
Please, Murad. Grateful.
Grateful.
Number 27, Manmohan PN.
Ian Manmohan.
May I seek for a passover?
I'll have to file my objections if your Lordships may not have it next week.
Learned counsel for the respondent, learned senior counsel representing the respondent number 7 seeks time to file statement of objections. Hence list on yavat veki.
May I seek for Friday, my lords, this Friday itself, 14, because there is a promotion.
Objections have to be filed by this
please.
respondent.
In fact, your Lordships have already said, my lord, it's all
25th.
subject to the result of the main writ petition.
I have in fact,
Some order ಇದೆ ನೋಡಿ ತಾವು 10-9 ಅಲ್ಲಿ
however, my lords,
10-9, please come to my lord, para number 11.
This is that, okay.
Yes, my lord, para 11 ಅಲ್ಲಿ.
Yes, list on yavat veki.
20.
1 week, 2 weeks, how much?
2 weeks.
2 weeks time is a list on, after 2 weeks, put it on date.
Great.
my lords, may I seek, my lords, on 21st, my lords.
21st.
Yes,
Please. Number 28, Chimparani.
yes. Nagesh Mukke.
I am for the respondent number 3 in this case.
We
Cost
time, my
title
lord, I'll
not-
comply the office objection, amendment of cast title.
Ah,
I'll file my objection to IA for vacating stay, my lord.
yes, what is the stay sought? What was the stay granted?
Stay granted, my lord.
What was stayed, madam?
Continue, the petitioners are contract basis teachers, my lord. They are continuing their services, my lord, since from more than 10 years, my lord. Hence, my lord, I have obtained a stay, my lord, the direct, not to disturb the petitioners, my lord, until the regular appointment, my
Your
lord.
Honor, I am
After
the,
We'll consider the writ petition on merits.
yes,
My lord, respondent number 2 needs to file statement of objections, my lord.
Your Honor, I am the respondent number 3. Actually, I am the regular recruited candidate, Your Honor. As per their recruitment, I have appointed on 30/12/24.
My lord, respondent number.
Madam, let him complete. Wait for your turn.
Your Honor, they have filed a earlier petition, that is writ petition number 7304. That's annexure number 5, Your Honor. In that, the serial number 37, they have got order that till the regular recruitment, let the guest faculty continue the work.
Is this pursuant to the judgment rendered by Justice Sachin Magadum?
Please, my lord. My lord,
In this,
respondent.
No, the regular recruitment is already done.
Is 2017 recruitment, my lord. After that, my lord, there is a page number in my writ petition, my lord. page number 45, there is a 875 vacant post, my lord. The 2024.
That is okay. Where is the judgment in that writ petition?
He only
Your Honor,
placed.
it's Annexure 5, Your Honor.
Annexure R5, page number
Annexure?
20.
Annexure R5, Your Honor.
Page number
R-
60, my lord, impugned order, Mary.
In that serial number 37, Your Honor.
R5,
Yes, Your Honor.
The 60
Serial
is
number
RD.
37, page number 35.
Now let us see what was the order.
Yes, Your Honor.
What was the order?
Page number 60, my lord.
Ah,
May I read, my lord? Order. The writ petitions are allowed in part. The respondents are hereby directed to continue the services of the petitioner as the teachers, lecturers, till regular recruitment is conducted in accordance with law, Karnataka Residential Education Institution Society Regulation 2021. The pending of interest application will does
yes.
not survive. So, my lord, respondent number 3 appointed 23/6/2017 recruitment notification, my lord. After that, my lord, the respondent number 2 issued the notification, the annexure V, page number 45, my lord. There are 875 posts are vacant. For this, in this, my lord, some of the petitioners are working on contract basis. For this, after this verifying the post, total 875 posts, my lord. For this, still now they have not issued the notification for regular appointment.
That is not the issue. This court passed an order that until a regular recruitment is conducted, you shall be continued.
Conducted, my lord. After this order, they have not conducted regular.
Why did you make this person as a respondent number 27 in that petition?
There is no regular recruitment notification is not yet issued, my lord.
Now, were you a
After
party in
this-
this petition?
Please, my lord.
Illide.
I'm the party is serial number 37, my lord.
Number
37, my lord. Page number 35, my lord.
Hanumanta.
Please, my lord.
Page number 37.
Page number 35, serial number 37, Anumanta.
Hanumanta. Never.
M. Anumanta. He's
Hanumanta
also
is,
one of the petitioner in this case also, my lord.
where is he petitioner in this case?
Petition number 7, my lord.
Malagi Hanumanta.
Here M. Anumanta, here it is Malgi Anumanta. Since, my lord, after this
Correct.
order, my
Why
lord,
did you not bring it to the notice of this court in the earlier writ petition that he was recruited under the 2017 notification?
now he impleaded as a party, my lord, respondent number 3, and he says, my lord, 2017, his regular appointment has been issued and he appointed, my lord.
Yes.
Now he is disturbing my place. I am still continuing the service, my lord.
Madam, 2017 recruitment ಆಯ್ತೋ ಇಲ್ವೋ?
Hagide, my lord.
Did you challenge that recruitment in this writ petition?
That time, no one is disturbed me, my lord. Now, 2024, they have not issued
Madam,
any.
you were there in
recruitment
the
notification.
organization. You were there in the organization.
I am there, my lord. Till now, I am there, my lord.
In 2017, there was a recruitment notification.
Please, my lord.
You knew it.
I knew it, my
Why
lord.
did you not bring it to the notice of this court?
That time, there's no one is disturbed me, my lord. After
Madam,
that,
let
post,
nobody disturb you.
there are 3.
But there is a notification inviting applications for recruitment.
Please, my lord, that
To your post. To your post.
not my. post, my lord.
2017 ಯಾರ್ post ಬಂದಿತ್ತು?
There are 3,376 post has been called out, my lord.
Yes.
In that, my lord, leaving there is a writ petition pending before this honorable court in the separate writ petition, my lord. Hence, leaving that, the 3,376 post has been called up. That time, they have not disturbed me.
Now,
Later,
have you
2000
mentioned to the court in the earlier writ petition that there was a notification in the year 2017?
There is one writ petition pending, my lord, in their
ಈ
appointment
writ
order,
petition ನೀವು ಹೇಳಿದ್ದೀರಾ?
page number 22, my lord.
I hope you understand what I am
Yes,
trying
my
to
lord.
ask you. Did
For-
you mention in the earlier writ petition, which was disposed of on 21st of February 2024,
Please, my lord.
that there was an earlier notification, recruitment notification, based upon which certain candidates were selected?
In that writ petition, my lord, I have not filed that writ petition, my lord, this writ petition.
Madam,
This
Hanumanta had filed. Hanumanta.
Hanumanta is filed, my lord.
ನೀವು ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಆಗ್ಬೋದು, ಪಾರ್ಟಿ ಹೇಳಿ. Advocate could change. What about the party? Did the party bring to the notice of this court that there was an earlier recruitment notification?
Your Honor.
Please, my lord.
That is-
Order, my lord, page number 50.
Page number?
50.
Hmm.
May I read the prayer, my lord?
Yes.
issue a writ of nature of mandamus directing the respondent to continue the service of the petitioners as teachers, lecturers, as they are working as against the sanctioned vacant post in Karnataka Residential Education Society till regular recruitment is taken place in accordance with law. Accordance with the Karnataka Exchange 2000 under the facts and circumstances of the case. Issue writ of nature mandamus directing the respondent to pay the pay scale attached to the post teacher lecturers as specified in the regulation Karnataka Residential Education Society 2021, published while bearing 2021 16 to 2020 Annexure G on the principle of equal pay for equal work as held by the Honorable Supreme Court 2017 1 SEC 148, and consequently direct the respondents to pay the reference of arrears of salary to the petitioners from the date of appointment with all other consequential benefit under the facts and circumstances of the case. Issue writ of nature and mandamus directing the respondent to extend the benefit of service weightage to the petitioners while making regular recruitment to the post of teachers, lecturers on par of with teachers, lecturers, those who have already appointed with the benefit of the service weightage in terms of notification 2020 Bangalore dated 21/1/2011 to the writ of the writ petition under the facts and circumstances of the case. Issue any other appropriate order or direction honorable court deems fit grants consideration of the facts. This is the prayer made in the earlier writ petition, my lord.
Where have we said about
This
the
writ
2000?
petition is filed, my lord, 2022, my lord.
Correct. So what should happen to the 2017 notification?
2023, this writ petition has been filed, my lord. The 2017 recruitment process is completed and appointed. After that, the rest of the post is the
If
contact
this man
is.
is appointed in 2017 notification, should he not be given a posting?
Please, my lord, there are vacant posts, my lord. Kindly take my page number
Madam,
45, Annexure B, my lord.
So long as his appointment is not set aside, so long as his appointment is not set aside, he is entitled to be posted somewhere, at least to the post where he is appointed.
Knowingly, my respondent number 2, my lord, knowingly there is a one contact teacher is working and there is an order by this honorable coordinate bench has been already order passed. They placed him into my place, my lord.
Madam, you are not challenged his appointment, for God's sake, you are not challenged his appointment.
The recruitment process
Therefore,
is completed in the 2022 itself, my lord.
Yes.
Now there is a HORI Adesha has been
Yaವಾಗ
passed, my
argument
lord.
material?
Order ಈಗ 2024 ಅಲ್ಲಿ order
When
passed.
will you argue order ಅಲ್ಲ? When will you argue the matter?
Permit me
When
submission.
will you argue
I'll
the?
file my objections, my lord, for his vacating stay, my lord, with I'll take
Madam,
this.
no vacating stay. I'll take up the petition for final disposal.
I'll just come to
Hold.
know when he filed the application
We
only.
are
my
not
lord.
on that. 2017, if you are not challenged, if you have got an order by suppressing facts, if you got an order by suppressing fact, this court will undo all those orders. So far as you are concerned, Barcode. IA 2 of 25 is filed for vacating stay. Since any order on this application would render the writ petition infructuous, IA 2 of 25 would be considered along with the writ petition, would be considered along with the main writ petition. List on 2024 ನೋಡಿ ಯಾವ ಡೇಟ್ ಗುರುವಾರನಾ ಗುರುವಾರ ಕೊಡಿ
23.
23rd 20th March. Yes, serial number 29. Please wait. Sandeep Katti.
I appear for the petitioner, my lords. I am filing a memo seeking the withdrawal of the writ petition.
A memo is filed by the
With
learned
liberty
counsel.
to file fresh petition. my lords.
ಏನಕ್ಕೆ?
ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ನಾನು I have filed a writ petition seeking mandamus to consider my representation for payment of interest on arrears. After I filed this writ petition, they considered my representation, refused my request. So,
Challenge it.
to challenge
Barcode.
that,
A memo, file no liberty, mister. You sought for a mandamus to consider. They have considered, rejected. Why you want liberty?
now to
ಸುಮ್ನೆ ಏನ್ ಯೋಚನೆ ಮಾಡೋದೇ ಇಲ್ಲಪ್ಪ.
file fresh petition challenging that refusal.
Challenge it, mister. That's a new cause of action.
Yes.
Unnecessary ಯೋಚನೆ ಮಾಡೋದಿಲ್ವಾ? You don't apply your mind, is it? ಕೊಡಿ.
To writ petition.
File a proper memo, no liberty. The petitioner has sought for a writ in the nature of mandamus to consider his representations dated 1/1/2021 and 10/10/2024, demanding interest at the rate of 8% per annum on the belated pension,
Arrears of salary.
belated arrears of salary, on the belated payment of the arrears of salary. Full stop. The petitioner contends that the representations have now been considered and the same are rejected, and therefore this writ petition does not survive for consideration. He however prays that liberty be reserved to the petitioner to challenge the orders rejecting the representations. In view of the aforesaid and the memo filed, this writ petition is dismissed as it has become infructuous. It is however always open for the petitioner to challenge the endorsements issued by the respondents, rejecting the representations of the petitioner. Yes.
Serial number 30.
Same minutes.
Same order. Memo Kodi, where amount?
Serial number 31.
Shiva Reddy.
Shiva Reddy K.
Yes, my lord. The annexure S is representation given by the petitioner to the concerned respondents to consider the pension benefits to his father, my lord. My lordship, his grandfather, he was serving as a government school teacher. He was appointed in the, my lord.
Your father is alive.
She is recently no more, my lord. During his lifetime, he had given several representation to the department to consider the.
That should accept notice for respondents 1 to 4. Anirudh.
32. MP Anirudh.
Appear for the petitioner. The matter arises out of an order of the Assistant Registrar of Cooperative Societies who determined the age of the deceased employee. There were a series of litigations, the latest of which being before this honorable court, where by virtue of judgment dated 23rd April 24, this honorable court directed the Assistant Registrar of Cooperative Societies to determine the age of the deceased employee. Now, if my lords were to kindly take page number 63 of the writ petition.
Yes. So where is the order?
No, that's impugned order is at page 15.
Yes.
The reasoning is at page 18, my lords. Page 18, the paragraph number 7.
Where is the operative portion? Please read the operative.
Page 18, para 7.
Yes.
ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಜಿ ಜಗನ್ನಾಥಮ್ಮ ದೇವಿ ಇವರ ಹುಟ್ಟಿದ ದಿನಾಂಕ 8/9/1949 ಎಂದು ಸಂಗಟಾಗಿ ದೃಢೀಕರಿಸಿ ನೀಡಿರುವ ಸೇವಾ ಪುಸ್ತಕದಲ್ಲಿ ಇರುತ್ತದೆ. ಹಾಜರುಪಡಿಸಿರುವ ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ so and so dated 18/1/1973 KM ಪಾಂಡುರಂಗ ಇವರ ಪ್ರಕರಣದಲ್ಲಿ ತೀರ್ಪಿಸುವ ಸೇವಾ ಪುಸ್ತಕದ ದಾಖಲಾತಿ ಹುಟ್ಟಿದ ದಿನಾಂಕವನ್ನು ಬದಲಾವಣೆ ಮಾಡಲು ಅಧಿಕಾರ ಇರುವುದಿಲ್ಲ ಎಂದಿರುತ್ತದೆ. ಇವುಗಳನ್ನು ಗಣಿಗೆ ತೆಗೆದುಕೊಂಡು ಜಿ ಜಗನ್ನಾಥಮ್ಮ ದೇವಿರವರ ಹುಟ್ಟಿದಬ್ಬ ದಿನಾಂಕ 8/9/19
ಹುಟ್ಟಿದಬ್ಬ ಅಲ್ಲ, ಹುಟ್ಟಿದ ದಿನಾಂಕ. ಹುಟ್ಟಿದಬ್ಬ ನಿಮ್ಗೆ ಎಲ್ಲರಿಗೂ ಅಲ್ಲ.
ಹುಟ್ಟಿದ ದಿನಾಂಕ ಎಂದು ಪರಿಗಣಿಸಿದೆ. So he relies on a judgment of the year 1973, where a certain constable who at the time of entry had his date of birth adjudicated of SSLC marks card vis-a-vis the horoscope and got it.
No. Where is the order passed by the learned single judge of this court directing the?
That is at page 57, my lord.
Please read. Is there any direction to determine the age?
Yes, ma'am. Page 57, para 15.
Please read.
It is also relevant to note that during the course of hearing, a fresh contention is raised relating to the date of birth and retirement of late Jagannathama Devi. The petitioners claim that late so-and-so was Jagannatha Devi was born in 1949, whereas the respondent society, by producing a copy of extract of the school register issued by the government school, is contending that late Jagannatha Devi was born on 8/9/1941. Thus, the respondent society has taken the year of superannuation as 1999, whereas the petitioner claimed that late Jagannatha Devi would
have attained superannuation in 2008. This court is not going to decide this new controversy raised for the first time before this court. However, the age difference being substantial, this court directs the authority executing the award shall also adjudicate the controversy relating to the date of birth. Now, basis this, the impugned order has been passed. Now, if the school birth register is seen, my lords, that is that school register, annexure H, page 63, the bottom but fourth row. Ali 1949 anta ide.
AJ is directed to accept notice for respondent number 1.
Kindly for a moment. In
ಆಯ್ತು,
page 60.
ನಿಧಾನಕ್ಕೆ ಆರ್ಗ್ಯೂಮೆಂಟ್ ಮಾಡ್ರಿ.
Please.
What about these private respondents?
I will serve them, my lords.
Are they necessary?
They are necessary. They are the legal heirs.
Could issue emergent notice to respondents 2, 3, 2, 3, 4, 5. Yes.
Stay, my lords, they are seeking to
Say
execute.
what?
Stay of the proceedings in the execution case, because they are seeking to execute whatever is due according to me I have paid. They are seeking additional 7 lakh rupees because there's a 10-year difference. According to them, date of superannuation will become 2008.
We have to deposit some money.
50,000 rupees, my lords.
50%, 25%.
I would request 1 lakh rupees.
Impugned order is impugned. The impugned order is stayed subject to the petitioner depositing 25% of the amount claimed in EP number.
EP number. Two of 2000, 2001.
2 of 2000, 2 of 2020, 21.
2000, 2000, 2001.
2000, 2001, pending consideration before.
The respondent number 1.
Before the respondent number 1, the deposit shall be made before the.
Manoj?
Where will the deposit, where should the?
I'll deposit before this court.
No, before the respondent number 1 only. Deposit before the respondent number 1.
Great.
The amount deposited shall not be released until further orders from this court.
Please, Manoj, grateful.
Yes.
Number 33, Yashwant Netaji.
Netaji.
My Lord, I appear for the petitioner. Lord, this dispute is with respect to appointment of additional government pleaders in Chendraipatna Taluk. Lord, the present respondent number 5 was appointed as additional government pleader on 1/1/2024. Subsequently, my Lord, his appointment was set aside by the order of this honorable court on 1/2/2024. On the ground that section 26 subsection 2 of the Karnataka law officers rules has not been followed. My Lord, according to the said rule, my Lord, the applications for the post of government pleaders and additional government pleaders has to be invited by the deputy commissioner, and the said list has to be transferred to district judge, which has to be subsequently transferred to the government. After this, the appointment will be made, my Lord. Again, my Lord, the said rules has not been followed. By way of not following the said rules, my Lord, again the same respondent number 5, my Lord, whose appointment was set aside, has been again affirmed by annexure S, my Lord, on 20/2/2025, challenging that the present petition has been filed, my Lord. My Lord, the notification for inviting, my Lord, has to be invited by way of order of the deputy commissioner, that is the third respondent. Here, my Lord, presently the applications were invited by respondent number 4, that is backward classes commission district officer, who is nowhere concerned with the entire process. And my Lord, the application should be sent by deputy commissioner to the district judge and then district judge to the government.
Yes.
Here, my Lord, the application which was invited was made in 3 newspapers, my Lord, which are not widely circulated in the region. And even the application, my Lord, was not sent to the local bar association, that is Chendraipatna. And my Lord, district judge, in fact, sends the communication to the district commissioner, and district commissioner sends the same to the government, my Lord. This is not according to section 26(2).
Judge is not involved.
He is involved, my Lord, but he has taken the opinion of senior civil judge, who is nowhere concerned with the entire process. And my Lord, the entire application process, my Lord, has been taken in a way that there are only limited number of participants. My Lord, out of 150 members in the local bar, only 4 applications were made. By the reason, my Lord, my Lords may take annexure P, Q, and R, my Lord. Page, my Lord, at 41, my Lord. My Lord, these are the newspaper notifications which are made, in those 3 newspapers, my Lord. One is Echaravani, other one is Prajodaya and Prakashamana. these three newspapers, my lord, are not widely circulated. And my lords may come to page number 27, ma'am. That is annexure F. The notification, my lord, ought to have been invited by the deputy commissioner, that is third respondent. Here, my lord, the Department of Hindulida Vargagala Kalyana Ilake Asan, who are nowhere concerned with the entire process.
My lord, I entered wakalat for fifth respondent. My lord, who has been appointed as an additional government pleader to the senior civil judge court at Chenraipatna as per annexure X, which sought to be quashed by exercising the writ of certiorari, my lord. But they have not at all stated which law has been either authorized or it has been breached. Lord, in the earlier occasion, what had happened, Lord, the appointment was not made in consultation with the district judge. On only that ground, Lord.
Where are the rules relating appointment?
Lord, annexure.
Lord, they have produced
annexure T.
that rules. As per annexure, page 60, annexure T, my lord, it starts from 46.
Yes.
The relevant rule, my lord, is at 26, my lord. In page.
Yes.
Yes, my lord, 68, my lord. The sub-rule 2 reads like this, my lord. The deputy commissioner shall, whenever required by the government, invite application from eligible practicing advocate of the place for the post of district government pleaders, so and so, specifying the date from which such an application should be made and forward the application so received to the district judge along with the remark about their suitability for appointment to the concerned post. On receipt of the same, the district judge shall forward them to the government in the Department of Law and Parliamentary Affairs, appending so and so. These are all the main features, my lord. In the case of amendment, government has directed Deputy Commissioner Hassan to invite the application, appoint as per this rule, as observed by this honorable court in the previous occasion.
Yes.
Lord, in the case, what has happened? The Deputy Commissioner, Lord, has directed the Commissioner of
Backward classes.
Backward classes.
What is his role to commissioner, direct the backward classes commissioner?
My lord, as per the government circular, my lord, he is expected as a assistant to the deputy commissioner will do some ministerial work.
Sir, he is supposed to do it. This is not a, what you call appointment of some sweepers.
Yes, my lord, he is a government pleader.
It's a very senior position in the judiciary.
2 minutes.
Correct. So therefore, how can the deputy commissioner delegate his work to a backward classes commission?
But he has not delegated only for the limited purpose of collecting application. But the deputy commissioner, my lord, has done all the
notification issued by the deputy commissioner inviting applications. ಇದೆಯದು?
ಅಲ್ಲ ಒಂದು ಅವರು ಅನೆಕ್ಷರ್ ಅಲ್ಲಿ 27/2000 ಒಂದು ಆರ್ಡರ್ ಇದ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
Where is the notification issued? Where is government? Where is the notification issued by the government, by the deputy commissioner?
We will place it, my lord, 2-3 days, we will place it.
AG is directed to accept notice for response 1 to 4. Mr.
I appear for the fifth respondent, my lord.
What is your name?
My lord, K.R. Nagaraja.
Mr. K.R. Nagaraja undertakes to appear for the respondent number 5.
5, my lord.
Vakal hakidiri?
Hakidini, sir.
Has appeared for the respondent number 5.
Earlier, my another colleague has entered caveat, but I have filed the wakala.
Office is directed to show his name in the cause list. List on, when do you want it?
21.
Learned the AG is directed to secure information whether the notification to invite applications for the post of district government pleader was issued by the deputy commissioner and whether the process as prescribed under
Rule 26.
Rule 26 of the
Karnataka. Lord, appointment of law officers.
Karnataka law officers bracket appointment and conditions of service.
Rules 1977.
7 is complied. Just list on.
Lord,
Next week I have one date. 14th March.
My lord, till then it may be annexure S may be stated.
There should be somebody to represent the government in the courts.
Our charge
But he has already reported, my lord, he has
Can't
taken
we
charge
can't-
on 28th.
Somebody should work.
My submission is the
Still
charge has not
34.
been taken, my lord. Till the next date, it may be stayed.
Let it come. Yes.
34,
Not any date, my lord. Next, please, great.
Pawan Kumar.
It's my request the matter be taken up tomorrow, my lords, because senior counsel engage ಆಗಿತ್ತು ಮಗಂಗ್ ಹುಷಾರಿಲ್ಲ ಅಂತ ಹೊರಟ್ಬಿಟ್ಟು.
ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು?
Suspension, my lords, it's been more than 6 months since I've been suspended. So I'm working the post of project director of my lords in Nirmik Kendra.
Where's the order of suspension?
Annexure B, my lords,
Annexure B.
page 18. ಪ್ರಾಜೆಕ್ಟ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿದರೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ರೆ ಇನಾಗ್ರೇಷನ್ ಮಾಡಿದ್ದಾರೆ, ಯಾವುದೋ ಒಂದು ಎಂಕ್ವೈರಿ ಪೆಂಡಿಂಗ್ ಇದೆ, ಯು ಮೈಟ್ ಇಂಟರ್ಫಿಯರ್ ಅಂತ ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಮೈ ಕೇಸ್ ಇಸ್ ಪ್ರಾಜೆಕ್ಟ್ ವಾಸ್ ಕಂಪ್ಲೀಟೆಡ್, ಇಟ್ ವಾಸ್ formally not handed over, my lords, because there is no direction from the governing body.
Yes, government.
1, 2 and 5, your lordship.
AGS director accept notice for response 1, 2 and 5. Issue emergency notice to respondent number 3 and 4. List on date put.
It's interim order ಕೇಳಿದ್ದೀನಿ.
Interim order ಏನಕ್ಕೆ?
Stay of my suspension, my lords.
So
6 months ಆಗಿದೆ.
We'll direct them to reinstate you into service. Yes, list on date put.
20th March.
ಅಲ್ಲ, my lords, urgency ಏನಂದ್ರೆ it's a single post cadre strength, my lords. They are trying to appoint somebody else without removing, virtually almost to my termination.
I hope you understand this is only a case of suspension. This is not a case of termination, which means that you are still in service.
ಹೌದು, but still they are trying to appoint.
Service, mister. You're still in service.
Page 40 ಒಂದೇ ಅನ್ಸುತ್ತೆ.
It's an order of suspension, which means to say that you are still in service. Nobody else can be appointed to your place.
Let them know prescribed, my lords. They'll terminate and appoint somebody else, my lords. That is the
Final hearing matters.
Termination ಮಾಡೋಕೆ ಎನ್ಕ್ವೈರಿ ಮಾಡಬೇಕು. ಎನ್ಕ್ವೈರಿ ಮಾಡಿದಾರ?
ಏನು ಮಾಡಿಲ್ಲ.
ಏನು ಮಾಡಿಲ್ಲ. ಮತ್ತೆ ಹೆಂಗ್ ಮಾಡ್ತೀವಿ? ಒಂದು ಡೇಟ್ ಕೊಡಿ, ಲಿಸ್ಟ್ ಆನ್
28th March. Final hearing matters, serial number 35.
ಯಾವ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಇತ್ತಲ್ಲ ಮೊನ್ನೆ ಕೇಳಿತ್ತಲ್ಲ ಯಾವ್ದು? ಲಿಸ್ಟ್ ನಂಬರ್ 2. Ready?
My request it may be listed in the same stage, my lords. Same stage list.
Yes, ಬರುತ್ತೆ ಕೊಡಿ. Yes.
List number 2, final disposal, serial number 1, Ashwini Rajgopal.
Yes. Have you amended the writ petition?
Pardon me, my lords.
Have you amended the writ petition?
I have amended the writ petition, my lords. The respondent number 2, my lords, has filed an additional statement of objections, my lords. It's yet to be filed in the registry, my lords. My statement of objections also ready, my lords. Could I request, my lords, it to be taken up maybe Friday, my lords? Amended writ petition along with all annexures have been filed separately, my lords, by a memo on 7th itself.
Yes, where is the other side?
PV Chandrasekhar, CM Nagbhushan.
I had informed him, my lords, that by serial number 35.
Already heard extensively.
Yes, my lords, I understand. my lords. Yes,
What
my
is there to be heard? Everything is argued.
lords. Yes, my lords.
Is there anything else to be argued?
They may have to.
They also concluded. Only I
I
have to pass an order.
We'll place on record some more additional judgment, my lords.
Judgment for what?
On the principle that
ಯಾವತ್?
Friday, please, my lords.
Friday ಆಗಲ್ಲ. Friday is only for judicial officers.
Please.
Tomorrow, day after tomorrow. Before I forget anything, I want to close this.
Yes, my lords.
Day after tomorrow.
Very well.
This day after tomorrow.
Interim order may kindly be extended.
Interim order granted as extension till the next day.
Grateful to.
List number 1 for.
Yeah, the
final-
mail, the learned counsel for the petitioner has amended the writ petition.
Witness.
Full stop. And objections ಆಗ್ತೀರಾ amended writ petition ಗೆ? The learned counsel for the respondent number 2
Please.
has filed statement of objections to the amended writ petition. So learned counsel for the petitioner seeks time, listed after tomorrow. Huh? ಅವರು ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಆಗ್ಲೇ.
I'll file it in the registry.
So the learned counsel for the petitioner has also filed a rejoinder. The learned counsel for the petitioner seeks time, listed day after tomorrow. Interim orders granted earlier. Interim order granted earlier is extended till the next date.
Grateful.
List day after tomorrow. Yes. ಹೆಂಗೆ ಹೇಳ್ತೀವಿ 2:30 ಆಯ್ತು 2:30 ಇಟ್ಕೊಳ್ಳಿ.
may I request, my lord, let it be in the list, my lords, with an understanding that it will be taken up at 2:30.
2:30.
Please.
Yes.
List number 1 for final hearing matter.
12.
Case number 35. M. Subramania Bhatt.
Lords, on the last occasion, one in two direct ಮಾಡಿದ್ದು, my lords.
Yeah.
With regard to
The records will be put with the petition along with the
documents
petition
submitted,
query.
that is Seva Dridhikarana Patra, which is page number 21. ನಮ್ಮ ಹತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯಾ ಅಂತ ಕೇಳಿ.
ವೆರಿಫೈ ಮಾಡ್ಬೇಕಾಗಿತ್ತು 2 days.
Yeah, 2020, you know that I don't grant time.
ಅಲ್ಲಲ್ಲ, only for verification matter. We are ready in the matter. God said
It's
directly
a
to see
short
whether
question of
the certificates which are now produced in the writ petition are in fact the very same certificates which are there in the file ಅಂತ. ಅದನ್ನ ವೆರಿಫೈ ಮಾಡಕ್ 2 ದಿನ ಬೇಕು. But on merits, my lord, we are ready. ಅದನ್ನ ವೆರಿಫೈ ಮಾಡಕ್ ಆಗಲ್ಲ because file could not.
So without verifying, can the writ petition be taken for consideration?
On 2 days, just 2 days, day after tomorrow I am requesting.
Learn counsel for the petitioner, learn counsel for the respondent number 2 seeks time to comply the order dated 3/3/2025. List day after tomorrow.
Yeah.
Yes. Day after.
Oblige.
36. SM Babu.
SM Babu.
Placing the
Not placed on
date of
record the actual
appointment.
discipline in which the petitioners were appointed as junior.
I'm placing the date of appointment of the petitioners here as per the directions.
So there's some order on the last date.
Yes, ma'am.
Director to place on actual discipline in which the petitioner was appointed as junior.
Blood. Date of appointment, my land fund has given the date of appointment as junior engineers.
Mechanical. ನಿಮ್ಮ ಹೆಸರೇನು? What is your name? Ashok P. Hugar.
All the 9, my lord. There are 9 petitioners before your lordship.
Yes, Mr.
My lord,
My lord.
one judgment, I'm placing on judgment of Haryana High Court, Punjab and Haryana High Court. On the same issue, my lord. Page number 1, my lord. May I read, my lord? On the same issue, my lord.
Yes.
First point, my lord, whether a notification dated 26/5/1977 in
Number?
my lord.
Page number, where are you reading?
Page number 2, my lord. Page number 2.
Of the judgment?
Yes, my lord. Whether a notification dated 26/5/1977 in file F1 F16-19/75 T2 allegedly by the Ministry of Education and Social Welfare, New Delhi, was in fact issued by the said department. On the said notification only, the petitioner have challenged the writ petition, Your Honor. And whether benefit of the said notification can be given to the appellants in the present case in LPA 26 of 2018. In the said notification dated 26/5/1977, the Director Technical of Ministry of Education recognized that diploma in engineering is an appropriate discipline plus total 10 years of technical experience in the appropriate fields equivalent to a degree in engineering. Next, my lord. The benefit of the said notification is being claimed by the appellants, while the respondents contended that there is no such notification issued by the Union of India, that is fictitious document, and so it is not be enforced, my lord. Learned single judge in his order dated 22/12/2017 in CWP 16224 of 16 had agreed with the contention of the respondent and declined to apply the said notification by placing reliance on a counter affidavit said to have been filed by the respondent number 67 and 11 on 11/2/2017, wherein they had taken a stand that the alleged notification has not been issued by the Ministry of Human Resources Development, Government of India, and that is a fictitious notification, that efforts were made to obtain the original of the said notification from Central Board, Central Record Unit section of Ministry and the Department of Publication, Ministry of Urban Development, Government of India, which is repository of Gazette notification published in the Government of India press, but both the CRU section of Ministry and the Department of Publication have stated categorically that the said notification is not available. reference is also made made to an order passed on 15/12/2015 by the Central Administrative Tribunal, Chandigarh bench in OA number so and so, a notification dated 23/3/2016, published on 9/5/2016 by the Ministry of Human Resource Development, wherein the notification in file 18-19/75 T2 dated 26/5/1977 was declared as fictitious, my lord. The learned single judge who decided CWP 16224 of 2016 held that the benefit of the said notification cannot be given to the appellants who are respondents before the rejected plea, respondent before him, and rejected the plea of the appellants that for the previous 40 years, not only Union of India and its department, but even the state government had recognized and granted benefits under the said notification. The learned single judge held that in view of the affidavit of the Secretary, Ministry of Human Resources Development, the benefit treating the appellants as degree holders wrongly granted and directed withdrawal of all the benefits given to them. Learned counsel for the appellant contended that learned single judge erred in disbelieving the very existence of notification dated 26/5/1977 and in denying the benefits under the said notification to be to the appellants. According to him, the said notification has been given effect to in several cases decided by various high courts, including this high court, and some of the said orders have been confirmed by the Honorable Supreme Court. He draw attention of this court in civil appeal number 591/2009, decided on 7/5/2015, arising out of CWP number 17974/2006, decided on 10/1/2008 by this court. We may point out that in CWP 17974 of 2006, as also in civil appeal number 591/2009, nobody doubted the existence of notification dated 26/5/1977. The court proceeded on assumption that such notification was issued by the concerned ministry and was valid and subsisting and granted relief on that basis. Therefore, it cannot be held that there was an adjudication in those proceedings about the validity and existence of the said notification. Likewise, it may be that in review petition filed in the Supreme Court in review petition number 2826/2007, there was a reference made to the order dated 15/12/2015 passed by the Central Administrative Tribunal, Chandigarh bench, wherein it had declared that said notification dated 26/5/1977 as fictitious, and the review petition itself was dismissed on 16/1/2018, observing that no merits was found in the same and also on the ground of delay. But the scope of the review petition is that interference would be warranted only if there is an error apparent on the fact of the record, and the dismissal of the review petition stating that there is no merits in it would only give an impression that no error apparent on the face of the record was found in the order passed in civil appeal. The said observation in review petition cannot be construed as finding being given by the Honorable Supreme Court about the incorrectness of the order dated 15/12/2015 passed by the Central Administrative Tribunal, Chandigarh, or about the validity of the existence of the notification dated 26/5/1977. Having regard to the stand taken by the Secretary of Ministry of Human Resources Development in counter affidavit dated 11/12/2017 referred above, it is not possible to hold that notification dated 26/5/1977 was in fact issued by Union of India and grant relief to the appellants as if the said notification is valid and subsisting. Wherefore, we do not find any error in judgment of the learned single judge warranting interference by this court in existing exercising of jurisdiction under the later parent.
Yes.
The said notification itself fictitious and the.
Is it your contention the objections?
No, my lord. This judgment was passed later, my lord.
Judgment was passed later.
Yes. No, we are not taken that contention.
Not taken such a
Yes, no,
contention.
my lord.
How can you take contentions which are in one writ petition in a different way and another petition in a different way? In this writ petition, you did not raise a contention that the
No, my lord.
notification is
No, my lord. We are not-
fictitious.
Yes, my lord.
There you go and raise a contention, it's fictitious. Why this double standard?
Same notifications ಅವ್ರು ಏನ್ ರಿಲೈ ಆಗಿದಾರಲ್ಲ ಸೆಂಟ್ರಲ್.
How can you take such a contention there and not raise a contention here?
What, again, the petitioners are relying on the central government, ಇದೇನಿದೆಯಲ್ಲ my lord, annexure.
ಅಪ್ಪ ನಂಗೆ ಅರ್ಥ ಆಯ್ತಪ್ಪ, even if you tell it 100 times, the same point will be canvassing the same point. What I asked you was, in Punjab and Haryana, you took a contention that this notification is fictitious.
Yes, ma'am.
And in Karnataka, when the same question comes up for consideration, you don't take a contention. Why this double standard is what I am asking you. Why this double standard? In this writ petition, you proceed to file your statement of objections on the premise that this notification exists.
Yes.
Yes, ma'am. Yes, ma'am.
Now we are taking a totally opposite.
Yes, ma'am.
We should file an additional written statement, additional statement of objections or something like that. Yes, sir.
In para 5 of my objection,
Hmm.
the WP is liable to be dismissed for the reason that the petitioner have failed to produce the necessary certificate or confirmation from GOK, technical education for equivalent of the diploma 10 years technical experience as equivalent to degree in engineering for the certificate issued by IAF ಅಂತ ತಗೊಂಡಿದ್ದೀವಿ sir last.
So you are proceeding on the assumption that the
Yes, assumption,
notification
yes.
exists.
Properly ಗೊತ್ತಿರ್ಲಿಲ್ಲ sir.
Huh?
Assumption ಮೇಲೆ ಇದ್ ಮಾಡ್ರಿ sir.
Although you proceed on the assumption that it exists. Now we are coming and saying that the notification itself does not exist.
If I am not interrupting, I'm sorry. The KPSC itself, as my lord recruited, I have the documents, I'll produce it before your lordship. As recruited, not only to the post of junior engineers, but also to the assistant engineers.
Yeah.
On the certificate issued by the military authorities.
Hmm.
And my lord, there in respect of quota meant for ex-military service candidates. In fact, today I got all those documents, but I could not.
Some review petition was filed before the Supreme Court. Yavudu? Please come to the order that he has produced today.
Yes, my lord.
Likewise, page number 4 ಅಲ್ಲಿ ಏನೋ ಇದೆ ನೋಡಿ.
Yes, my lord. 591 of 2009, my lord.
No. Review petition 2826 of 2017.
Last paragraph.
Yes, my lord.
Last paragraph. Review petition filed by the Supreme Court. In review petition number so there was a reference made to the order dated past with central administration. This order here.
Order.
This notification did not exist, does not exist.
Lord, that is
Then
one of
what?
that is the notification I am trying to rely upon. Now, my lord, now by virtue of this judgment, my lord, that I can't rely on that judgment. Now let us go once again, Lord, may kindly. I'm sorry if it is a repetition. Now, Lord, may kindly take, my lord, the recruitment rules. Ink page 37. Ink page 37. We are concerned about the post of assistant engineer.
Yes.
Lord, there, Lashmi kindly say below civil, electrical, mechanical, instruments, so on so.
Page number
Category of page 37.
37.
Adರಲ್ಲಿ category of post. Adರಲ್ಲಿ assistant engineer, civil, electrical, mechanical,
Yes.
instruments, so on so. Now, Lashmi kindly see, Lord, one is appointment by direct recruitment. We are not concerned about this direct recruitment. Now, Lordship, below, my lord. By transfer of a junior engineer having 3 years diploma qualification. I'll stop at that, my lord. Here, Lordship, kindly say, the petitioners, my lord, all the petitioners have the diploma in civil engineering in respect of different trades. That is in respect of these categories. I will also bring it to your Lordship's notice. These persons have been appointed as junior engineers in that particular trade itself, in which they have been trained. Now, my lord, the second portion is then engineer having 3 years diploma qualification on acquiring engineering degree. That means these persons who have been appointed as junior engineers after 3 years of experience as junior engineers will be eligible for being considered to the post of assistant engineers in accordance with these rules, if they possess the degree.
Yes.
Now, what is the degree that has been learned in the certificate itself that they have said that, Lord, I'll read that certificate, Lord. Lord, ink page 27, annexure.
Yes.
Any one of those annexures, Lord. Lord, so far as para 1 is concerned, that is so far as the diploma is concerned. Number 2, this is regarding degree.
Yes.
Indian Air Force trade missile fitter so and so has been recognized as diploma in electrical engineering.
Mechanical engineering.
Lashmi, either the electrical or same certificates. Your Lordships are reading annexure, Miller?
Annexure A.
Yes, I'll read annexure A itself.
A1.
A1. Yes, Miller. Engineering fitter. Indian Air Force trade engine fitter has been recognized as diploma in mechanical engineering for recruitment to subordinate posts and services under the central government, wide government of India, Ministry of so-and-so, Department of so-and-so, so-and-so. Further, diploma in engineering. Now, this is important, Miller. Further, diploma in engineering in appropriate discipline plus total 10 years of technical experience in the appropriate field is recognized as equivalent to degree in engineering, wide government order of Ministry of India dated so-and-so, so-and-so. So, my respectful submission is that, my lord, after recruitment as junior engineer, my argument, my lord, after appointment as junior engineers, admittedly they have, after completion of 3 years, since they possess this qualification as per the certificate issued by the Indian Air Force, since they have 10 years of experience in that field itself, they should be treated as degree holders. Therefore, the requirement under the C&R rules fulfills this certificate that they are bound to be considered to the post of assistant engineers in the category of transfer of a candidate to that respective
Correct,
grades.
but this is again based on that notification dated 20.
That is what, my lord, is coming in my way.
Ah.
That, my lord, I may have to examine, or your lordship may, if there is a Supreme Court judgment, my lord, I can't. Definitely, my lord.
Review petition, pull that judgment. Pull out that judgment, Mr. in review petition civil number 2826 of 2017.
Yes, ma'am.
Adun tarabekalva.
That is the most important judgment, my lord, that the Supreme Court has.
Shall I pass it over?
Yes, ma'am.
Down. And you also get the judgment in the SLP, because this is in review.
Yes, ma'am.
There should be one judgment in SLP
SLP.
also. Get the judgment. Pass
230,
over.
230, my lord.
230.
Number 37, Vijay Kumar.
Vijay Kumar. Vaishali Hegde, yes.
This is a matter, my lord, where the petitioners were.
With your lordship's leave, may
Yeah.
I just make one submission? Your lordship, this was a transferred brief, not that I'm giving an excuse, but it's the truth. Transferred brief, and there was a statement of objection in the file, so I presumed it would have been filed. But on checking up the court papers, it has not been filed. So the statement of objections I've
We'll take
prepared.
it, yes. Learn counsel for the respondent number 2 has placed on record the statement of objections. Yes. Ready, na?
Please.
You ready?
Please.
You are also ready?
Please, good. What remains, I do not know. In view of the statement of objections.
I
they have
also
been
do not
prepared.
know what remains. Let us see.
They are very.
Yeah.
This is the only matter, my lord, where, my lord, the benefits have been extended to the petitioners. And, my lord, without their holding any inquiry or any opportunity of audience, my lord, that the same has been withdrawn. That is the only case, my lord, I like.
Where is
like
the impugned order?
Please, my lord. Annexure. Annexure M and Annexure N, my lord.
M and N.
Yes, my lord. Page 61 and 62. With regard to first petitioner and second petition. Now, what has happened here is, my lord, the petitioner was initially appointed as assistant professor, my lord, and thereafter, my lord, as per the government order, my lord, which is at Annexure H. I may be permitted to read Annexure H for a moment, my lord, page 38.
Annexure H is
H, page 38.
38.
Proceedings of the government of Karnataka, which is dated, my lord, 24th May 2010.
Yes.
So, Lord, preamble, based on the recommendation made by the University Grants Commission, the Government of India, Ministry of Human Resource Development, Department of Higher Education, in its letter dated 31/12/2008, read at reference number 1, above has communicated to the state government a new scheme stipulating revised pay structure, service conditions, and educational qualifications in respect of teachers, librarians, and physical education directors working in the university, government and aided colleges, and government and aided law colleges for adoption in the states. Lord, now I would like to draw your lordships, Lord, page 39, in continuation of the same paragraph, Lord. In the letter read at 9, above Ministry of Agriculture, Department of Agriculture, Research and Education has advised the state governments to implement the above said scheme in the universities of agriculture sciences in the states. Accordingly, the same has been implemented in respect of teachers and equivalent cadres in the University of Agriculture and Horticulture University in Karnataka. Lord, the scheme says, Lord, now I would like to, Lord, at the bottom, Lord, the government order. Government are pleased to extend the 2006 revised UGC ICAR pay scales to the teachers of Karnataka Veterinary, Animal and Fisheries Science University, Bidar as follows. kindly be noted, my lord, it is only in respect of Bidar. That is the, my lord, we are also working in, under the University of Fisheries, my lord. What has happened is this government order is made applicable only in respect of Bidar University. What that says is, my lord, kindly come to, my lord, assistant professor, item number 4. Assistant professor selection grade or associate professor with 3 years of service as on 1/1/2006. The pay scale would be, my lord, associate professor, redesignating the post of assistant professor as associate professor, or 12,000 to 18,300 is the existing pay scale. They should be placed on 37,400 to 67,000, along with AGP of 9,000.
Yes.
This was the scheme introduced in 2010, my lord, extending the same benefits to the petitioner, my lord, which was extended on
Where were you working?
my lord, Mangalore University.
Bangalore.
Mangalore.
Hmm.
Department of Fisheries, Resources and Management, Colleges of Fisheries, Mangalore. Lord, the annexure L may kindly be, page 60. Lord, the refixation of pay to Dr. S.R. Somsekhar, Assistant Professor, College of Fisheries, Mangalore. Consequent to the promotion of Dr. S.R. Somsekhar, Assistant Professor, selection grade, College of Fisheries, Mangalore, with effect from 6/6/2006, the pay of the teacher is refixed as follows. Lord, 1/1/2006, my lord, I was drawing the pay band of, I was in the pay band of 19,210, and basic was 26,210. My lord, which on acquiring the on 6/6/2006, my lord, promoted as assistant professor selection grade in the pay scale of rupees 15,600 to 39,100 with plus AGP 8,000 with less than 3 years of service. I was having less than 3 years of service, Lord, at that point of time, this was the scale. Thereafter, my lord, on completion of 3 years of associate, on completion of 3 years, the associate professor was given 37,400 on 6/6/2009, 37,400 plus AGP 9,000, not the 46,400 was the pay scale.
Yes.
On 12/10/2010, pay is refixed due to sanction of 3 advance increments for acquiring PhD degree with effect from 12/10/2010 and 2 advance increments for designated as associate professor. That the scheme provides for that, my lord. Annexure H, which I read right now, my lord. I would like to now, my lord, to kindly.
But on completion of 3 years, you were designated as associate professor itself.
Assistant professor to associate professor, those who acquire PhD qualification. Yes, ma'am.
No, but with assistant professor with 3 years was designated as associate professor.
Yes, ma'am.
As per this notification.
Yes, ma'am.
2010.
It's just redesignating me because I was already in the assistant professor selection grade.
Yes.
After completion of 3 years, my lord, I was given associate professor. It is a redesignation to the post. Kindly come to, my lord, page 45 for a moment.
45.
45. Sorry, my lord, 46.
Yes.
Lord, career advancement scheme for teachers, Lord. I was given a career advancement scheme, which was, Lord, in the year 2010 itself, Lord, the assistant professor, item number Roman 5, Lord.
Yes.
Roman 5. Assistant professor completing 3 years of service in the AGP of rupees 8,000 shall be eligible subject to other conditions that may be prescribed by the UGC or ICAR and the university to move to the pay band of rupees 37,400 to 67,000 with AGP of rupees 9,000 and to be designated as associate professor. This benefit was extended in view of the government, the proceedings, Lord.
Yes.
That has been extended in 2012 itself. Lord, without giving any opportunity of audience, Lord, or without giving any notice or hearing, Lord, straight away, Lord, they have passed annexure M and N.
Yum.
Yes, Lord. This is the impugned order, my lord. These are the impugned order by which, my lord, the annexure M, page 61. Consequent to implementation of UGC and ICAR, pay scale 2006, wide reference number 1, The pay of Dr. Somsekhar, Associate Professor, College of Fisheries, College, Mangalore, has been fixed under wide reference number 2. The error occurred while fixing the salary has been rectified, and the additional increment sanctioned to the official is herewith withdrawn and redesignated as Assistant Professor Selection Grade. The pay of the official has been fixed as follows. Have been brought back to the post of Assistant Professor Selection Grade, and the benefits, the increments which were given to me, and the redesignation which was given to me, Lord, as per the government circular, the proceedings, Lord, that has been withdrawn without giving any opportunity of hearing. This is the only case, Lord. For this reason, Lord, I have approached this honorable court, challenging the bill.
This notification, what is the date of this notification? Granting
24th May 2010.
24th May, na?
Yes, ma'am.
And what is this GO at serial number 1 referred in annexure N? 24/6/2010. Adena? This is the government order?
4/6/2010.
Yes, do you have a copy? 24/6/2010.
24/6.
No, Lord.
24 May
Even I
2000.
don't have, Lord. I have not placed it.
Hmm?
24/5/2010. Lord, it is 24/5/2010, if I'm not wrong, Lord. That I have produced at page 38. That is the notification, government circular.
24/5.
It is 24/5, Lord. It is not
24/5 or 24/6?
24/5.
24/5.
That is the reference number. Kindly come to me,
Come
Lord.
to the next letter.
Please, my Lord.
Annexure N ನಲ್ಲಿ
21, yes, my Lord. Annexure,
6 ಅಂತ ಇದೆಯಲ್ಲ ಅಲ್ಲಿ.
no, my Lord. It is 24/5 only. Kindly come to the reference number, my Lord, which I have.
I saw that. AHF.
AHF 106 VET 2009, Bangalore dated 24th May 2010 ಅಂತ ಇಲ್ಲಿ
ಇದು annexure N ನಲ್ಲಿ ನೋಡಿ.
My Lord. Annexure N.
It says 6.
That is also 24/5, my Lord. Reference number 2.
No. Annexure N. It says 6.
It says 6.
Annexure N is reference number 2, my Lord.
Reference 2, it says 6.
24/5 only, madam.
5 ಅಲ್ಲ 6
24.
ಅಂತ ಇದೆ.
5, madam. That is the very reference
ನೋಡ್ರಿ,
bearing
ನಿಮ್ಮ
number.
ಗಮನ ಸರಿ ಇದೆ.
AHF 106 BET 2009, Bangalore dated 24/5/2010.
5 ಆ?
The very proceedings, government proceedings.
Highlight ಮಾಡಿ.
Yes, madam.
Please. Your Lordship may kindly take the objection that I have filed. Take your Lordship to page 33, R2H.
Yes.
This is a, Your Lordship, I'll read the order straight away. It's dated 15/10/2015. The Vice Chancellor, Karnataka Veterinary and Animal thing, either is pleased to promote the teachers enlisted in the annexure to the order from associate professor to professor in the pay band of 37,400 to 67,400 with AGP 10,000 under the career advancement scheme, so and so. Thereafter, Your Lordship, I take Your Lordship to the annexure, page 35. Serial number
14.
Serial number 12 and 14 are the petitioners. Now, their promotions was with retrospective effect from 2013 and 2012, 2011.
Yes.
Before that, Your Lordship, as page 31, R2G.
Page 31.
31. R2G. Again, I shall take Your Lordship just to the order. So the Vice Chancellor so and so is pleased to redesignate the teachers enlisted in the annexure to this order from assistant professor to associate professor with the pay band of 37,400 so and so, so and so. That is the pay band they are in. And Your Lordship may kindly see there also at serial number 3 and 4 are the petitioners.
Yes.
That is with effect from 24/5/2010, the date of the government order.
Yes.
And The other gentleman is from both of them from the date of the government order. So they've been redesignated. So that
Yes.
grievance will not survive. Apart from that, your lordship may kindly see, my learned friend read the government order. I would like to take your lordship to page 45 of the petition, which deals with increments. Subclause 3.
Yes. Yes.
The number of additional increments on placement of each higher state of AGP shall be as per the existing scheme of regulation of increments on promotion from lower pay scale to higher pay scale. However, in view of the considerable rise in effective pay between the two pay bands, there shall be no additional increments on movement from the pay band of 15,000 to 39,000 to the pay band of 37,000 to 67,000.
Yes.
Now, this is the pay band that they are in, 37,000 to 67,000.
That is in the post of associate professor.
Associate professor. And therefore, no increments can be given.
Yes.
So that is why we had.
You are explaining all these things by way of the statement of objection.
Yes, I've done that.
But why did you not call upon them
Your lordship may kindly see thereafter,
for revising their pay scale and reducing it
please,
and not giving the whatever increments?
please.
Should not hear them.
No, they've given representation that was under consideration. Your lordship may kindly say, I've produced all the documents. 2015, they've been given all the benefits. In fact, I am given to understand that the first petitioner is not even pursuing his claim because it's only a matter of 5,000. And only the second petitioner, I do not know whether I'm not in a position.
Whatever it is, they are from Mangalore.
Yes, please.
So Mangaloreans, they don't leave even a pie. So,
No, your lordship, we are generous and large-hearted lord.
that is what we see. The civil court, civil cases are Kutag Nodi. All that we get from Mangalore is Mori and Dari.
But seriously, in view of this, I think my learned friend should ask them whether they're interested, because the first petitioner has told because they've got all the benefits. It's only 5,000 rupees at the most.
5,000 rupees every month.
No.
Yes.
Only
Every month.
because after that they've been given. No, you're not entitled to. Okay, can I have that formality if they're retiring in this year? That formality, if they want an inquiry, I can.
For a moment, Annexure L may kindly be seen.
It's all right. You hear them out and pass appropriate orders. ಇವಾಗ ಹಂಗಾದ್ರೆ ನಿಮ್ದು ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ಸ್ ಎಲ್ಲ ಇದಾಗ್ತದೆ.
ರಿವೈಸ್ ಆಗ್ಬೇಕಾಗತ್ತೆ ಬಿಕಾಸ್
ಡಿಲೇ ಆಗ್ತದೆ.
ಹೌದು,
ಡಿಲೇ ಆಗುತ್ತೆ.
Annexure L.
ಇದು ಫೈನಾನ್ಷಿಯಲ್ ಇಂಪ್ಲಿಕೇಶನ್ ಇಸ್ ಜಸ್ಟ್ 5,000 rupees. I don't know. Subject what she say.
It has to be from 6/6/2009. What they say is, Madam said.
Before the order.
Yes.
Before the government order.
Yes.
How can it be?
What they say is 24/5/2010. 6/6/2009 they have extended me the benefit.
You hear them out and pass appropriate orders.
We'll give them out and pass orders.
Or should we keep this petition?
Your lordship may kindly see, they've given us 3 representations. All 3 representations, the government has rejected, saying they're not, I've produced.
That is not the point.
The government has said under no
Okay, but we'll keep this petition pending.
Please.
In the meanwhile, you please hear them out and pass appropriate orders.
Very well, your lordship.
Why should we, after 12 long years?
Please.
I don't want to send them back.
Again, and then.
Then again, they should not come back.
Then, your lordship may fix a time frame within which we.
In this petition, the petitioners have contended that upon refixation of their pay in view of certain government orders, the respondents, without issuing notice to them, unilaterally reduce the pay on the assumption that the petitioners were not entitled to certain increments. Full stop. The learned counsel for the respondents fairly submitted that the petitioners were the petitioners were not notified before the increments that were granted earlier under mistaken impression was recalled. Full stop. In that view of the matter, instead of disposing of these petitions, directing the respondents to reconsider the case of the petitioners, it is appropriate to keep this petition pending by directing the respondent number 2 and 2 to issue a notice to the petitioners, hear them out and pass appropriate orders regarding the reduction of the pay scale or the withdrawal of the increments granted to them. Full stop. This shall be complied by the petitioner, respondent number 2, within a period of 2 weeks.
Yes. I
Within a
will
period of
report-
2 weeks.
Yes.
List on
Please, first week of April, Your Lordship.
first week of April. Yeah, date code.
6,
2nd April, 2nd April.
2nd April.
I'm obliged.
38.
Appear for the petitioner, please, my lord.
Okay, Girish,
It's a,
you ready?
ready, my lord. I am ready, my lord.
You are
May I
also
go
ready.
ahead? My lord, it is
Yes,
a
please.
wrongful denial of promotion, my lord.
Hmm.
Petitioner was initially appointed on 31/5/2003 as grade 1 Gram Panchayat Secretary, my lord.
Yes.
He has completed probationary period as well as he has completed 5 years service also. And my lord, while annexure D, my lord, government order dated 4/3/2010, that is page annexure D, page 25. Government has taken a decision to promote 33% of in-service candidates to the post of PDO, my lord. And by virtue of annexure E dated 15/3/2010, my lord, that is annexure E is very important. Page 27, 36 grade 1 Gram Panchayat secretaries have been promoted as Panchayat development officers. The petitioner was left out without assigning any reasons, my lord. Annexure thereafter, annexure F dated 18/3/2010, page 30, my lord, came to be passed by the first respondent, citing some reason and suspending the petitioner, my lord, from the service. May I read that, my lord, for a moment, annexure F, my lord.
Yes.
Shri Jagdish Nayak, ಕಾರ್ಯದರ್ಶಿ ಗ್ರೇಡ್ 1 ತುಂಬೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಬಂಟ್ವಾಳ ತಾಲೂಕ್ ಆದ ನಿಮಗೆ ನೀವು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಬಂಟ್ವಾಳ ತಾಲೂಕ್ ತುಂಬೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಸಂಪೂರ್ಣ ಸ್ವಚ್ಛತಾ ಆಂದೋಲನದಡಿಯಲ್ಲಿ ಸಾಧಿಸಲಾದ ಪ್ರಗತಿಯನ್ನು ಆನ್ಲೈನ್ ನಲ್ಲಿ 28/2/2010 ಒಳಗೆ ದಾಖಲಿಸುವಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರಗಳಲ್ಲಿ ಅನೇಕ ಬಾರಿ ತಿಳಿಸಿದ್ದರೂ ಆನ್ಲೈನ್ ಮಾಹಿತಿಗಳನ್ನು ದಾಖಲಿಸಿರುವುದಿಲ್ಲ. ದಿನಾಂಕ 17/2/2010 ಜರುಗಿದ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಕಾರ್ಯದರ್ಶಿಗಳ ಪ್ರಗತಿ ಪರಿಶೀಲನಾ ಸಭೆಯಲ್ಲಿಯೂ ಈ ಬಗ್ಗೆ ಎಚ್ಚರಿಕೆಯನ್ನು ನೀಡಲಾಗಿತ್ತು. ಆನ್ಲೈನ್ ಮಾಹಿತಿಯನ್ನು ದಿನಾಂಕ 15/3/2010 ಒಳಗೆ ದಾಖಲಿಸುವುದು ತಪ್ಪಿದಲ್ಲಿ ಸಂಬಂಧಿಸಿದ ಕಾರ್ಯದರ್ಶಿಗಳನ್ನೇ ಜವಾಬ್ದಾರಿಯನ್ನಾಗಿ ಮಾಡಲಾಗುವುದು ಎಂದು ಉಲ್ಲೇಖ 2ರ ಕಚೇರಿ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಲಾಗಿದ್ದರೂ ಇದುವರೆಗೂ ಆನ್ಲೈನ್ ನಲ್ಲಿ ಮಾಹಿತಿಯನ್ನು ದಾಖಲಿಸದೆ ಕರ್ತವ್ಯ ನಿರ್ಲಕ್ಷ್ಯ ತೋರಿರುತ್ತಾರೆ. ಮೇಲಿನ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಈ ರೀತಿ ಕರ್ತವ್ಯ ನಿರ್ಲಕ್ಷ್ಯ ತೋರಿ ಗಂಭೀರ ಲೋಪವೆಸಗಿದ ಕಾರ್ಯದರ್ಶಿಯನ್ನು ಸೇವೆಯಿಂದ ಅಮಾನತ್ತಿನಲ್ಲಿಡಲು ಇಲಾಖಾ ಶಿಸ್ತು ಕ್ರಮ ಜರುಗಿಸುವುದು ಸೂಕ್ತವೆಂದು ಮನಗಂಡು ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರವು ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶಿಸಿದೆ. ಬೈ ಆರ್ಡರ್ ಡೇಟ್ 18/3/2010 he was suspended, my lord.
Yes.
That was revoked, my lord, by next annexure, my lord, annexure G, my lord, in page 31, my lord.
Yes.
Then, my lord, disciplinary proceedings were conducted, annexure H, my lord, page 32. He has been exonerated from the charges, my lord.
Yes.
Then, my lord, I made a representation, my lord, annexure B, my lord. Kindly grant me promotion as which was given. Annexure B, page 19, my lord.
Yes.
For that, my lord, they have issued annexure A endorsement, my lord, citing the landmark judgment of Sirsikar, my lord, AR 19, it has to be AR 1967, but they have said 1997, there's a typographical error. Citing landmark judgment of MJ Sirsikar, which is in turn is applicable to my case. They have declined promotion to me from the date of 15/3/2015, my lord.
Yes.
My lord, this judgment, my lord, my colleague couldn't come there. This is very clear, my lord. Even promotion of civil servant may be illé bardidare swami. Even enquiry mugdidre, I mean, if he is exonerated, his promotion should come from retrospective effect from the date when
So
others.
how are you entitled for the promotion is what, where is the promotion list?
My lord, that is annexure D, my lord, annexure, one minute, annexure D. Annexure D, my lord, annexure E, page 28, my lord. ಇಲ್ಲಿ ಪೇಜ್ 28 ಅಲ್ಲಿ 29 ಗೆ ಬರ್ತೀನಿ ಸ್ವಾಮಿ. ಲಾಸ್ಟ್ ವ್ಯಕ್ತಿ 36ನೇ ವ್ಯಕ್ತಿ ಕುಸುಮಾಧರ.
You not arrayed any of the persons who's going to be affected
My
by
lord, I am
promotion.
I am seeking only give me retrospective promotion, my lord.
Yes.
I am questioning annexure A, my
Mister,
lord.
you are asking your promotion to be restored.
Please, my lord.
Which means to say that you will be placed above some person.
That's true, my lord. We have not made
You
any
not arrayed anybody as a party. Then
But my lord, here, my lord, my prayer,
I'm not
my,
on that. I'm not
please,
on
my lord.
that.
I got it,
No,
my lord.
some
We have,
person will be affected by any
Please,
order
my
that is going to be passed.
my lord, what
Not
happened,
arrayed.
my lord? Thereafter, my lord, 80 direct panchayat development officers were recruited. Now I have been placed below them also. I mean, 36 here plus 80 panchayat
We
development
are not dealing with that case. We are not dealing with the case of PDOs. We are dealing with your case for seeking, where you are seeking for promotion.
My lord, that's my prayer is also like that. I have also sought for a mandamus, my lord. Mandamus in my second prayer is for mandamus.
Correct,
Seeking.
but should you not implead the immediately affected person?
My lord,
ಮಾಡ್ಬೇಕಲ್ವಾ?
my contention is because as on that date, my lord, 15/3, there were no suspension order against me.
Again, I understood your case,
Yes,
Girish.
yes,
Why
yes,
don't you
yes.
understand my point?
I got it, my lord.
Then if you got it, then you please answer my query.
That's not made.
Then how can you be placed above a person who is already promoted without hearing him?
Now there are several persons, my lord, more than 80 plus 36, 116 persons.
Therefore, if a retrospective promotion is granted, then where will you be placed? You'll be placed about several people. Should they not be heard?
That's that point, my lord.
Then
I have mistake.
I
may be permitted.
Not in this petition filed in 2013. And you want to implead them now? You're challenging the promotion now? After so many years, you can't disturb settled waters. Good. The petitioner is before this court challenging an order dated 14/12/2012 passed by the respondent number 1, rejecting his claim for promotion with retrospective effect, that is from 15/3/2010. He has also sought for a direction to the respondent number 1 to promote him with retrospective effect from, that is from 15/3/2010, and grant all consequential benefits. Full stop. The petitioner contends that he was appointed to the post of grade 1 Gram Panchayat Secretary on 31/5/2003 and completed his probation period successfully on, completed the period of probation successfully on 9/6/2005. He contends that the next promotional post was the post of Panchayat Development Officer. Full stop. As per the Karnataka General Service bracket Development Section and Local Government Section Recruitment Rules 2009, notified on 4/3/2010, the post of PDO was to be filled through direct recruitment and by promotion from the post of grade 1 Gram Panchayat Secretary who had completed 5 years of service in that post. Full stop. If a sufficient number of grade 1 Gram Panchayat secretaries who had completed 5 years were not available, those who had completed 3 years could be considered. The petitioner contends that pursuant to the said rules, the respondent number 1 promoted 36 Gram Panchayat secretaries on 15/3/2010, although 67 promotional vacancies were available as on that date. He contends that he was eligible for promotion in all respects, but was ignored and left out from the process of promotion. Later, in order to cover up the illegalities, illegality in not granting promotion to the petitioner, he was suspended from service on 18/3/2010, which was later recalled on 28/4/2010. Full stop. A disciplinary proceedings was held against him, where it was held that he was not guilty of any misconduct. Full stop. Petitioner contends that he was promoted as a Panchayat Development Officer on 30/7/2012. Full stop. Since retrospective promotion was not granted to him from 15/3/2010 when he was eligible, he made many representations before the respondent number 1.
Annexure B and K.
Full stop. The respondents rejected his claim by passing the impugned order dated 14/12/2012 on the ground that none of the juniors of the petitioner were promoted. Full stop. The petitioner applied for necessary details of the proceedings of the respondent number 1, and on obtaining them, he realized that 67 promotional vacancies from the post of Panchayat Secretaries Grade 1 to the post of PDO was available as on 15/3/2010 in Dakshina Kannada district. And out of that, 8 posts of Panchayat Extension Officers was merged with PDO posts, and therefore 59 promotional vacancies were available. He contends that out of that, 46 Gram Panchayat secretaries were enlisted for promotion, amongst whom 9 secretaries were facing disciplinary proceedings, and one had not completed his profession. Therefore, he contended that only 36 persons were promoted to the post of PDO. He contends that out of the 9 GP secretaries who were facing disciplinary proceedings, his name was also included. Though, as on 15/3/2010, there was no disciplinary proceedings initiated against him. Full stop. He contends that he was entitled for being promoted to the post of Panchayat Development Officer on 15/3/2010 itself. And full stop. Nonetheless, the respondent number 1 announced the seniority list of Panchayat Development Officers as on 1/1/2012, where the petitioner was placed at serial number 139 below 90 officers who were directly recruited. The petitioner filed his objections questioning the seniority list, consequent to which the respondent number 1 issued an endorsement dated 16/2/2013, reiterating the stand that they had taken in respect of his promotion to the post of PDO. So the petitioner is therefore before this court challenging the said order. Next paragraph. Run counsel for the petitioner contends that the petitioner was appointed on 31/5/2003, and therefore, while granting promotion to the post of PDO, his date of entry into service had to be considered for the purpose of promotion. He contends that mere pendency of a departmental proceedings does not deprive the petitioner of his entitlement to be promoted. He contends that the only procedure to be adopted is to place the promotion of the petitioner in a sealed cover, which has to be declared after the disciplinary proceedings are concluded. He contends that the non-grant of the promotion to the petitioner is therefore illegal, and the petitioner is entitled to be promoted from 15/3/2010 when many of his juniors were promoted. Next paragraph. The learned counsel for the objection ಹಾಕಿದಿರಾ?
Objection.
The learned counsel for the respondent number one orally opposed the writ petition and contended that the petitioner was granted promotion to the post of PDO in the year
2012.
2020.
2012.
2012.
She accepted. Full stop. He contends that the petitioner raised an issue when the seniority list was prepared in the cadre of Panchayat development officers. He therefore contends that the petitioner, having once accepted the promotion to the post of PDO, cannot now turn around and claim that he ought to have been promoted to the post of PDO from 15/3/2010. Full stop. He contends that the persons who may be affected by restoring the promotion of the petitioner with retrospective effect are not arrayed as parties in this petition, and therefore the petition is not maintainable. Next, I have considered submissions made by the learned counsel petitioner and the learned counsel.
One submission.
Yes.
At least for grant of monetary benefits, my lord, he has
Nothing,
been,
nothing,
he has
Mr.
been, he has been.
Without
he has-
promotion, how can you be granted monetary benefit?
Because the very order is, my lord,
Sorry,
erroneous order,
purport.
my lord.
The petitioner who claims that he was entitled to be promoted from 15/3/2010 on which day many of his juniors were promoted, ought to have challenged the order of promotion. Full stop. The petitioner has laid low from the year 2010 till the year 2013, during which time he was granted a promotion to the post of Panchayat Development Officer, which he accepted without any without demur. Without demur, DEMURR, full stop. The petitioner kicked up a row when the seniority list of Panchayat Development Officers was published, by contending that his promotion must have been with effect from 15/3/2010. Full stop. The said objection of the petition was rejected in terms of the order dated 16/2/2013.
Annexure.
Full stop. The claim of the petitioner for retrospective promotion was though rejected with order dated 14/12/2012, the petitioner ought to have arrayed the immediate juniors who would be affected by restoring the promotion of the petitioner from the date when they were promoted. Full stop. Therefore, the petitioner is not entitled to any relief in this petition, as restoring the promotion from 15/3/2010 is likely to result would result in the petitioner being placed above nearly 90% officers of the 90 Panchayat development officers who are placed below the petitioner, even without hearing them. In that way of the matter, the petitioner is not entitled to any relief in this petition. Consequently, the petition is dismissed.
39, P. Mahesha.
My lord, appearing for the petition. My lord, matter may kindly be passed over. My lord. Senior is.
Pass over.
Number 40, Desim Babu.
Babu.
Whisper and pass over minutes.
Pass. AJ Srinivasan.
41, AJ
Hola,
Srinivasan.
Charan.
My lord, your lordship had
passed an order, my lord, directing them to produce certain records based on which they had discriminated me against me in the payment of certain terminal benefits to me. And they are yet to produce those documents before this court, my lord.
What are those documents?
My lords, we are ready, my lords. However, arguing counsel, my lords, as a matter before court all one, my lords, he is on his legs. My lords, may
So what
kindly
are
pass
those
over, my lords.
documents? After hearing the learned counsel for the petition and this court felt it necessary to call upon the respondents to give specific details of the persons found in page number 48 of the writ petition, insofar as it relates to the dates when they submitted the request for voluntary retirement, when it was accepted and when they were relieved, and when their request for voluntary was allowed to be withdrawn, as also whether they were granted terminal.
Annexure
Passed over, my lords. He's on his legs.
You want to pass over?
Yeah, please.
records, whether they, only the records they have to produce. Yes, ma'am.
Please,
The matter is listed today. Let us show some progress.
Yes, my lord. Yes.
Pass.
Hearing B group matter, serial number 42, A.R. Prasad Deva.
ಕೊಡಿ ಬರ್ತಾ ಇಲ್ಲ ಅಲ್ಲ ಇವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿಲ್ಲಲ್ಲ ಪ್ರಸಾದಿ ಅವ್ರು ನೀವಾ
I am for.
ವೈ ಯು ಆರ್ ನಾಟ್ ಕಮಿಂಗ್ ಟು ದ ಕೋರ್ಟ್
I have not received any message to my mobile, Your Honor. Several times I moved memos, I have not intimated.
somebody has to send a message to you.
You know, today, yesterday I received my mobile. No, I have implemented 3 persons as parties, which are parties affected with these 3 persons. Honorable Court has passed the order.
Please argue.
Let me file amended petition.
Please
Short
argue
it.
the matter.
Short it.
No adjournment.
Huh?
No adjournment. Please argue the matter. If you are entitled to relief, then we'll consider. Two 2014 matter, you are asking
Yeah,
for an adjournment.
Petitioner joined the service of this respondent number 1 in the year on 23/1/1984. When there were earlier 2 stenographers by name R.K. Rangaswamy and Rangnath, who were initially appointed stenos in the year 1979 and 1980, both were promoted on dated 1982. So made to work as a personal assistant as per service register maintained the head office. So when they were promoted as a personal assistant, the 2 stenographer posts became vacant, and they called for the suitable candidates by advertisement. Petitioner applied, and he was selected by submitting all his degrees, qualifications, stenotypist, everything. He was possessing BA and LLB and senior steno and Kannada. The petitioner initially appointed as stenographer in so-and-so pay scale. Next, and is subject to Karnataka State Handicap Development Corporation Employees Service Condition Supervisor Election 1996.
Are you ready or not? You're not ready. Pass over. ಓದ್ಕೊಳ್ಳಿ ಫೈಲ್. ಇಲ್ಲಿ ಕೋರ್ಟ್ ಬಂದು ಇಲ್ಲಿ ಓದ್ತಾ ಇದ್ರೆ ಫೈಲ್ ನ. No adjournment, sir.
Okay.
How many times should we adjourn? Last time you are not there. ಅದಕ್ಕೆ ಹಿಂದಿನ ದಿನ ಬಂದಿಲ್ಲ ನೀವು. ನೋಡಿ 3/1/23 you did not turn up. 1/2/23 you did not come.
ನನ್ನ ಮೆಸೇಜ್ ಬಂದಿಲ್ಲ ಸರ್.
ನಿಮ್ಮ ಹೆಸರು ಎಷ್ಟು ಸತಿ ಬರ್ಸ್ಬೇಕು ಸರ್?
ಸರ್ ಮೆಸೇಜ್ ಬಂದಿಲ್ಲ.
31/5/24 you did not turn up. ಬರ್ತಾನೆ ಇಲ್ಲ ನೀವು ಕೋರ್ಟ್ಗೆ.
ಸರ್ ಬರ್ತಾ ಇದ್ದೇನೆ ಸರ್, ನನಗೆ ಮೆಸೇಜ್ ಬರಲಿಲ್ಲ ಸರ್.
ಮೆಸೇಜ್ ಬರಲಿಲ್ಲ ಅಂತ ದಟ್ ಇಸ್ ನಾಟ್ ದಿ ಇಶ್ಯೂ.
ನಾನು ಹೇಗೆ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್?
ಪಾಸ್ವರ್ಡ್ ನೋಡಿ ಹೇಳಿ.
Your lordships, kindly, serial number 53. 53.1 is not connected with 53. As a serviceman.
We are still at 42.
I am seeking adjournment. I have informed
It's 43.
53.
Please wait.
53. Oh, I'm sorry.
Serial And for the petitioner, my lord,
Hmm.
page 37 is the annexure impugned.
53 ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
ಅದ್ರೊಳಗೆ 53.1 ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಅಂತ ಕನೆಕ್ಟ್ ಆಗಿದೆ. ಅದು that has to be disconnected.
Why is general miscellaneous matter listed?
ಜನರಲ್ ಮಿಸ್ಲೇನಿಯಸ್ ಏನೋ ಸೀನಿಯರ್ ರೋಸ್ಟರ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಅದು ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸಲ್ಲಿ ರಿವಿಷನ್ has been allowed. Challenging that some 3 cases have been filed. ಅದ್ರೊಳಗೆಲ್ಲ ನೋಟಿಸ್ ತಗತ್ತಿದೆ.
ಬರುತ್ತಲ್ಲ ಬರ್ಕೊಳ್ಳಿ.
Pardon me.
53.1 officers directed WP number 15875 of 2024 is delinked and order to be listed separately on
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ನಾನು ಇದು ಮಾಡ್ತೀನಿ. I will file ವಕಾಲತ್, undertake to file ವಕಾಲತ್ in other connected cases.
Mr. H.N. Manjunath Prasad seeks time to file memo of appearance for the respondent in the other connected petitions.
And I have speaking next week ಅಲ್ಲಿ ಕೊಡು.
ಯಾವತ್ತೋ told, yes.
I have informed the other side also.
2:30.
Please.
ಏನ್ matter ಇದು ವಿಜಯ್?
Lord, the petitioner, Lord, who is retired in 2014.
ಮೊನ್ನೆ ಬಂದಿತ್ತಲ್ವ ಇದು?
Yes, yes. Chennaigoda is here. 2142B, Lord.
Let's take it up at 2:30.
Please.
Submission, seal number 32. I gave the lower court case number incorrectly. Correct one I'm giving.
ಏನದು?
Stay ಆಗಿತ್ತು, proceeding subject to deposit.
Seal number?
32, my lords. The proceedings in execution case was stayed by court's order. Case number ತಪ್ಪುಕೊಟ್ಟಿದೆ. I've given the earlier proceedings case number. Correct number I've given.
ಏನ್ ಕರೆಕ್ಟ್ ಮಾಡ್ಬೇಕು?
Case number ಅಷ್ಟೇ. Execution petition.
ಆಯ್ತದೆ, ನಂಬರ್ ಸರಿ ನೋಡ್ಕೊಳ್ಳಿ.
With my lords kindly, my lords, number 46 may I make a request, my lords, could I request for day after tomorrow, please, my lords. In the afternoon, my lords, seniors on his legs in a part-heard matter, please.
PM Naik.
Please.
In D case,
No, my lords.
Promotion.
Redesignation.
ಆಯ್ತು ಹೇಳಿ ಯಾವತ್ತು ಅಂತ. Take whichever.
Please, grateful.
Any Monday ನಾ? B group Monday ತಾನೆ?
Monday. Very well.
2015 Monday.
Please. Grateful.
ಅಲ್ಲ ಒಂದು ಡಿಸ್ಪ್ಲೇ ಮಾಡ್ಬಿಡ್ರಿ ಯಾವ್ದಾದ್ರು ಯಾವತ್ತು.
Sir, court officer, sir. Sir, court officer, sir.
Yes, sir.
The 53.1 adjourn ಆಗಿದೆಯಾ sir?
53 point ಮಂಜುನಾಥ್ ಪ್ರಸಾದ್ ಅವರ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮೇಡಮ್ 53 ಅಡ್ಜರ್ನ್ ಅಲ್ಲ ಅದೇ 53 ಡೀಲಿಂಗ್ ಆಗಿ ಅದು ಮೇನ್ ಹೇಳ್ತು ತಾನೆ.
ಸರ್ 52 ಏನು ಅಡ್ಜರ್ನ್ ತಗೊಂಡಿದ್ದಾರಾ?
0.1 ನಲ್ಲಿ ಡೀಲಿಂಗ್ ಆಯ್ತಾ, ಸ್ಪ್ಲಿಟ್ ಸಪರೇಟ್ಲಿ ಅಂತ ಆಯ್ತು. 53 ಅಡ್ಜರ್ನ್ ಆಯ್ತು ತಾನೆ ಟೋಟಲ್ ಆಗಿ. ಏನ್ ಬರ್ಕೊಂಡಿದೆ ಓದಿ? 53 ಏನ್ ಹೇಳಿ ಬರ್ದಿರೋ ಓದ್ಕೊಂಡು ಏನ್ ಹೇಳಿದ್ರೆ ಓದಿ ಹೇಳ್ತೀನಿ ನಾನು. ಆಯ್ತು, ಅದೆಲ್ಲ ಅರ್ಜನ್ ಅದೊಂದು ಡಿಲಿಂಕ್ ಮಾಡಿ ಆಮೇಲೆ 23ಕ್ಕೆ ಹಾಕಿ 23ಕ್ಕೆ ಹಾಕಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ 52 ಯಾರು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡ್ರಿ?
3 of 2020 ಅದು ಇದೆ ಯಾವ್ದು ಮೇಡಮ್? 45 ಇದೆ ಮೇಡಮ್.
ಸರ್ 52 ಯಾರು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡ್ರಿ?
52 ಇದೆ ಮೇಡಮ್. 50 ಇದೆ ಮೇಡಮ್. ಯಾವ ಸರಿ ನಂಬರ್ ಯಾವ್ದಕ್ಕೆ ನಾವೇ ಇಲ್ಲಿ ಕೊಡೋದು ಸರ್, ನೀವು ನಮಗೆ ಕೊಡ್ಬೇಕು. ನಾನು ಎಲ್ಲಿಂದ ಕೊಡೋದು ನಿಮ್ಗೆ? ಗಿರಾಕಿಯಿಂದ ಮಾಡಕ್ಕೆ ಆಯ್ತು ಸರ್, ಬರ್ದಿದ್ದೀನಿ ನೋಡಿ. ನೀಲ್ಕಂಠಪ್ಪ ಕೆ ಪೂಜಾರ್ HGP.
ಸರ್ 53.1 ಕರೆಯಲ್ಲ ಸರ್, ಎಜ್ಜನ್ ಆಯ್ತಲ್ಲ ಸರ್? 53.1 ಎಜ್ಜನ್ ಆಯ್ತಲ್ಲ, ಕರೆಯಲ್ಲ?
53.1
ಅದೇ ಡಿಲಿಂಕ್ ಮಾಡಿದ್ರು ಸಾಹೇಬ್ರು, ಅದೇ ಅದು.
ಹಾ ಸರ್, 53.1 ಡೀಲಿಂಕ್.
ಓಕೆ
ಎಲ್ಲ 28 ಮಾರ್ಚ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
My lord's leave, my lord. Serial number 48, your lordship. Can I request my lord to have this matter tomorrow, my lord? 2018 matter, file is misplaced today, that's why. Tomorrow, my lord. I know what is the file now is.
So the petition seeks time.
Tomorrow. Your lordship has, your lordship has heard the matter when your lordship was sitting at the roster of service matter, my lord. Where Satish Dodamani has.
ಎರಡು ತಿಂಗಳಿಂದ ಯಾರು ಗೊತ್ತು?
That's
Who
right.
remembers what?
ನಾಳೆಗೆ short matters.
Yes.
Grateful.
ಕರೀರಿ ಯಾವುದು?
Admission is 230 matter, serial number 59. Sundar Raman MB.
Yes.
The review petition, lordship said heard, another friend, and us.
Regarding that House Committee
House
report.
Now, please see the order, my lord, at page number 46, running page 46. Para 17. In the case on hand, the plaintiffs were categorically mentioned in the plain. Statements made by the defendants in the two episodes dated 7/12 and 14/12, which purportedly defamed the plaintiff and the project. Therefore, it was for the defendants to establish that the information published or telecast was based on the documents, information source or corrected by them, no difficulty. A perusal of the two episodes referred above shows that the defendants have substantially relied upon the Karnataka Legislative House Committee report, the framework agreement, the proceedings before court, and the statements of agreed owners. It therefore goes without saying the defendants had pieced together various circumstances, claimed that the proponents had indulged in wrongdoing. Whether the material so collected was sufficient enough to justify the defense is a matter of fact. Then, insofar as the House Committee report is concerned, it is not necessary that defendants have to prove every bit contained therein. If they are able to establish that the episodes that were telecast were based on the House Committee report, they are bound to produce an authentic copy of the House Committee report. Having said that, defendants are not completely deprived, and their lordship then go on. Now, Lord, please see the House Committee report came into existence in the year 2016. 16.
So 2012, it
wouldn't have been there. And
if that is the issue, I think we have to read.
No, this is like what they call making mountain out of a molehill. There is a typographical error. Your lordship is not going to look at anything in isolation in that manner. What this case was about? No, there is a typographical error.
Please wait. If it's a mistake, we have to accept it.
It's a typographical error that can be
7/12
corrected without reviewing the judgment.
7/12/2012 and 4/12/2012 are two episodes.
Yes.
If the House Committee report is subsequent,
Yes.
then this is definitely a mistake.
Well, it is an error which, by the way, can be corrected without resorting to the review power, because that is what the courts have done. When the courts recognize that there is a typographical error, which at the end of the day,
A typographical error.
this is.
It is not.
This is. Now, for that, your lordship will have to go through the entire judgment because.
No, I have said that if you have referred to this framework agreement to telecast, then it's a, what you call.
Okay. Now, if that one phrase is removed from the judgment and the judgment read, the question is, will then the judgment support the eventual conclusion? It does support the eventual conclusion. Now, if that.
Anyway, it is my mistake. Let me correct it. Yes.
Allah, but then it is, the law is too well established in this regard.
I'm not going to review the judgment.
Your lordship, can I just refer the court to one-page orders passed by other high courts, which in fact have not been interfered by the Supreme Court?
Sorry. This review petition is filed in the light of certain observations made by this court in the course of the order, which is found at page paragraph number 17. Full stop. This court had recorded a finding that the two episodes dated 7/12/2012 and 14/12/2012 this court had that the two episodes that was telecast by the defendants were based upon the Karnataka Legislative House Committee report, while in fact the House Committee report was tabled in the year 2014, is it?
16, my lord.
In the year
16.
2016.
12th December 2016.
Full stop.
Our writ petition makes the
Therefore, comma, the finding of this court that the episodes were based on the Karnataka Legislative House Committee report is not correct. Full stop. To that extent, comma, the order dated so and so deserves to be reviewed. However, the order, however, the remaining portion of the order shall remain intact. Yes, review petition is allowed to the above extent. So that is all. That's a mistake on my part. Why shouldn't I accept it? It is
Right,
my
so-
mistake.
Allah, now what happens?
What happens?
The review is closed. This.
Review, which means the petition is not being restored.
Petition is not restored. The order remains, but only to.
There's a correction.
Only clarified.
There's a correction now in that order. That's all.
That is all. The order remains.
Grateful.
Hmm.
Nobody would have been misled. Even the trial court would not have been misled by this is a finding of fact.
No, that is right. I can't give a finding.
Allah,
that-
trial court would not have actually said, oh, because the High Court said it was based, I will treat it as based, Anta, because
no,
High Court
but-
sees
no,
it
no,
actually
that
happens.
can't be done.
Binding between parties, which becomes binding between parties.
It doesn't confuse anybody except
But it
somebody who reads
doesn't.
with the intention to be misled.
16 comes later than 12, isn't
That's
it?
correct.
So
Now, the
therefore-
trial court would never have been confused with this aspect at all.
Correct, but if it's a mistake on my part, why shouldn't I accept it? No, yes.
Great.
Further arguments, serial number 60. Rachana Bharadwaj.
Yes. I thought you'll only file your written submissions. Do you have any further submissions to make?
ಹೌದು.
Ah,
ಮೇ Constitution of India ಇಲ್ವಾ? ನೋಡಿ ಆಗ್ತಾ ಇದೆಯಾ? Lord, the bugbear in this matter is whether I'm entitled to the promotion to the post of senior assistant, which is the 27th vacancy in the roster point. The respondent secretariat, who's my employer, relies upon Rule 4 and 4A of the seniority rules. Lord, I would like to bring to your lordship's kind notice one amendment brought to the Constitution of India, to Article 16(4)A. 16(4)A, 16(4)B, and amendment to Article 335 of the Constitution fell for consideration before the Honorable Supreme Court in the case of M. Nagaraj. While the amendments were upheld, M. Nagaraj fell for consideration again in Jarnail Singh's case on certain aspects of M. Nagaraj, which dealt with the creamy layer, identification of adequacy, and representation of backward class and scheduled caste, scheduled tribe. Since it ran into the teeth of the judgment of Supreme Court in Indira Shawne's case, some portions of Nagaraj were not held to be correct. However, the validity of these amendments to constitutions were upheld. They were not disturbed. Pursuant to Nagaraj's case, with regard to identification of adequacy or otherwise of representation, since there was no material available before the government, on account of which the earlier Act of 2002 was stuck down by the Supreme Court in Pavitra 1, government constituted a committee headed by the Additional Chief Secretary, which submitted a report. Based on that, the Act was once again amended, which was questioned again by the parties affected, which is in Pavitra 2. In Pavitra 2, the amendments were upheld. The amendment inter alia provided for consequential seniority. By virtue of that consequential seniority, which was brought by way of an amendment, to be in tune with amendment to Article 16(4)(a), well, I'm entitled to count the seniority in my promotion post.
No, but why are we going into all those things?
That's because
No, the issue is very simple. You're entitled for a
Yes.
promotion
yes,
by applying that roster.
Yes.
You are the only candidate available
yes.
because there's some departmental proceeding.
No, there was no departmental proceedings.
What else was that?
What happened was the social welfare department annulled my appointment on the ground that
You're
the-
right, yes.
recruitment was not in accordance with the rules. The challenge which I threw to that was accepted by this honorable court,
Yes.
and that order was set aside. My probation was not declared, presumably because there was a case which I had instituted was pending. However, pursuant to the order of this honorable court, they declared my probation and regularized my appointment,
Yes.
by virtue of which I had to count the seniority from the date of declaration of my probation and confirmation.
Date of entry into service.
That goes back.
Mm.
That is in the lower cadre. Now, a vacancy arose on a particular day. For our purpose, let us take it as 13th of September 2010, on which day I was eligible to be considered for promotion to that post in accordance with the roster, as also in accordance with the ratio that is prescribed for the promotion. I was the only candidate available for promotion as against that post. That post was filled up by general merit candidate.
Yes.
That could not have been done in view of Sabharwal's case. Why I related this constitution is this. What led to amendment to these constitutions are, one, the case of, I'll cite some judgment. That's what I wanted to cite these judgments, my lord. Your lordships were other day referring to Badappanavaru. Badappanavaru was a case when the rules or the act of the kind did not fall for consideration.
Yes.
There was no amendment to Article 16(4). 16(4) came only subsequently with retrospective effect. Then 85th Amendment, which provided for consequential seniority, also fell for challenge. That was upheld in Nagaraj's case. So I am entitled to count my seniority by virtue of the amendment. So
Yeah.
Article 16(4)(a) and the act that was enacted in the year 2017. I'll read that act and I'll leave it to your lordship. Act is 2017. The entire history of reservation and what led to that amendment
Yes.
is narrated there, including the law laid down by M.G. Badappanavaru.
Yes.
I don't want to trouble your lordship reading the whole entire history because that is available there.
Yes.
What led to amendment is this. Now, what is that amendment? In internal page number 7 of the booklet, your lordship will find section 3. Notwithstanding anything contained in any other law for the time being in force, the government servants belonging to the scheduled castes and scheduled tribes promoted in accordance with the policy of reservation in promotion provided for in reservation order shall be entitled to consequential seniority. Seniority shall be determined on the basis of the length of service in a cadre, provided that the seniority inter se of government servants belonging to scheduled castes and scheduled tribes, as well as those belonging to the unreserved category, this is more important, promoted to a cadre at the same time by a common order, shall be determined on the basis of the seniority inter se in the lower cadre. Now, there are 3 persons involved in this litigation effectively. That is respondent number 2, respondent number 3, and the petitioner.
Yes.
Respondent number 2 and 3 belong to general merit category. While promotion of respondent number 2 is against a vacancy which fell for scheduled caste candidate, the promotion of respondent number 3 is against a quota which was meant for them. However, in view of the fact that I was the only candidate eligible to be considered for promotion to the post of senior assistant, which was 27th vacancy in the roster, which was not given to me because of that case, I'm entitled to stage a march over them, reading the fact that the promotion was considered, that I was considered to be eligible for promotion with effect from 13th of September 2010. Now your lordship will turn to Annexure K for a minute. So before that, my lord, can I take your lordship to Annexure J for a minute?
Yes.
Annexure J. That is the order, official memorandum, by which the petitioner was promoted. The second paragraph of that order. ಸದರಿ ನೌಕರರ ಪರಸ್ಪರ ಜ್ಯೇಷ್ಠತೆ ವೇತನ ಮತ್ತು ಅರ್ಹತಾ ದಿನಾಂಕದ ಕುರಿತು ಸಿಬ್ಬಂದಿ ಮತ್ತು ಆಡಳಿತ ಸುಧಾರಣೆ ಇಲಾಖೆ ಸೇವಾ ನಿಯಮಾವಳಿಗಳು ಇವರಿಂದ ಅಭಿಪ್ರಾಯವನ್ನು ಪಡೆದ ನಂತರ ಆ ಸಂಬಂಧ ಪ್ರತ್ಯೇಕವಾಗಿ ಆದೇಶವನ್ನು ಹೊರಡಿಸಲಾಗುವುದು. Now, Annexure K is what I'm referring to.
Yes.
Annexure J is at serial number 2 in that particular document.
Yes.
Read as reference number 2. 131, first page of the document, because
Yes.
there are some difference in the
Yes.
page numbers of the court copy and my copy. Moorne paragraph. Well, Lord, that order refers to the order of this honorable court, wherein they had set aside the annulment order.
Yes.
Kindly see. ತದನಂತರ ಸದರಿ ಅರ್ಜಿಯ ವಿಚಾರಣೆ ಮುಗಿಸಿದ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ ಸಮಾಜ ಕಲ್ಯಾಣ ಇಲಾಖೆ ವತಿಯಿಂದ ನೇಮಕಾತಿಯನ್ನು ರದ್ದುಪಡಿಸಲಾಗಿದ್ದ ಆದೇಶವನ್ನು ಅನೂರ್ಜಿತಗೊಳಿಸಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸರ್ಕಾರಿ ಅಧಿಸೂಚನೆ ಸೋನ್ಸೋ ಮತ್ತು ಸೋನ್ಸೋ ನಿರ್ದೇಶನಗಳಂತೆ ವಿಧಾನಸಭೆ ಸಚಿವಾಲಯದಲ್ಲಿ ಪ್ರಸ್ತುತ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳ ಎದುರು ನೇರ ನೇಮಕಾತಿ ಮೂಲಕ ತುಂಬಲಾದ ವಿವಿಧ ಹುದ್ದೆಗಳಲ್ಲಿ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಮತ್ತು ಪರಿಶಿಷ್ಟ ವರ್ಗಗಳ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳನ್ನು ಸಕ್ರಮಗೊಳಿಸಿ ಕ್ರಮ ಸಂಖ್ಯೆ 1ರಲ್ಲಿ ಓದಲಾಗಿರುವ ಆದೇಶವನ್ನು ಹೊರಡಿಸಲಾಗಿರುತ್ತದೆ. ಏತನ್ಮಧ್ಯೆ ರಿಟ್ ಅರ್ಜಿಯು ಬಾಕಿ ಇದ್ದ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಸಚಿವಾಲಯದಲ್ಲಿ ಹಿರಿಯ ಸಹಾಯಕರುಗಳ ಹುದ್ದೆಗಳನ್ನು ಮುಂಬಡ್ತಿ ನೀಡುವ ಮೂಲಕ ತುಂಬಲಾಗಿದ್ದು ಅನುಪಾತ ರೀತ್ಯ ಶೀಘ್ರ ಲಿಪಿಗಾರ ವೃಂದದಿಂದ ಹಿರಿಯ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಮುಂಬಡ್ತಿ ನೀಡಬೇಕಾದಲ್ಲಿ ಅನುಸರಿಸಲಾಗಿರುವ ಮೀಸಲಾತಿ ರೀತ್ಯ 27 ಪರಿಶಿಷ್ಟ ಜಾತಿ ಬಿಂದುವಿನ ಎದುರು ಪರಿಶಿಷ್ಟ ಜಾತಿಗೆ ಸೇರಿದ ಅರ್ಹ ಅಭ್ಯರ್ಥಿ ಇಲ್ಲದ ಕಾರಣ ಸಾಮಾನ್ಯ ವರ್ಗಕ್ಕೆ ಸೇರಿದ ಹಾಗೂ ಸೇವೆಯಲ್ಲಿ ಶ್ರೀಮತಿ ವಸುಂಧರಾ ದೇವಿ ಸಿಯವರಿಗಿಂತ ಹಿರಿಯರಾಗಿರುವ ಶ್ರೀಮತಿ ಎಸ್ ಮಂಜುಳಾ ಇವರ ಹಿರಿಯ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ದಿನಾಂಕ 13/9/2010 ತದನಂತರ 28/1/11 ಸಾಮಾನ್ಯ ವರ್ಗಕ್ಕೆ ಸೇರಿದ ಶ್ರೀ ಶಿವರಾಮಾಚಾರಿ ಇವರನ್ನು ಕೂಡ ಹಿರಿಯ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಮುಂಬಡ್ತಿ ಜ್ಯೇಷ್ಠತೆ ಪುನರಾವಲೋಕನದ ನಿಬಂಧನೆಗೆ ಒಳಪಟ್ಟು ಮುಂಬಡ್ತಿಯನ್ನು ನೀಡಲಾಗಿರುತ್ತದೆ. This promotion of second respondent is illegal is what my humble submission.
Yes.
Now, what gives me strength is the judgment of the Honorable Supreme Court in the case of Sabarwa. It's a constitution bench judgment.
Yes, R.K. Sabharwal, yes.
Yes, I know your lordship had an occasion to look into that. This is only for the limited purpose to reinforce that appointment to a post which is meant for a particular category as per the roster can under no circumstance be filled by anybody else. This provided for carry forward if at all you wanted. They could have carried forward this vacancy.
Yes.
Which they did not do. For them, the administrative reason is, since there was there was no candidate eligible then for the purpose of filling up the post, we have filled it up with a general merit candidate. That is what bothering me, because I am entitled except for the fact, it's a fortuitous fact that some order of the Social Welfare Department annulled my appointment, which was set aside by this honorable court. The probation was not declared because of that. And when it was declared, it was subject to the result of the writ petition that was pending. After the writ petition was disposed of in my favor, the Secretariat passes an order saying that that condition subject to which your probation was declared has been removed. So your appointment is regularized from the date of my appointment. Now, what was bothering them? I was eligible to be considered in accordance with the rules of recruitment. I had put in 5 years of service on the date when the vacancy arose, and the DPs met for consideration of cases. If I was otherwise eligible, and moreover, when you decided to give me the date of eligibility as 13/9/2010, I am entitled to be counted as senior to in my promotion post because of the amendment brought to this act, to be in tune with Article 16(4)A as amended by the 85th Amendment. Therefore, my lord, I am entitled to be treated as senior to respondent 2 to 6, because the vacancy in 27th roster
Correct.
point.
Now that the date of eligibility is declared, date of eligibility to the post of assistant,
No, senior assistant.
senior assistant is declared.
Declared.
Which means to say, for all future promotions, this date will be the date.
Not only for consider my case of promotion, but also for seniority.
Seniority and even for promotion or for fixation, whatever.
Yes.
This will be the eligible date.
Yes. No, why I am saying that? Because the promotion of second respondent and third respondent is not by the same order on the same date. You have ignored my claims.
Now, between the petitioner and the other respondents.
Yes.
What was the seniority? Who was senior?
In the lower cadre, they were seniors, no doubt.
So if they're seniors in the lower cadre,
Yes.
how can you be fixed above them in the promotion post?
That's what. That's by what the amendment. to the Act.
Please read Article 16(4)A.
Yes. See, I can't be coming to court and asking for.
Yeah.
No, I'm just telling my colleague.
ಪರವಾಗಿಲ್ಲ ತಗೊಳ್ಳಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಕೊಡ್ರಿ, ಇನ್ನೊಂದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇದ್ರೆ ಕೊಡ್ರಿ.
Lord, Article 16(4)A, as amended, enables the state government to provide for consequential seniority.
Yes.
So they have provided by
That is between persons belonging to the same caste.
not caste.
4A ಓದಿ.
No.
ಓದಿ.
Yes, sir. Now, Lordship, may kindly read the act for a minute.
Yes. Just read Rule 3, Section 3.
Yes.
Good.
Notwithstanding anything contained in any other law for time being in force, the government servants belonging to the scheduled castes and scheduled tribes promoted in accordance with the policy of reservation in promotion provided for in the reservation order shall be entitled to consequential seniority.
Yes.
Seniority shall be determined on the basis of the length of service in a cadre. Provided that, this proviso is important, provided that the inter-se seniority, the seniority inter-se of the government servants belonging to scheduled castes and scheduled tribes, as well as those belonging to the unreserved category, promoted to a cadre at the same time by a common order.
Yes.
Shall be determined on the basis of the inter-se, seniority inter-se in the lower cadre.
ಏನಂಗಂದ್ರೆ ಅರ್ಥ?
ಅಂದ್ರೆ ಈಗ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್, ನಾನು third respondent, fourth respondent, fifth respondent, we were all promoted at the same time.
Yes.
By virtue of the same common order. Then the inter-se seniority as was maintained in the lower cadre shall rule the roost in the higher cadre.
Yes.
But where a promotion is given to me out of turn, the first portion of Section 3 comes to my Section 4 also, one ನಿಮಿಷ ಓದಿ.
ಇನ್ನೊಂದ್ಸತಿ ಓದಿ, proviso ಓದಿ.
Proviso. Provided that the inter se seniority of the government servants belonging to scheduled castes and scheduled tribes, as well as those belonging to unreserved category, promoted to a cadre at the same time by a common order. ಈಗ 4 ಜನ ನಾವು ಪ್ರಮೋಟ್ ಆಗಿದ್ರೆ ಅದರಲ್ಲಿ 27th vacancy also which fell for my in my favor was also filled by promoting me. I will go with them in the same order in which we were arranged in the lower cadre. But where it is not so, this is to protect my seniority, this amendment was brought.
Yes.
That is to be tuned, my lord, that is, this amendment was effected to go to the constitution to overcome what the Honorable Supreme Court has said in Indra Shawnee's case. That's what the Supreme Court has held in Nagaraj's case. That amendment has been upheld. Now, this amendment is by virtue of the power conferred on the state government by Article 16(4)(a) as amended by 82nd Amendment.
Yes.
ಇಲ್ವಾ? ಅವನಿಗೆ 16(4) ಓದಿ ಅಂತ ಹೇಳಿದೆ.
The catch-up rule, has the Supreme Court considered the effect of catch-up rule in the light of the 2002 rules?
Catch-up rules, which was first, my lord, enunciated in the case of Ajit Singh, 1 and 2. All these judgments were considered by Supreme Court in Nagaraj's case. The Constitution bench says, to overcome various defects pointed out in the law, the amendments were brought. In fact, Article 16(4)(a), 77th Amendment was brought to overcome the judgment of these series of judgments, starting from Vipul Singh, ending with Ajit Singh 2. They were all considered. They were all the cases where there was no provision of law, as in the case of Amendment Act. Now, Amendment Act provides for counting the consequential seniority. By virtue of this amendment, I am entitled to claim that I am senior to them in my promoted cadre.
No, but the anomaly would be, for
Yes.
example, if A, B, and C are in the same cadre.
Yes.
A, B, and C are in the same cadre. A, B has entered earlier. The date of entry into service is earlier. C has entered subsequently. Because C belongs to scheduled caste, he gets a promotion earlier than A and B. C will get a promotion because he belongs to scheduled caste. Now, when A and B gets promotion, should they not be fixed above C so that the seniority in the lower cadre is maintained?
That's what all the three judgments, starting from Vipul Kumar, followed by Badapanavar, Ajit 1, Ajit 2, they said. However, pursuant to the law laid down by Supreme Court, the Parliament was compelled to amend Article 16(4)(a).
Yes.
By virtue of the amendment, the state government gets the power to give the benefit of consequential seniority to such of those candidates of scheduled caste and scheduled tribe who get promoted out of turn because of the roster. I don't know the trouble, your lordship, reading all those judgments. Nagaraj's case is an answer to the question whether the people who were seniors to me in the lower cadre when they get promoted subsequent to the reserved candidate, will take the seniority with them and be treated as my senior. So Nagaraj's case has dealt with that issue. Now, Pavitra case, first case, they stuck down the 2002 Act because there was no study, there was no material available before the state government with regard to adequacy of representation. Then Pavitra said, since there is no such this thing, this act cannot be upheld. They stuck down that act. That led to state government appointing a committee of the additional chief secretary, Ratna Prabha. She gave a report, which was
representation.
Yes. That's what the preamble to this act, Miller. If your lordship sees for the first page of the act, Act 21 of 2018, Statement of Objection and Reasons. May I read it?
No, I don't know whether in the Nagaraja's case, the catch-up rule was held to be.
They said they are the concepts arising out of service jurisprudence. They cannot affect the amending power of the parliament. Therefore, they said it is always open to the state government to make such law so as to give consequential seniority to the candidates who are promoted out of turn.
Yes.
So therefore, the state in excess of that power, traceable to Article 16(4)(a), amended the act, giving me the benefit of consequential seniority. Catch-up rule and consequential seniority are the concepts of service jurisprudence, is what Nagaraja's case said.
Yes.
I'll just read to your lordship. That was considered and accepted by Jarnail Singh's case subsequently when Nagaraja's case fell for review, because it was running counter to what the larger bench of the Supreme Court in Indra Shawne's case had said, as far as the creamy layer and others.
Yes.
But when Nagaraja's case has not been reversed.
It is not reversed.
It is not reversed. It has been held to be not a good law only in one particular aspect. But that is with regard to creamy layer and the material that is to be considered and the unit for the purpose of reservation. Pavitra Kuda, secondly, my lord, that's a Pavitra judgment, Pavitra 2 is a division bench judgment of 2 judges. That fell for consideration in Jarnail Singh's case. Second, number 2. So, one copy, na? Yes. Now, if your lordship takes para 634 of that report.
Para
630, 633.
Of which judgment?
This is Jarnail Singh. Jarnail Singh 2.
634 paragraph ilvalla illi.
Page number. 634 page number.
Yes.
Para 63, the Karnataka legislature enacted the Karnataka determination of seniority of the government servant promoted on the basis of reservation to post in so and so, Act 2002. This court declared the provisions of said act as unconstitutional on the ground that the government of Karnataka failed to produce quantifiable data to show any compelling necessity for exercising power under Article 16(4)(a). And therefore, sections 3 and 4 of the said act were held to be unconstitutional. That is Pavitra 1. Thereafter, the government of Karnataka constituted a committee headed by the additional chief secretary to state of Karnataka and entrusted the following task to the committee. Collect information in the cadre-wise representation of SCs and STs in all the government departments. Collect information regarding backwardness of SCs and STs. Study the effect on the administration due to provision of reservation and promotion to SCs and STs. This because, my lord, they had to keep up with Article 335 of the Constitution, where efficiency of service should be always maintained. So in order to strike a balance between reservation, general candidates' interest, and the efficiency of service, this was done. On 5/5/2017, the report on backwardness, inadequacy of representation, and administrative efficiency in Karnataka was submitted by the Ratna Prabha committee. The government of Karnataka accepted the report, and the Karnataka extension of consequential seniority to government servants promoted on the basis of reservation to the post in civil services in the State Bill 2017 was passed by the Legislative Assembly and the Legislative Council, and thereafter received presidential assent on 14/6/2018. The grievance of the petitioner therein was that the data was collected only from 31 departments out of the total 62 based on Group A, B, C, and D and not on CADA. A further complaint was made that no data was collected with respect to public sector undertakings, boards, corporations, local bodies, granting aid institutions, and autonomous bodies, and therefore the data is only representative in nature. This court in BK Pavitra, that is number 2, reproduced so and so, a summary of the report of Ratna Prabha committee report, which is as follows. Not for our purpose, we may skip that. Lordship may come to para 66. Para 66. This court in BK Pavitra found the challenge to the report on the ground of data having been collected on the basis of Group A, B, C, and D as opposed to CADAs to be without merit. The basis of the said conclusion of the court was that there is no fixed meaning ascribed to the term CADA in service jurisprudence. Further, this court held that collection of quantifiable data on the inadequacy of representation is in the services of the state, according to M. Nagaraja. In addition, this court was also of the view that Article 16(4)(a) referred to inadequacy of representation in the service of the state. It was further declared that collection of data on the basis of groups does not exclude data pertaining to CADA, as a group includes posts in all the CADA in that group. Collection of quantifiable data for determining the inadequacy of representation of SCs and STs is a basic requirement for providing reservation in promotions as laid down by court in M. Nagaraja. The unit for the purpose of collection of data is CADA according to M. Nagaraj and Jarnail Singh.
Yes.
For the purpose, this Jarnail Singh is Jarnail Singh number 1, the Constitution Bench judgment.
Yes.
For the purpose of collection of quantifiable data for providing reservation in promotions, the entire service cannot be taken to be a unit and treated as a CADA, as already stated. The structure of service in the state of Karnataka is along the same lines as that of services central government. Services are divided into groups which are further bifurcated to CADAs. There is no confusion that a CADA is not synonymous with a group. The first term of reference of the Ratna Prabha committee was to collect data CADA-wise. The conclusion of this court in BK Pavitra 2, that the expression CADA has no fixed meaning in service jurisprudence is contrary to the judgment of this court, which have been referred to above while answering point number 2. In clear terms, M. Nagaraj held that the unit for collection of quantifiable data is CADA and not services, as has been held in BK Pavitra. Article 16(4)(a) of the Constitution enables the state to make reservations in promotion for SC and STs, which are not adequately represented in the service of state. However, the provision for reservation matters of promotion with reference to class or classes of post in the services under the state. That groups consist of CADA is a fact which was taken into consideration by this court in BK Pavitra. The conclusion that the collection of data on the basis of groups is valid is contrary to the decision of this court in Nagaraja and Jarnail Singh.
Yes.
The state should justify reservation in promotion with respect to CADA to which promotion is made, taking into account the data pertaining to a group which would be an amalgamation of certain CADAs in a state, in a service, would not give the correct picture of the inadequacy of representation of SCs and STs in the CADA, in relation to which reservation in promotion is sought to be made. Rosters are prepared CADA-wise and not group-wise. Sampling method which was adopted by Ratna Prabha committee might be a statistical formula appropriate for collection of data. However, for the purpose of collection of quantifiable data to assess representation of SCs, STs, for the purpose of providing reservation in promotion, CADA, which is a part of group, is the unit, and the data has to be collected with respect to each CADA. Therefore, we hold that conclusion of this court in BK Pavitra applying the collection of data on the base of groups and not CADAs is contrary to the law laid down by this court in M. Nagaraj and Jarnail Singh. This portion of Pavitra 2 was found fault with by the larger bench of the Supreme Court.
Yes.
But amendment to the act which Pavitra 2 upheld never fell for consideration in this case. As of today, my lord, in my humble submission, the act holds the field. Therefore, reliance upon Rule 4 and 4A of the seniority rules is of no consequence, inasmuch as I'm entitled to the benefit of consequential seniority. And catch-up rule has been diluted by this amendment. But up in our case, which was
No, but up in our case is not diluted is my belief. It is not diluted is my belief.
I will read that portion, my lord, in Nagaraja's case. Putidira. Putilva. Yes. Lordship found it. Para 73, my lords. Beda, para 68. Para 68, my lord, on page number 254 of SEC, which is a copy of which is given to your lordships.
69.
Para 68 ಅಲ್ಲಿ ಸಬರ್ವಾಲ್ದು ಹೇಳ್ತಾರೆ. If lordship desires that I need not read that.
68 deals with Article 16(4)(b).
True. That is for catching carry forward. Carry forward. 69. One of the contentions advanced on behalf of the petitioners is that the impugned amendments, particularly Constitution 77th Amendment and 85th Amendment Acts, obliterate all constitutional limitations on the amending power of Parliament. Lord, principally, what fell for consideration is the power of the Parliament to amend the Constitution. However, what the Supreme Court has observed here, that the width of these impugned amendment is so wide that it violates the basic structure of equality enshrined in the Constitution. The key issue which arises for determination is whether the above catch-up rule and concept of consequential seniority are constitutional requirements of Article 16 and of equality, so as to be beyond the constitutional amendatory process. In other words, whether obliteration of the catch-up rule or insertion of concept of consequential seniority code would violate the basic structure of the equality code enshrined in Articles 14, 15, and 16. The concept of catch-up rule appears for the first time in Virpal Singh Chauhan. In the category of guards in the railways, there were 4 categories, namely grade C, B, grade A special. The initial recruitment was made to grade C. Promotion from one grade to another was by seniority cum suitability. The rule of reservation was applied not only at the initial stage of appointment to guard grade C, but at every stage of promotion. The percentage reserved for SCs was 15%, and for STs it was 7.5%. To give effect to the rule of reservation, a 40-point roster was prepared in which certain points were reserved for SCs and STs respectively. Subsequently, a 100-point roster was prepared reflecting the same percentages. In 1986, general candidates and members of scheduled caste and scheduled tribe came within grade A in Northern Railway. On 1/8/86, the chief controller promoted certain general candidates on ad hoc basis to grade A special. Within 3 months, they were reverted and SCs and STs were promoted. This action was challenged by general candidates as arbitrary and unconstitutional before the tribunal. The general candidates asked for 3 reliefs, namely to restrain the railways from filling up the posts in higher grades in the category of guards by applying the rule of reservation. 2, to restrain the railways from acting upon the seniority list prepared by them, and C, to declare that the general candidates were alone entitled to be promoted and conferred in grade A, special on the strength of their seniority earlier to the reserved category employees. The contention of the general candidate was that once quota prescribed for the reserved group is satisfied, the 40-point roster cannot be applied because that roster was prepared to give effect to rule of reservation. It was contended by the general candidate that accelerated promotion may be given, but the railways cannot give consequential seniority to reserve category candidates in the promoted category. In this connection, the general category candidates relied upon decision of the Allahabad and Madhya Pradesh High Court. It was contended by the general candidate that giving consequential seniority in addition to accelerated promotion constituted conferment of double benefit upon the members of the reserved category and therefore violated the rule of equality in Article 16(1). It was further urged that accelerated promotion cum accelerated seniority is destructive of the efficiency of administration, in as much as by this means the higher echelons of administration would be occupied entirely by members of reserved category. This was opposed by the reserved category candidates, who submitted that for purposes of promotion to grade A special, the seniority list pertaining to grade A alone should be followed, and that administration should not follow the seniority list maintained by the administration pertaining to grade C as urged by the general candidates. And since the SCs and STs was senior to general candidates in grade A, the seniority in grade A alone should apply. In short, the general candidates relied upon the catch-up rule, which was opposed by the members of SCs and STs. They also relied upon judgment of this court in R.K. Sabarwa. This court gave the following reasons for upholding the decision of the tribunal. Firstly, it was held that a rule of reservation as such does not violate Article 16.4. Secondly, this rule opined that there is no uniform method of providing reservation. The extent and nature of reservation is a matter for the state to decide, having regard to the facts and circumstances of each case. It is open to the state, if so advised, to say that while the rule of reservation shall be applied, the candidate promoted earlier by virtue of reservation or roster shall not be entitled to
Seniority over
seniority over seniors in the feeder category, and that it is open to state to interpret the catch-up rule in the service conditions governing the promotions. Thirdly, this court did not agree with the view expressed by the tribunal that a harmonious reading of clauses 1 to 4 of Article 16 should mean that reserved category candidate promoted earlier than his senior general category candidates in the feeder grade shall necessarily be junior in the promoted category to such general category. This court categorically ruled with a para so-and-so that such catch-up rule principle cannot be said to be implicit in clauses 1 to 4 of Article 16. Lastly, this court found on facts that for 11 vacancies, 33 candidates were considered, and they were all SCs and ST candidates. Not a single candidate belonged to general category. It was argued on behalf of general candidates that all top grades stood occupied exclusively by the reserved category members, which violated the rule of equality underlying Article 16.1, 16.4, and 14. This court opined that the above situation arose on account of faulty implementation of the rule of reservation, as the railways did not observe the principle that reservation must be in relation to posts and not vacancies, and also for applying the roster even after the attainment of the requisite percentage reserved for SCs and STs. In other words, this court based on its decision only on the faulty implementation of the rule by the railways, which the court ordered to be rectified. The point which we need to emphasize is that court has categorically ruled in Virpal Singh Chauhan that catch-up rule is not implicit in Article 1 to 4 of Article 16. Hence, the said rule cannot bind the amending power of the Parliament. It is not beyond the amending power of the Parliament. In Ajit Singh 1, the controversy which arose for determination was whether after the members of SCs and STs for whom specific percentage of posts stood reserved having been promoted against these posts, was it open to the administration to grant consequential seniority against general category posts in higher grade. The appellant took a clear stand that he had no objection if members of SCs or STs get accelerated promotions. The appellant objected only to grant of consequential seniority. Relying on the circulars issued by the administration dated 19/7/1969 and 8/9/1969, the High Court held that the members of SCs and STs can be promoted against general category posts on the basis of seniority. This was challenged in appeal before this court. The High Court ruling was set aside by this court on the ground that if the catch-up rule is not applied, then the equality principle embodied in Article 16.1 would stand violated. This court observed that catch-up rule was a process adopted while making appointments through direct recruitment or promotion because merit cannot be ignored. This court held that for attracting meritorious candidates, a balance has to be struck while making provisions for reservation. It was held that the promotion is an incident of service. It was observed that seniority is one of the important factors in making promotion. It was held that the right to equality is to be preserved by preventing reverse discrimination. Further, it was held that equality principle requires exclusion of extra weightage of roster point promotion to a reserved category candidate. This court opined that without catch-up rule, giving weightage to an earlier promotion secured by roster point promotee would result in reverse discrimination and would violate Article equality under Articles 14, 15, and 16. Accordingly, this court took the view that seniority between the reserved category candidates and general candidates in the promoted category shall be governed by their panel position. Therefore, this court set aside this factor of extra weightage of earlier promotion to a reserved category candidate as violative of Article 14 and 16(1) of the Constitution. Therefore, in Virpal Singh Chauhan, this court has said that the catch-up rule insisted upon by the railways, though not implicit in Article 16(1) and 16(4), is constitutionally valid as the said practice process was made to maintain efficiency. On the other hand, in Ajit Singh 1, this court has held that the equality principle excludes the extra weightage given by the government to roster point promotees. As such, weightage is against merit and efficiency of the administration, and that the Punjab government had erred in not taking into account the said merit and efficiency factors. In Ajit Singh 2, 3 interlocutory applications were filed by the state of Punjab for clarification of the judgment of this court in Ajit Singh 1. The limited question was whether there was any conflict between judgments of this court in Virpal Singh Chauhan and Ajit Singh 1. On the one hand, vis-a-vis the judgment of this court in Jagdish Lal versus State of Haryana. The former cases were decided in favor of general candidates, whereas the latter was a decision against the general candidates. Briefly, the facts for moving the interlocutory applications were as follows. The Indian Railways, following the law laid down in Virpal Singh Chauhan, issued a circular on 28/2/1997 to the effect that the reserved candidates promoted on roster points could not claim seniority over the senior general candidates promoted later on. The state of Punjab, after following Ajit Singh 1, revised their seniority list and made further promotions of the senior general candidates following the catch-up rule. Therefore, both the judgments were against the reserved candidates. However, in the later judgment of this court, in Jagdish Lal, another 3-judge bench took the view that under the general rule of service, jurisprudence relating to seniority, the date of continuous officiation has to be taken into account. And if so, the roster point promotees were entitled to the benefit of continuous officiation. In Jagdish Lal, the bench observed that the right to promotion was a statutory right, while the rights of the reserved candidates in Article 16(4) and Article 16(4)(a) were fundamental rights of the reserved candidates, and therefore the reserved candidates were entitled to the benefit of continuous officiation. Accordingly, in Ajit Singh 2, 3 points arose for consideration. Can the roster point promotees count their seniority in the promoted category from the date of their continuous officiation vis-a-vis general candidates who were senior to them in the lower category and who were later promoted to the same level? Have Virpal and Ajit Singh 1 been correctly decided, and has Jagdish Lal been correctly decided? Whether the catch-up rule principle are tenable. At the outset, the court stated that it was not concerned with the validity of constitutional amendment, and therefore it proceeded on the assumption that Article 16(4)(a) is valid and not unconstitutional. Basically, the question decided was whether the catch-up principle was tenable in the extent of Article 16(4). It was held that the primary purpose of Article 16(4) and Article 16(4)(a) is to give due representation to certain classes in certain posts, keeping in mind Article 14, 16(1) and 335. That Articles 14 and 16(1) have prescribed permissive limits to affirmative action by way of reservation under Article 16(4) and 16(4)(a) of the Constitution. That Article 335 incorporated so that efficiency of administration is not jeopardized, and that Articles 14 and 16(1) are closely connected as they deal with the individual rights of the persons. They give positive command to the state that there shall be equality of opportunity to all citizens in public employment. It was further held that Article 61(1) flows from Article 14. It was held that word employment Article 16 is wide enough to include promotions to post at the stage of initial level of recruitment. It was observed that Article 16(1) provides to every employee otherwise eligible for promotion fundamental right to be considered for promotion. It was held that equal opportunity means the right to be considered for promotion. The right to be considered for promotion was not a statutory right. It was held that Article 16(4) and 16(4)(a) did not confer any fundamental right to reservation, that they are only enabling provisions. Accordingly, in Ajit Singh 2, the judgment of this court in Jagdish Lal was overruled. However, in the context of candidates under Article 16(4) and 16(4)(a), this court opined that Article 16(1) deals with a fundamental right, whereas 16(4)(a) and 16(4) and 16(4)(a) are only enabling provisions, and therefore the interests of the reserved classes must be balanced against interest of other segments of society. as a remedial measure, the court held that in matters relating to affirmative action by the state, the rights under Article 14 and 16 are required to be protected, and a reasonable balance should be struck so that affirmative action by the state does not lead to reverse discrimination. Reading the above judgments, we are of the view that the concept of catch-up rule and consequential seniority are judicially evolved concepts to control the extent of reservation. The source of this concept is in service jurisprudence. These concepts cannot be elevated to the status of an axiom like secularism, constitutional sovereignty, etc. It cannot be said that by insertion of the concept of consequential seniority, the structure of Article 16(1) stands destroyed or abrogated. It cannot be said that equality code under Article 14, 15, and 16 is violated by deletion of the catch-up rule. These concepts are based on practices. However, such practices cannot be elevated to the status of a constitutional principle so as to be beyond the amending power of Parliament. Principles of service jurisprudence are different from constitutional limitations. Therefore, in our view, neither the catch-up rule nor the concept of consequential seniority is implicit in clauses 1 and 4 of Article 16 as correctly held in Virpal Singh Chauhan. Before concluding, we may refer to the judgment of this court in M.G. Badappanawar. Lord, this is one. In that case, the facts were as follows. The appellants were General Lord, Your Lordship desires that I
read that.
My Lord is very fast.
I have read that.
Maybe Lordship had read it in some other connection.
I have read. I've already made marks.
Then I don't want. It will be like carrying coal to
Badappanawar catch-up rule with regard to
No, all this led to amendments to the Constitution. So, in view of the amendment to the Constitution, yes.
No, Badappanawar led to the amendment. What you say is right. But Nagaraja case, Supreme Court did not consider the effect of catch-up rule. It did not say that the law declared in Badappanawar is not correct law.
No, they did not say that. I'm only saying it stands diluted for the simple reason. In Badappanawar case, the provision of the act that of the kind that I'm now referring to was not available.
Yes.
For interpretation or for consideration.
Yes.
Kindly see para 81 minutes.
Yes.
81.
Yes.
Adu mele 80 paranally last 4 lines.
Yes.
This is the only judgment of this court delivered by a 3-judge bench, saying that if roster point promotees are given the benefit of consequential seniority, it will result in violation of equality principle, which is a part of the basic structure of the Constitution. Accordingly, the judgment of the tribunal was set aside.
Yes.
The judgment of Karnataka Administrative Tribunal was set aside. The judgment in M.G. Badappanawar was mainly based on the judgment in Ajit Singh 1, which had taken the view that departmental circular which gave consequential seniority to roster point promotee violated Article 14 and 16 of the Constitution. In none of the above cases was the question of the validity of the constitutional amendments involved. Ajit Singh 1, Ajit Singh 2, M.G. Badappanawar were essentially concerned with the question of weightage, whether weightage of earlier accelerated promotion with consequential seniority should be given or not. To be given are matters which would fall within the discretion of the appropriate government, keeping in mind the backwardness, inadequacy, and representation in public employment and overall efficiency of services. The above judgment, therefore, did not touch the question.
Correct. It did not touch the question of catch-up rule. What the court says is,
no, the above
16(4)(a), Article 16(4)(a), there should be concept of backwardness. Assessment of backwardness in the promotion pool, whatever. So as to give benefit of promotions to the reserved categories. That was the purpose. But the catch-up rule really did not come for consideration. It was not even disturbed in this M. Nagaraja.
To catch-up rule, the Nagaraja League, what the law laid down by these 3 judgments, Ajit Singh 1, Virpal Singh, Ajit Singh 1, Ajit Singh 2, and Badappanawar considered.
Yes.
They said, what they say is, my lord, at the risk of repetition, my lord, I'll read it once again. Whether weightage of earlier accelerated promotion with consequential seniority should be given or not to be given, are matters which would fall within the discretion of the appropriate government,
Yes.
keeping in mind the backwardness, inadequacy, and representation in public employment and overall efficiency of services. Now, keeping in mind these factors, the government thought it fit to amend the Act
Yes.
and brought in these provisions, Section 3, 4, and 5, which fell for consideration before the Supreme Court in Pavitra 2. Earlier, 2002 Act fell for consideration before Pavitra 1. On that being struck down, my lord, because there was no adequate report or sufficient data, then that led to the appointment of committee by the government. On taking this report, Act was amended. That is the Act of 2018, which I just read out to your lordship.
Yes.
By virtue of that, the catch-up rule, my lord, may not be of much significance now, because under this particular provision of the Act as amended, which has been upheld by the Pavitra's case, I am entitled to count my seniority in the promotional card. These are my humble submissions.
16.4A has to be complied. Is there any data for compliance of Article 16.4A?
That's why that is committee's report.
Correct? Committee's report is so far as this post is concerned.
I will read that statement of object itself. Lordship may kindly see. The Act.
Yes.
On second page of that booklet which I passed on.
Yes.
Page 2. The government of Karnataka has, second paragraph of the page. The government of Karnataka has enacted the Karnataka determination of seniority of the government servants promoted on the basis of reservation to the post in civil services of the state, Act 2002, Karnataka Act 10 of 22, hereinafter referred to as Karnataka Act 10, to remove any ambiguity and to clarify that the government servants belonging to scheduled castes and the scheduled tribes promoted in accordance with the policy of reservation in promotion contained in the reservation order shall be entitled to seniority as it is available to government servants belonging to other categories. The validity of Karnataka Act 10 of 22 and constitutional amendments to Article 16.4A and 4B came to be challenged in Supreme Court in C.M. Nagaraja and others in WP number so-and-so. The Honorable Supreme Court in the said case upheld the constitutional validity of Article 16.4A and 16.4B and held that the validity of the individual enactments of the appropriate states shall be gone into in individual petitions by the appropriate bench. In turn, having been remitted, the High Court of Karnataka in WP number so-and-so has examined the constitutional validity of Karnataka Act 10 of 2002 and declared that the same was a valid piece of legislation as he satisfied the test specified by Supreme Court in Nagaraja's case. The correctness of the above view taken by the High Court of Karnataka was then assailed in appeal before the Supreme Court in Pavitra case, BK Pavitra case. The Honorable Supreme Court of India in its judgment dated 9/2/2017 in the case of BK Pavitra and others of Union of India and others in civil appeal number so-and-so and connected matters while dealing with the issues of consequential seniority provided to the scheduled castes and scheduled tribes, having regard to the ratio of the decision of the Constitution Bench in Nagaraj in WP number so-and-so has observed that a proper exercise for determining inadequacy of representation, backwardness, and overall efficiency is a must exercise of power under Article 16.4A. The court held that in the absence of this exercise under Article 16.4A, it is the catch-up rule that shall be applicable. Having observed this, the court declared the provisions of Section 3 and 4 of the Act of 10 of 22 to be ultra-virus of Article 14 and 16 of the Constitution. The Honorable Supreme Court directed that revision of the seniority list be undertaken and completed within 3 months and further consequential action be taken within the next 3 months. In order to comply with the directions of the Honorable Supreme Court in BK Pavitra and others, was Union of India and others, in civil appeal number so-and-so, the government has issued order vide government order dated so-and-so to all appointing authorities to revise the seniority list. While in compliance of the Supreme Court order, the government considering the need and taking note of decision of the Constitution Bench in M. Nagaraj in writ petition number so-and-so has entrusted the task of conducting study and submitting a report on the backwardness of scheduled castes and scheduled tribes in the state, inadequacy of the representation in the state civil services, and the effect of reservation in promotion on the state administration to the Additional Chief Secretary so-and-so in government order dated 22/3/2017. Additional Chief Secretary to Government, with assistance of officers from various departments, has collated the scientific, quantifiable, and relevant data collected, and having made detailed study of quantifiable data, has submitted a report on the backwardness of the scheduled castes and scheduled tribes in the state, inadequacy of their representation in the state civil services, and the effect of reservation promotion on the state administration to the state government. The report confirms the backwardness of scheduled castes and scheduled tribes in the state, inadequacy of the representation in the state civil services, and that the overall efficiency of administration has not been affected or hampered by extending reservation in promotion to the scheduled castes and scheduled tribes in the state, and continuance of reservation in promotion within the limits will not affect or hamper overall efficiency of administration. The government of Karnataka has also obtained the views of legal experts and Karnataka Law Commission in this regard, and having examined the report submitted by the Additional Chief Secretary and views expressed by the legal experts, the government of Karnataka has accepted the report. Keeping in view the finding of the report, the government is satisfied and having identified and measured, has come to the conclusion that compelling reasons continue to exist for providing consequential seniority to the persons promoted on the basis of policy of reservation in the state since 1978, so as to ensure adequate representation of the scheduled castes and scheduled tribes across all departments. Hence, bill. Note that led to the enactment of 2018.
Yes.
Lord, that came into effect with effect from 17/6/1995. So I stand covered on all fours by section 3 and 4. Therefore, my humble submission is
Consequential seniority. Yes.
seniority. Lord, I understand one second. Lord, as your lordships have seen in Annexure K, they are referring to section 4 of the PPP Act. PPP rules also may kindly be seen.
What is it? Yes.
Lordship found PPP rules, my lord. They are called the Karnataka State Civil Services Regulation of Promotional Pay and Pension Rules of 1978. It told. What was?
ಇದೆ
ಅಲ್ಲ, ಎರಡೇ line ಇದೆ.
ಇದೆ. I have it. Yes.
Lord, these rules are also applicable by virtue of the adoption made in the recruitment rules of the Secretariat. Promotion of Rule 2. Promotion of a civil servant may be made with effect from a retrospective date. If his claim for promotion was withheld on account of dismissal proceedings or criminal prosecution of both pending against him, and he is exonerated or acquitted subsequently, that though it is not the case in my case. I was not considered, though I was eligible to be considered, because of the case that I had instituted. It is not that I was facing any inquiry. And in spite of the fact that my probation was declared only subsequent to the disposal of my writ petition by this honorable court,
Yes.
I was given the benefit of date of eligibility. That is relatable to date of occurrence of vacancy.
Yes.
And that vacancy occurred at point number 27, the roster point. Therefore, I was entitled to be considered, even if it's treated as a retrospective promotion, which was not given to me on account of pendency of my own case. But Lord, I cannot be suited out on this ground.
Yes.
Then section 4 they rely upon of the act.
That you argue.
Yes. No, I'm just
ಯಾವುದು 2002 Act.
18 Act, 17 Act. No, 2002 Act has been struck down by Supreme Court.
2002 Act, 18 Act.
18 Act, please, my lords.
Hmm.
Lords, kindly see section 3, my lords.
Yes.
Notwithstanding anything contained in any other law for the time being in force, the government servants belonging to scheduled caste
You're
and scheduled.
reading where? Section 3 or section 2?
Section 3, my lords. 3. Notwithstanding anything contained in any other law for the time being in force, the government servants belong to scheduled castes and scheduled tribes, promoted in accordance with the policy of the reservation in promotion provided for in the reservation order, shall be entitled to consequential seniority. Full stop. Kindly see note. Seniority shall be determined on the basis of the length of service in a cadre. Now, kindly see the proviso. Provided that seniority inter se of the government servants belong to the scheduled caste and scheduled tribes, as well as those belonging to the unreserved category, promoted to a cadre at the same time by a common order, shall be determined on the basis of the inter se seniority in the lower cadre. So on the facts of this case, my lords, all three were given the same date. So therefore, my lords, I had relied upon that other government order, my lords, which provided, my lords, for the seniority in the lower cadre. Same provision. Now kindly see, my lords, the next other proviso, the third last proviso, my lord, just above section 4.
Yes.
Provided also that the serial number of the roster points specified in the reservation order are intended only to facilitate calculation of the number of vacancy reserved for promotion at a time, and such roster points are not intended to determine inter se seniority of the government servants belong to the scheduled caste and the scheduled tribes vis-a-vis the government servants belong to the unreserved category promoted at the same time. Again, same time, lords. And such inter se seniority shall be determined by their seniority inter se in the cadre from which they are promoted, as illustrated in the schedule appended to this act. Kindly see the schedule. They have given an illustration. Lord, schedule alli, if 3 vacancies of assistant commissioner are to be filled by promotion at the same time by a common order, classification of vacancies would be as follows. First roster point is SC, second is ST, third is unreserved. If seniority of persons in the cadre of Tahsildars who are eligible and qualified in these cases are to be considered at the same time is as indicated below. A is scheduled caste, B is scheduled unreserved, C scheduled tribe unreserved. Then on promotion, their inter se seniority in the cadre of assistant commissioners will be as follows. Whatever seniority was there, scheduled caste, unreserved, and scheduled tribe, not in terms of the roster points. So therefore, my lords, in my respectful submission.
So the catching up rule is still there.
No, my lords, catch up rule, my lords, qua legal concept as a service rule concept is still there. Insofar as Badapanavar is concerned. Badapanavar was a case where, my lords, promotions were on different dates. Then, my lords, if it's on different date, my lords, catch up rule will apply.
Correct.
If it is on the same date, here it's a case, he has accepted the date. Retrospective one date ಕೊಟ್ಟಿದ್ದೀವಿ. On that day, my lords, 3 promotions happened, and therefore, my lords, inter se seniority on facts, my lords. But in so far as, what the other judgment, my lord, says, Nagaraj's case says is, the dehors that legal propositions with qua the service jurisprudence with regard to catch-up rule, in terms of 14A and 14B, it does not preclude, my lords, the state governments for making a law to give consequential seniority. So therefore, this 2022, please. Only one line of reply. There is no dispute or quarrel with regard to what the rule section says. Here's a case where the dates of promotion are different.
Yes.
Date of eligibility assigned is the same. That doesn't amount, that is by way of a common order. Kindly see again, my lord, at the risk of repetition. Both provisos which my learned friend read.
Yes.
Provided that, otherwise, my lord, the very purpose of amendment to Article 16(4)A would be defeated if this argument is accepted.
Yes.
My lord, that would be a monstrous interpretation of this particular rule. Provided that the seniority inter se of government servants belonging to a scheduled caste and scheduled tribe, as well as those belonging to the unreserved category, promoted to a cadre at the same time by a common order.
Yes.
We were not promoted by the same order. What they have done is to overcome the illegality in the promotion of second respondent to a post which was not reserved for general category candidate. They say that we'll give you the same date of eligibility.
Yes.
But the promotion as such was accorded on different dates to all the 3 candidates. As regards other respondents, they come from a different stream of assistance. I may not have any grievance to make.
Yes.
But my grievance is only with regard to these 2 candidates who come from the stream of stenographers, and they were not appointed on the same day. Kindly see Annexure K, page 132. That's what they say. And proviso 2, the last proviso, for a minute, Manu.
Yes. Both.
My learned friend referred to the schedule and the examples given therein. They all apply provided we are all promoted on the same date by the same common order.
Yes,
Now notionally you are given the same date. So that is the principle is what we are saying.
yes.
ಇಲ್ಲ ಅಂದ್ರೆ
Just
clarify.
Close it, close
reply,
it.
sir.
Yes.
No, there is no gainsay to the fact that I was not promoted along with second respondent or the third respondent. And it is not a common order. Kindly see, my lord, what that I have done in Annexure K. If you give me the date of eligibility as 39/2001, that is because the date on which 27 vacancy arose.
Yes.
The date of promotion of the second respondent is different.
ಯಾವುದು?
Second respondent.
ಹೇಳಿ. ಯಾವತ್ತು ಅಂತ ಹೇಳಿ.
She was
ಶಿವರಾಮಾಚಾರಿ.
ಅಲ್ಲ, ಶಿವರಾಮಾಚಾರಿ ಅಲ್ಲ. ಮಂಜುಳಾ.
ಮಂಜುಳಾ.
She was promoted on 13th of, or with effect from 13th of September 2010. Date of promotion of second respondent.
That's the same date, 13/9/10.
39/2010 she was promoted.
Yes, that is the date.
39/2010 is the date.
No, don't create confusion, please. 39/2010 is the date on which she was promoted as against the vacancy, which is 28.
Correct.
On that day, 28 vacancy had not arisen.
Yes.
On that day, what the vacancy which arose was 27 vacancy.
Yes.
That was reserved for scheduled caste candidate. That could not have been filled up by Manjula.
Yes.
That will be in tune with Sabarwal's case. Under no circumstance you can fill it up with the general merit candidate. Now, what is the date of eligibility given to Shivaramachari, who was promoted on 28th of January 2011? I was promoted on 2/11/2011, sweet after 10 months.
Yes.
There is no common order of promotion. This is for the purpose of fixing up the date of eligibility. You consider as eligible against a post which was 28th post.
Yes, 28th ಯಾವಾಗ ಬಂತು? When was that vacancy? When did
28th, my lord, they must provide the date.
28th vacancy, when did it arise?
28th vacancy did not arise on 13th of September 2000.
When did it arise?
Subsequent to that, I do not.
ಯಾವಾಗ ಅಂತ ಹೇಳಿ. So obviously 27, if it is 39, 28th will be after that only.
ಹಾಗಾಗಿ 20, I'll just clarify. It's 27th. If it was not filled up technically, it is treated as a backlog vacancy because no other candidate is available. So therefore, my lords, on that day, if a promotion vacancy is there, 28th is the date.
That will be 39.
Avate 39. Actually, what happens is under Sabarwal says that you cannot fill it up, but you can carry it as a backlog.
Yes.
So if you fill up backlog, again representation issue barala alle. So technically, I should have considered him under backlog. But what I give him the benefit of 39 itself. And I give, my lords, everybody the benefit of 39 and a consequential seniority. That's all we have done.
No, but eligibility has nothing to do with the fact of filling the post or occurrence of a vacancy.
Yes.
Therefore, the important thing to be noticed is the date of promotion, whether they were on the same date by the common order.
No, but what he says is correct. The 39, assuming that 27th roster point was treated as a backlog vacancy. Then the 28th roster promotion also arose on that day itself. 27th roster point was not filled.
Yes.
It was treated as a backlog vacancy. Then 28th roster point, it was a vacancy arose on that same day because 27 was not filled. 28th became vacant.
28th did not arise at all on.
We do not know.
No, that's what I mean, Lord. If they say that 27th was treated as a backlog vacancy and it was filled up subsequently by considering my case, Lord, I may not have any case. But my case is 27th vacancy, when it arose, I was eligible to be considered.
Right. But even if you consider that as a backlog vacancy, not filled.
Yes.
Not filled. Then the 28th roster point,
yes,
which was for general merit, the vacancy arose on the same day. That is what they are saying.
We do not have any material to show that.
Firstly,
secondly,
what happens is this, my lords. It was filled up 27th, my lords, was what we did here was 27th vacancy, which was for SC, was actually filled up by the GM candidate. Subsequently, what we have done,
28th was filled by
28th was filled by GM again. Now thereafter, my lords, after he succeeded in the writ petition, because as on that day his probation was not declared, in view to give effect to that, we passed this order whereby we treated 27th as his point. But just because by giving 27th and all three persons on the same date itself will not, my lords, give him consequential seniority.
Give us the correct date when 28th roster point was filled.
Lords, 28th roster point was filled, my lords, on the next promotion.
Okay.
It was filled
Lords,
on 28
Lords,
28/1/2011.
28th roster point ಯಾವಾಗ ಬಂತು ಅಂತ ಹೇಳಿ.
28th roster point that was filled up, my lords, by respondent number 3
28/1.
will be on 28/1/2021 ಆಗುತ್ತೆ ಅವಾಗ.
So
Now,
therefore, if you apply 16(4)(a),
Please, my lords.
then the seniority of the petition has to be given prior to the seniority of the date of promotion of the respondent number 3.
Lords, respondent number 2 was promoted on a particular date. He was promoted, my lords, there was no other candidate available. It was not treated as a backlog. Now backlog treat ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಇವ್ರಿಗೆ backlog ಅಂತ ಕೊಡ್ತಾ ಇದ್ರು.
Correct.
It was not treated as
That
backlog.
was a mistake.
So, my lords, what happens is one date of promotion is considered for the date of eligibility for all three vacancies. Consequential seniority because the junior was promoted on the same day.
That is right.
Please, my lords.
Then, for the purpose of seniority, she has to be fixed above these two. For the purpose of seniority,
Please, my lords.
even if you say 39/2010,
39/2010.
the purpose of consequential seniority, she has to be treated.
No, my lords, if it is treated as a backlog vacancy, then, my lords, backlog person will not get seniority from that roster point. There is no principle of law. He will get, it was never treated.
What is the
No,
principle
therefore
of-
I have given him a benefit. ಈಗ backlog vacancy ಅಂತ ನಾನು treat ಮಾಡಿದ್ರೆ 27th then I would have kept it aside as backlog vacancy. Then when he was eligible for, or he or she was eligible for promotion, I would have considered it. Date of promotion would have been the date. Only thing is vacancy was separately set aside. But I did not treat it as a backlog vacancy. It was filled up, my lords, because no other candidate was eligible. No other candidate was eligible. It was filled by a GM candidate. Unreserved, my lords. Thereafter, the petition was treated. So therefore, I gave him the benefit of that date, eligibility date. And it has to be notionally, my lords, it is like this. On the same day, 3 people are promoted in respect of the law from a lower cadre.
28th roster point to vacancy ಯಾವಾಗ ಬಂತು, when it was filled up ಅನ್ನೋದು ಕೊಡಿ ಸ್ವಲ್ಪ.
I'll just place it on. I'll place it along with the memo.
Yes.
Government advocate will place it, please.
There is one element that Malanan friend missed. May I point it out? It is not a backward vacancy. It is not treated as a carry
It is
forward.
not treated as a backlog vacancy, yes.
Fantastic. Now, what made you give me the date of eligibility? The date of eligibility will be fixed by an employer only if he finds me eligible on a particular date. Now, if you consider that I was eligible as on 13th of September 2010, which eligibility was overlooked when you appointed the second respondent, against the post reserved for me, which is not a carry forward vacancy, not a backlog vacancy. Then when you give me the benefit of date of eligibility, I shall be deemed to have been promoted to that post on that day.
Yes.
If that is the case, then I'm entitled for the consequential seniority in terms
What
of.
I am also telling.
Yes, that's what.
But he was a probationer on that day. That should be taken.
Maybe.
I give him a benefit, but that cannot, my lords, I give him benefit to, my lords, see that it is equitatious in nature, but that cannot come back to, my lords.
Please file your written submissions.
Please, my lords.
Sometime. ಹಾಕ್ತೀನಿ.
Ready ಇದೆಯಾ?
ಇಲ್ಲ, ಅರ್ಧ ರೆಡಿ ಇದೆ. ನಾನು ಇಟ್ಕೊಳ್ಬೇಕು ಫೈಲ್ ಒಂದು ವಾರ ಟೈಮ್.
Further arguments list on ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ.
ಅಲ್ಲ, ತಾವು ರಿಸರ್ವ್ ಮಾಡ್ಬೋದು.
Will not reserve it.
ಆಲ್ ರೈಟ್.
ನೀವು ಕಂಪ್ಲೀಟ್ ಮಾಡೋವರೆಗೂ ನಾನು ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ.
1 week.
ಒಂದು ವಾರದಲ್ಲಿ ಹಾಕ್ತೀನಿ.
ಲಿಸ್ಟ್ ಒಂದು ಡೇಟ್ ಕೊಡು.
Next Monday.
17th.
17th ಬೇಡ. 19 ಆಗ್ಬೋದು.
Next ಕರೀರಿ.
17th, 18th ಇಲ್ಲ.
Last over matter, serial number 36.
My lord is giving me 19th.
Take whichever date you want.
19th.
19th.
Obliged.
ಯಾಕೆ ಯಾವತ್ತು ಬೇಕೋ ಕೊಡ್ರಿ.
Last over matter, serial number 36.
Sir. Sir.
Yes.
ಸಿಗ್ತದೆ.
Any useful information?
ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ ಸರ್, ಬರೀ ಡಿಲೇ ಮೇಲೆ ಮತ್ತೆ ನೋ ಮೆರಿಟ್ಸ್. SLP ಇದು ಸಿವಿಲ್ ಅಪೀಲು ಇದೆ. Civil appeal, 591 of 2009, my lordship. First one.
What is this question of law raised is kept open to be agitated in an appropriate case? What is this question of law? There must have been a judgment, some order. Once the appeal is admitted, SLP is admitted,
Yes, ma'am.
there can't be a one-line order. There should be an operative portion of law. There should be a, what you call,
Yes, ma'am. Online order.
civil appeal is dismissed ಅಂತ ಹೇಳಿದ್ರು.
Review appeal is dismissed.
So once a matter is admitted and treated as a civil appeal, would that be dismissed by a one-line order? Yes, sir.
Lord, when once the secretary of the central government has filed an affidavit, the base itself has gone, Lord.
Yeah.
Base ಇಲ್ಲ ಈಗ. I don't have any base at all, because it is only by pursuance of the government order issued, central government order issued. These certificates have been issued.
Correct, but then the notification itself is not there ಅಂತ ಆದ್ರೆ, then
The defense is itself is lost.
defense itself is gone.
Lost. I can't, my lord, I can't say anything more. Therefore, my lord, I want to, because if there is a, if in the absence of that, my lord, I have a case, that's all.
ಅಲ್ಲ,
That's,
of course, now that you have been appointed as a junior engineer mechanical,
yes. Yes,
and after completion of 10 years in that particular field, maybe if we take that certificate into account, what you say is right.
correct.
But ಈಗ notification ಇಲ್ಲ ಅಂದ್ರೆ ಹಿಂಗೆ.
Notification ಇಲ್ಲ ಅಂದ್ರೆ, then my lord, that second
Please you file an additional statement of objection.
Yes, ma'am.
something, my land fund should say, how that second provision, that is regarding acquiring qualification of this equivalence, at least. At
Correct,
least
notification ಇಲ್ಲ ಅಂತ statement ಅಲ್ಲಿ ಇಲ್ಲ.
ಅದನ್ನೇ,
ಅದನ್ನಾದ್ರೂ ಹಾಕಪ್ಪ.
at least for your lordships to have a bearing on it.
When will you file it?
Short accommodation, madam.
Monday. This next Monday.
Lord, same is the seal number 40. I'm sorry, I forgot to mention that. Seal number 40.
For respondent.
That is, this is in case of Karnataka Power Transfer, Power Corporation Limited. It is Karnataka.
Statement of objections.
Have you said that there is
No,
no notification?
Nothing.
No, my lords, we have filed a statement of objections, my lords, and he has the diploma holder, my lords.
Mr. The certificate is issued based on a notification of the year 1977.
Yes, my lords.
The Punjab and Haryana High Court has said that there is no such notification. Have you taken a ground in the statement of objections that there is no such notification? Did you understand what I said?
Yes, my lords.
What did you understand?
Lords, you have asked me that whether I have taken contention regarding the notification dated 26/5/1977, which was challenged in Punjab and Haryana High Court.
That is why you should keep your eyes, ears, brain, everything open.
Yes, my lords.
The certificate that they are relying upon is based on a notification of the year 1977.
Yes, my lords. Yes, they have relied on that, my lords.
Correct.
Yes, my lords.
Now, the Punjab and Haryana High Court, considering the same notification, has said that such a notification does not, it is not existent. It is fictitious.
Yes, my lords.
Have you taken a contention in your statement of objections?
No, we have not. We have not taken.
So therefore, should you not take that contention?
We'll file additional statement.
ಅದನ್ನ ನಾನು ಹೇಳ್ತೀನಿ.
My lord, just a minute, my lord. Lakshmi, kindly say, these orders came to be passed only in year 2009.
That is right.
Till then, my lord, I'm sorry to say, several persons have been appointed on that. Now, Lakshmi, kindly say, the first petitioner in this case
ಏನ್ ಮಾಡೋದು?
made an application.
Should we repeat the same mistake?
No, I'm the last person to say that. Lord, he made an application to the under the RTI to the KPSC to show under what basis these persons have been appointed. the other persons who had buffer. They have sent a reply under the RTA Act, sending the same certificate.
That is right.
Therefore, my submission, of course, my lord, I can't support, now I can't rely upon that certificate at all. Therefore, my lord, as your lordships rightly said, to strengthen this case, my lord, let them file
File an additional statement, yes, list.
and a copy may be
List on Monday.
in advance.
Number 39, P. Mahesha.
P. Mahesha.
Waiting for the first response.
Challenge the endorsement issued, rejecting the compassionate appointment, my lord, wherein they have taken the income of my family members who were residing separately, my lords. And a judgment was passed of the division bench by the other side, my lords. That judgment holds good, my lords, till today. There is no doubt, my lords, but I have one more point, my lords. Your lordships may kindly see annexure L, based on which the impugned endorsement was passed, is 20th of February 2013, my lords. But if your lordships may kindly peruse, the date of death of my father is 5/9/2012. So as on that date, this policy shouldn't have been considered.
Yes.
It is a well settled principle that the date of the death of the
What was the rules in force as on the
my lords,
date?
annexure M, my lords.
M.
Annexure K, page 30, my lords. In this, if your lordships may kindly come to page 32, there is no determination criteria. There is a vacuum.
Yes.
And hence, my lords, benefit should be given to the petitioner is all my submission is.
Please come to rule 3 of this rules. Annexure K.
Please, my lord.
Was this the rules in force at the time of death of your father?
Please, my lords, 2011. Thereafter, this circular is
Please read rule 3.
computation of total income of family as per regulation 4(1). Please, my lords. The income certificate issued by the Tahsildar so and so, my lords, they should be living separately or jointly. But if your lordships may kindly come to page 30.
Please read.
Please, my lords. The income certificate issued by the Tahsildar with regard to the total family income has to be verified to determine the financial crisis or destitution of the family. The total recurring monthly income of the family from all sources of all the persons, whether living jointly, separately or jointly, including the earnings of the other family members, even if they are working in KPTCL, e-sums or any other government department, shall be less than the income prescribed by the board from time to time. Let's here, they have not prescribed any income, alerts. The board has not prescribed any income as on the death of the petitioner's father, my lord.
In September 2011,
please, my lord.
What was the income prescribed for the by the board to consider a case for appointment on compassionate?
Lords, on from 1/1/2011 to 36/2011, the very next page, the limit was 18,953.
Yes.
My father died on 5/9/2012. So there's a vacuum wherein they have not given the determination criteria.
Yes.
That is all my submission is.
No, but they have determined the monthly income now.
They have determined based on 2013 circular.
Yes. Correct,
Even-
but 2011 takonಡ್ರು ಕೂಡ what will be the monthly income?
Lords, that they have to prescribe, my lords. They will have to prescribe.
That may kindly pass on that circular.
Told.
Second page. my lord.
Yes. Yes, madam.
Please, my lords.
Second- Third page of the circular. my lord.
Yes.
26.
18,953.
This is 2017 circular.
ಆಯ್ತಪ್ಪ ಟೇಬಲ್ ಕೊಟ್ಟಿದೆ ನೋಡಿ ಕಂಪ್ಯೂಟೇಷನ್
Every,
please.
from the beginning.
17/2011 to 31/12/2011 is 19,649. Now, what is the monthly income of this family?
Their monthly income of families, my lord, 36,043 rupees.
On what date?
As on 1/3/2013.
Should you not take the date of death of the servant?
My lord, the deceased has left behind 3 sons and wife and 2 daughters, my lord. Two sons are working in the SESCOM only.
That's okay. As on the date of death,
Yes, madam.
the income of the family, including all other members,
Yes.
should be taken.
Yes.
Now, you have taken the income in the year 2013.
No, we have issued the endorsement that's taken is 29/12/2012, which will be reflected in financial M.
Annexure
M, madam.
A,
M.
M.
Page 14.
12/10/2012. The petitioner income is 25,000 rupees.
Hmm.
And his mother income is on 10,000 rupees, 10/12 is 0. And his
Now,
brother.
please give us the date. When did this employee die?
That's 5/9/2012, my lord.
5/9/2012. What is the monthly income as on 5/9/2012?
5/9/2012, that 26,066.
No, no, monthly income.
066.
Yes.
Now, what is the income that you have arrived at?
36,040.
0.40.
36,000
043.
as on
That as on that 29/12/22.
29,
12,
29?
20.
29/12/2012.
Yes, Mr.
Lords, if you lordship may kindly peruse rule regulation 4(1)B. Recurring in monthly income from all sources of the family for the purpose of this regulation shall be computed by the head of the office or the appointing authority. One, on the basis of the last annual property return filed by the deceased board employee. And if for any reason it is not available on the basis of the certificate of income issued by a revenue officer not below the rank of Tahsildar. Here, my lords, in this imputed endorsement, they do not say that the said income is based on the last annual property return filed by the deceased employee or on the basis of the Tahsildar.
But good.
Very well.
The petitioner has challenged an endorsement dated hearing number so dated 1/3/2013, by which his application for appointment on compassionate grounds was rejected. He has also sought for writ in the nature of mandamus to consider his application for appointment on compassionate grounds. Para. The petitioner contends that his father was working as a mechanic grade 2 in the office of the respondent number 2, died while in service on 5/9/2012, leaving behind the petitioner, his mother, 2 sisters and 2 brothers. Full stop. The petitioner therefore filed an application for appointment on compassionate grounds on 10/12/2012, along with all relevant documents. He contends that as per the circular in force dated 23/9/2011 and 20/12/2013, the first respondent had fixed certain criteria for processing applications for appointment on compassionate grounds. As per the circular dated 20th of February 2013, the income limit was fixed at a sum of rupees 26,066. Full stop. The petitioner claims that in order to substantiate his family income, he had placed on record the income certificate issued by the Tahsildar concerning him and his mother, to show that the monthly income was well below the ceiling limit. Full stop. The petitioner claims that he had studied up to 9th standard and was entitled for a job, entitled for the post of a junior lineman. Full stop. He also obtained a no objection from his mother, and that she consented for granting appointment to the petitioner on compassionate basis. He contends that his 2 brothers were also employed under the respondent number 2 and were working as linemen, but were separated from the petitioner's family long back, even during the lifetime of his father. Full stop. The respondent number 4, while considering the application of the petitioner, issued a checklist of documents and recommended that the petitioner is eligible for employment and on compassionate basis. Full stop. He considered the total annual income of the petitioner's family was rupees 4,32,524, which was below the ceiling limit. Full stop. The petitioner contends that the relevant circular which was in force which dealt with the application for which dealt with the manner of consideration of applications for appointment on compassionate grounds was the one issued on 23/9/2011, in terms of which, the ceiling limit was fixed at a sum of rupees 18,593 per month. The petitioner therefore contends that the income of the petitioner was therefore below the ceiling limit fixed prescribed, and he was entitled for appointment on compassionate grounds. Full stop. The petitioner contends that the respondent number 2, without considering this, applied the ceiling limit prescribed under the notification dated 20th of February 2013 and held that the income exceeded the limit prescribed and rejected the application. Being agreed with the same, the petitioner is before this court. Next para. The learned counsel for the petitioner contended that the father of the petitioner died on 5/9/2012, and at the relevant point of time, the circular which was in force and the circular issued by the respondent number 1 relating to appointment on compassionate grounds was the one which was issued on 23/9/2011, in terms of which, the income limit was.
There was no income limit in.
No income limit.
Please, Malats. There's no income determination criteria. Page 32, Malats.
Please wait, please.
1997. Where it is quoted with circular I have given below.
Why do you say there's no income criteria?
Malats, from application which is submitted from 1/1/2011.
Correct.
I would submit it.
They have issued circulars in increasing the.
There was no circular as such, Malats. They have now given 2017 circular, wherein they have computed, that is all. There was no circular as in.
Was the one issued on 23/9/2011, which prescribed the ceiling limit for the period 1/1/2011 to 36/2011. He contends that there was no ceiling limit prescribed as on 5/9/2012 when the father of the petitioner died. Thus, he contends that the respondent number 2 must have considered the application of the petitioner without, respondent 3 must have considered the application of the petitioner without reference to any ceiling limit. Full stop. The petition is orally opposed by the respondents who contend that computation of the total income of the family was one of the criteria for determining an application for compassionate appointment. They contend that though under the circular dated 23/9/2011, no monthly ceiling limit was prescribed, for the period beyond 36/2011, the respondent number 1 had issued a circular dated 26/10/2011 prescribing the ceiling limit for considering application for appointment on compassionate grounds. In terms of this, comma, for the period 1/7/2012 to 1/12/2012, the monthly income, the ceiling limit was a sum of rupees 26,066. They contend that for the purpose of considering an application filed for appointment on compassionate grounds, comma, the income of the family from all sources of the person, all the persons, whether living separately or jointly, including the earnings of other family members, has to be considered. They contend that the two brothers of the petitioner also employed with the respondent number two, one na two na?
Respondent number two.
One and two na?
Respondent number 2 only.
Respondent number two. And therefore, comma, their income also has to be taken into consideration. And if done, comma, the petitioner is not entitled to be appointed as the income was beyond the ceiling limit prescribed. In support of their contention, they relied upon the judgment of the division bench in writ appeal 30918 of 2012. Full stop. In reply, the learned counsel for the petitioner submitted that the word family is defined.
Regulation 2B.
Huh?
Regulation 2B, Malad.
Under regulation 2B, which does not include the members who are not residing, living with the family of the deceased employee. It therefore contends that the income of the brothers of the petitioner could not be taken into account. And it is only his income as well as the income of his mother that had to be taken into consideration. And if done, he was entitled to compassionate appointment. Next, for I consider submission made by the learned counsel for the petitioner and the learned counsel for the respondents. The father of the petitioner died on 5/9/2012. Full stop. As on that day, the rules that were in force was the one issued by the respondent number 1 on 23/9/2011. Full stop. Rule 3 of the said circular, I don't know, rule 3 and thing, clause 3 of the said circular reads as follows, copy mode, page 31. It specifically provided that the monthly income ceiling limit is variable as and when there is an increase in the rates of DA/HRA or revision in the scale of pay of the post of FDA in the state government. The computing ceiling limit will be intimated periodically. Full stop. Though the petitioner contends that his two brothers were living separately, nothing was placed on record before the court to establish the said fact. Even otherwise, it is undisputed that the two brothers of the petitioner are already employed with the respondent number 2. Full stop. If the family members of the petitioner are already employed, are already gainfully employed, it is too much for the petitioner to expect the corporation to provide compassionate appointment while his two brothers do not show any concern towards the petitioner. Full stop. The board, the respondent number 2, has framed uniform, has issued the circular for uniform application to all its employees. The board cannot be expected to conduct a mini inquiry to find out whether the members of the family of the petitioner are really supporting the petitioner or not. Full stop. This is one of the criteria that the board has to take into consideration while considering the applications for appointment on compassionate grounds. Full stop. The division, as rightly contained by learned counsel for the respondents, comma, the division bench has considered the very same question and has upheld the applicability of the computation of the total income of the family as per Regulation 4.1 of the Regulations 1997 to hold that the income of the family from all sources of all the persons should be taken into consideration. And if it is only less than the income prescribed by the board from time to time, would an application for appointment on compassionate grounds be considered? Full stop. As stated by the learned counsel for the respondent number 2, comma, the monthly income for the period 2017-2012 to 31/12/2012 was a sum of rupees 26,066, which was to 66, and but the income of the petitioner from income of the family of the petitioner from all sources was way beyond the monthly limit fixed by the respondents. Therefore, comma, the petitioner was not entitled to be appointed on compassionate grounds. There is no error in issuing the impugned endorsement warranting interference. Hence, the petition is dismissed. Yes.
Number 40, urgent serial number 41, AJ Srinivasan.
AJ Srinivasan.
Each, if I may,
I appear for the respond.
state the little facts, my lord, few facts.
In the morning, you said you're supposed to get some documents.
Records,
What happened, Kashif?
Lord, this matter was heard, my lord, before your lordship, my lord.
That is right, I don't remember. Anyway, what happened?
My lord, since these records pertain to, my lord, 2001, 2002, we were able to collate some of them, my lord. I have got information. In fact, none of the allegations made by petitioners are true. My lord, the contention is that bank has adopted different methodology for different persons, and that some of them have been relieved, my lord, from the date they were actually relieved because of the orders of the Honorable High Court. No, that is not true. In all these cases, my lord, I have instructions to say the day their VRS was accepted, they were relieved on that day. I have instructions and I'm submitting it on record. And my lord, some of them they were able to dig in. In fact, my lord, he also made a submission to say.
So what was the direction to you?
My lord,
your lordship had said.
Actual records, my lord.
Your lordship had
directed them to produce the records.
So it says to give specific details of the persons found in page 48 of the petition.
Yes, my lord.
Insofar as it relates to the dates when they submitted the request for voluntary retirement.
Yes.
When it was accepted.
Yes.
When they were relieved. When their request for voluntary retirement was allowed to be withdrawn.
Yes.
As also when they were granted the terminal benefits.
Yes.
Yes,
my lord. If your lordship sees my memo, Lord.
What is page 48 of the petition?
Lord, 48 contains list of, my lord, persons which the petitioner alleges that, my lord, they were relieved on subsequent date, even though they were
The lordship may
offer of
see
acceptance.
at serial number 20, my lord, of page 48, my lord. My lord, before that, I'll just submit how it is relevant, my lord. My lord, the few facts are like this, my lord.
I'll take it up for disposal only if both of you are ready.
I'm ready, my lord. I'm ready.
I'm ready.
Subject to learn. In fact, on merits, I'm ready, my lord, because this is, my lord, just to say that there is no parity. But on merits also, he is not entitled to. I will establish before your lordship. I'm ready to address my.
You ready?
Yes,
Yes, please go on.
yes. My lord, the facts of the case are like this, my lord. So, my lord, the petitioner, my lord, the brief facts are like this, my lord. The petitioner submitted his, under the VRS scheme, which was an operation on 31/1/2001. He submitted his, applied for VRS.
31/1/2001.
And then, my lord, it was accepted, my lord, on, he was supposed to be relieved on 34/2001, before which he withdrew his VRS and approached since they were no, before
When
he
did-
could be
when- When
released
did he withdraw?
on 27/4/2001.
27/4.
2001.
That is 3 days before.
Yes, my lord. Before being relieved, he withdrew it, and then, my lord, before he was relieved, he approached this court. The court stayed the proceedings, my lord, and subsequent to that, he worked, my lord, and he was also the single judge's order was also in his favor, stating that he had withdrawn it and it was within his right to do it. And thereafter, my lord, this was appealed by the management before the in writ appeal, my lord. During that time, what happened was, my lord, he also was promoted as manager, my lord, and he worked as a manager. Unqualifiedly, he was promoted as a manager without any reservation subject to the appeal. And then he retired. At that time, my lord, the Supreme Court had passed an order, my lord, stating that once a VRS has been given, it cannot be withdrawn, was the judgment, my lord. Pursuant to that, what the court, the division bench said was, my lord, I could make a representation to them, stating I had hardly a few more years of service, my lord. And all those people who had retired from service, my lord, during the pendency of the matter, they were paid all the benefits up till the date of their retirement. As though they retired without VRS, they were paid, my lord. And there were also one more group of people, my lord, who had withdrawn the matter during they had also obtained stay from this court and they were working, continued to work. But they withdrew from the writ petition, and the management paid them both the VRS amount and till the date they retired. As on the date when they withdrew the petition, my lord, the court had passed a stay order. Up till that day, when they worked the last work, till that day they gave them the terminal benefits, gratuity, PF and everything, my lord. I want to be treated equally only because I have succeeded before the learned single judge, and then matter was pending before the division bench. At their instance, they had filed an appeal. I could not have withdrawn the petition. It was before the writ appeal. They had approached. The question is whether you can discriminate against me, stating that because you have not withdrawn, I'll pay you as on 2001. That is as on the date of my submitting my VRS. They pay me gratuity, all the benefits, only on the basis of this one. And that representation, my lord, before the writ petition, my lord, by that time it was 10 days, my lord, and before the order copy could come, my lord, they relieved me, my lord. So I could not, I placed a representation which was not considered. Yes. And that is why I came before this court, my lord. I am all that I'm asking is this, my lord, to be treated on par with all others who have been relieved.
What did the division bench say?
My lord, the division bench, my lord, the order of the division bench was, your lordship gets it at page number 10, my lord, 27, my lord. Yes. Is the relevant portion. 27, at page 8, para 8, may I read, my lord? At this stage, the learned counsel for the respondent number 1 seeks leave of this court, make representation to the appellant bank, seeking permission to allow him to continue till the date of its superannuation. He made such submission in view of the fact that the virtue of the undertaking given by the appellant bank respondent was allowed to continue work as assistant manager. It appears that there was an interim order passed by in writ petition, and by virtue of thereof, he was continued to work not as clerk, as assistant manager by the time I was promoted. During the pendency of the writ petition, respondent number 1 has promoted as assistant manager. In view of the facts, he seeks leave to make representation as aforementioned. He further admits that hardly 2 years. I had only 2 years of service. Respondent number 1 is left and he is allowed to continue. It is open for the respondent number 1 to make representation as aforementioned to the concerned authority chairman within a period of 10 days from today. If any application representation is made, same may be considered by the concerned authority chairman sympathetically and communicated its decision to the respondent number 1. If the applicant representation is accepted, the appellant bank shall allow the respondent number 1 to rejoin and continue till he attains the age of superannuation. We hope and trust that the concerned authority chairman shall decide the application representation.
So when did you give the representation?
My lord, that was on, my lord, 15/2/2012, my lord. The next annexure B, my lord.
15/2/2012.
12.
What did they decide?
My lord, they said, my lord, they did not decide because they said after 10 days you have come. Not the 10 days, but the order copy, what was dictated before the court, I could not hear, my lord. After the order copy, on the same day, I have given a representation as soon as the representation I got.
We have,
Why are you
he was, by the time he made the representation, he was already relieved. He was already relieved from service. All settlements were already.
They were
That's
before the
okay,
court
but,
arguing this matter, my lord.
You made a statement before the court. He has given.
Before
Why
that,
act
my lord,
like
could
Shylock?
your lordship see para 7 of the order? Starts from page 25. My lord, if I may take your lordship only to page 26, my lord, right hand portion.
Yes, please.
My lord, after 3-4 lines, under the circumstances, it was held that the revocation was possible and effective at any time before acceptance. Up to such acceptance, no legal obligation excluded. On the second question, it was held that those employees who have accepted the payments or any other benefit under the scheme cannot approbate or reprobate, nor can be permitted to withdraw. It is that clear that the scheme was contractual in nature. It is constituted an invitation and not an offer, and therefore revocation was possible and effective at any time before the acceptance. This position of law has not been disputed by the learned counsel for respondent number 1. In view of the well-settled position of law and admitted facts, we have no option but to allow both these appeals and set aside the orders of the impugned therein, ordered accordingly, no cost. Now, my lord, the writ petition was filed challenging the order of relieving. Lord, by virtue of an interim order, he continued in service. Now, my lord, writ petition is dismissed. Lord, eventually, based on this writ appeal order, writ petition is dismissed. Therefore, my lord, the order relieving him from 2001 is confirmed. Lord, what now he's saying is, my lord, as on the date of passing of this order, I had 2 more years of service left. You please consider. My lord, immediately after this order, my lord, he did not make the application for representation. Either way, my lord, he was not entitled to. Legally, he is not entitled to.
The court said, and you said, okay, we'll consider.
My lord, by that time, he was already relieved. My lord.
Okay. He didn't make the application.
After relieving, there's no question of consideration. What happens is, my lord,
this court passed an order. You also said we'll consider.
Please, my lord, if he makes the application within 10 days. My lord, he had not made it in 10 days, so we relieved him. My lord, what happened is, my lord, it has to be, my lord, on day-to-day basis. Because, my lord, if today is the last date for, my lord, applying, and he does not, tomorrow he gets relieved automatically. My lord, the bank does not have a say in that. Only thing is, my lord, whether he is legally entitled to, my lord, the question of law before your lord.
Ordinary course, when he would have retired.
My lord, ordinary course, my lord, he would have retired in 2014. My lord.
2014,
my lord, the exact date, my lord, I can see.
What was the last date he worked?
My lord, 13/2/2012.
13/2/2012.
Yes.
He worked until then.
Lord, pursuant to an interim order of this honorable.
Anyway.
Yes.
So what do you want to do?
Lord,
make an offer.
Lord, may I make place on record, my lord, the law on the point, my lord, because these are covered by few decisions of the Honorable Supreme Court and also, my lord, this Honorable Court. Lord.
Yes.
My lord, may I invite your lordship's attention to, my lord, the second judgment at ink page 5, my lord, State of Gujarat and others versus Dilip by Sriram Patil, 2006, my lord, 3091. My lord, identical matter. If your lordship takes page 6 and para 5, please, my lord.
But why did you give him the promotion of assistant manager?
Lord, because, my lord, he was working as a, my lord, because of the interim order passed.
But then why did you
any employee, my lord, who is continued in service, my lord, whether it is by virtue of an interim order or otherwise, my lord, if he continues in service and promotions falls due, Lord, he will be entitled to. It is not a disciplinary matter where it will be kept in sealed cover, my lord.
Correct, but why did you give him the promotion?
My lord, we had to because he continued in service, my
It
lord.
was based on interim order.
But, my lord, the interim order eventually merges with the final order, my lord, and this honorable court has dismissed the writ petition. Therefore, the order relieving him in 2001 is confirmed. Lord, for that period, from 2001 to 2012, Lord, he's worked, he's gotten salary, he's gotten promotion, he's gotten increment, and he's been paid.
Yes.
But whether he's entitled to other benefits for having, my lord, this honorable court upholding the decision of relieving him from 2001. Therefore, my lord is not entitled to. That is what I'm only trying to point out before your lordship. Paragraph 5, my lord. My lord, this is only on the ground of.
Did not
My lord,
much
this-
on that.
Yes, my lord. The next judgment, if your lordship takes, my lord. My lord, this honorable court's order, my lord, in page 17, my lord, ILR 2007, Karnataka 1821. Division bench of this honorable court. My lord, the relevant portion of your lordship comes to in page 24, para 7. Learned counsel for the respondent invited our attention to the decision of Supreme Court in so and so, wherein the Supreme Court, following the judgment of the Constitution bench, held that when labor courts recorded a finding that the domestic inquiry is defective and gave opportunity to adduce evidence, the management workmen thereafter recorded the finding that the dismissal was valid. It would relate back to the date of original dismissal and not to the date of judgment of the labor court, even though the facts are not exactly similar. Learned counsel is right in pointing out that the principle of subsequent decision relating back to the date of original decision was recognized by the Supreme Court. And as counsel for the respondent is also right in contending that if the contention of the appellant is accepted, an anomalous situation would
The VR benefit, can you calculate?
He's gotten that.
2012, as on 2012, can
My
you
lord, VR
calculate?
benefits, what happens was, my lord, VR benefits was released to him in 2001. My lord, he was there was a joint note between the Indian Banks Association and all banks where, my lord, they were entitled to get pension. This was in 2010. Because he continued in service, my lord, he got entitled to that. He had applied for that. And my lord, he was paid pensionary benefits. He continues to draw pension also. The only thing is, my lord, for that period, will that be counted as, my lord, in service or not? My lord, the dishonorable court and, my lord, the honorable Supreme Courts have said that it will relate back to the order, original order, since the writ petition has been dismissed eventually.
Yes, yes.
My lord. Just a few.
And, my lord, on the point of, my lord, the discrimination, my lord, my memo, if your lordship sees, none of them, my lord, have been given that benefit. Few of them, in fact, my lord, attained the age of superannuation.
But
while
he
in
has
service.
given a, what we call list of employees
Yes, my lord.
who are being given the benefit of.
Correct, my lord. That is not true. If your lordship sees my memo, the
lord,
next page, my lord.
Please come to the memo that he has, the document that he has.
Yes, my lord.
47 is under the RTI, my lord. This was provided for 47. This is an annexure 48 is an annexure to
Yes,
47.
yes, 48. What do you say about this?
My lord, I have been able to get details of that, my lord. My lord, the assertion that some of them withdrew the case, my lord, is not true. My lord, I have gotten information of some of them. My lord, few of them had never filed, my lord, challenging the relieving order.
But then VRS case withdrawn.
My lord, that is not correct. My lord, my lords must see my memo. My lord, because this is 2007, my lord, I could get some.
Through RTI.
They have not.
My lord, this is not, my lord.
How did you confirm it through RTI?
It was given
My
to
lord,
RTI.
what I'm saying is all of them were relieved and their terminal benefits were calculated as on the date they were relieved as per VRS. None of them have been given benefit of service. My lord, for the period they continued in employment by virtue of an interim order. My lord, this is on record, I've submitted.
My lord, this contains only 6 people, my lord. Your lordship may see from page, at page number 48, my lord. Page, item serial number 20, my lord. Nirmal Sethi. He is superannuated and he was paid up till 2006.
Yes, he's superannuated.
1 minute. He submitted his VRS, but he was, since he superannuated during the pendency of the matter, he was paid till the date of superannuation. The next matter, my lord, is M. Narasimha Shetty, 21, my lord. He submitted his VRS, was withdrawn on 31/1/2002. He was an assistant manager like me, my
It
lord.
was date of relieving.
My lord, none of them were
Yes.
paid benefits,
And-
but I'm putting it on record as per instructions. They were relieved and all terminal benefits were settled as though they were relieved on the date of accepting VRS.
Yes, Mr.
My lord, here, my lord.
It might have been released at a later date, But
My
it was
lord,
construed as on the date of release.
Venkatesh Prasanna, your lawyer, 17, my lord, 17. A.K. Narayan Swami, my lord. VRS case withdrawn, 28, 2003. And he was, my lord, as on the date of 28, though he had submitted in 2001, my lord, till 2003 he was paid. As on the date
no,
of withdrawn.
No, no, no.
So,
That is not-
Prasanna,
that is
date
not
of
correct.
relieving is 31/12/2012. Senior manager, 31/12/2002.
Yes.
31/12/2002.
My lord,
Pension and gratuity.
17, Narsimha Narayana Swami, my lord.
Now you say Venkatesh Prasanna, now you are jumping to Narayan Swami.
Venkatesh Prasanna also, my lord, correct.
Oh, both.
Yes, my lord.
31/12/2002 is the date of relieving.
Yes, my lord.
VRS, gratuity
31/12,
and pension are
2002.
paid on the same date.
Yes. So what, no, my lord, he was allowed to, 2001 he submitted his,
Illide, 2001 anta.
my lord,
What is it?
all of them applied on the same date. VRS scheme is only for a particular period.
Correct.
So they all applied in 2001 along with him. They were all supposed to be relieved, but they continued by virtue of a interim order passed by this court.
Yes.
And when they continued to work, when they withdrew the matter, they were given a benefit of being paid all the terminal
But
benefits.
this
which they
document
had
does not say that.
till the date of being
But
relieved.
few of them have been paid at a later date because
And
of pendency
these
of writ
people's-
petition, but
these
none of them have been given benefit of that period. They were
Yes,
all
my-
relieved as on the date of
You
relief.
please have a look at this Dinakar Shetty.
Yes, my lord.
He was relieved on 2005.
Yes, my lord.
Another person, 2009, Arrow Shantaram Shetty. How is that possible? Shantaram Shetty, 2009.
Shantaram Shetty.
Yes.
My lord, he superannuated in 2009. My
Correct.
lord,
He had
date of relieving is 2009.
He had applied for VRS. You
Yes, my
allowed
lord.
him to- you
My lord,
allowed-
my lord, this document, your lordship may see last two columns
You allowed
are
him to
just the date on which they were paid these benefits, my lord.
No.
My
You
lord, may
allowed
kindly-
him to superannuate in 2009.
Yes, my lord.
And you given the VRS benefit on 28/2/2009 on 28/2/2000. That is the date of relieving.
Leaving. He worked till that day. My lord,
Please give the details.
my lord, the particulars given, my lord, is only of 5 people, my lord. But let
Yeah,
them
that
give of
also
these,
for the-
all these 26
Either
people, one thing, my lord.
you settle it with him by giving the benefit payable as.
Lord,
on
I was able
last
to get
date.
details of 6 people. My lord, the other
On the
people also I
last
will
date-
get.
On the last date, he worked, whatever benefit that he is entitled to, as on the last date he worked, you
Yes.
give it.
My lord, that legally is not entitled to, my
Then
lord.
you
as per-
consider,
Please,
you
my lord.
please.
I will
give
try
all
to
the
get
details.
all of those details, my lord. 6 of them I got it. Because of
All
my
the
lord
details are
merger,
good.
it takes some time. I may be given more, at least
No,
about
no,
2
no,
more
you
weeks
are
time.
being given more than 3 months.
All
This
records.
this
put
order
into
was
the-
passed in my last roster.
This erstwhile Vijay Bank, my lord. Problem. But my lord,
If you
I
want
will
to-
get instructions, my lord, to say that none of them have been paid. My lord, for the period they were in service due to an interim order. of
This
this
is an RT information that is
RT
given by you, mister. What was the order? When was the order passed, directing you to produce the documents?
My lord,
Purport, the learned counsel for the respondents seeks time to comply the order dated 18/9/2024. After hearing the learned counsel for the petitioner and the learned counsel for the respondents, this court is of the opinion that the information sought for by order dated 18/9/2024 is crucial and relevant for the purpose of considering this writ petition. Hence, the learned counsel for the response is directed to furnish the information by the next date of hearing, failing which, with the information furnished by the respondents, which is enclosed as at page number 48 in the petition, shall be taken into consideration for the purpose of considering the reliefs in this petition. Yes. Match. This town, when do you want it?
10 days. Please.
17 March.
17.
Serial number 42, K.R. Prasad Deva.
17/3, my lord.
17/3.
1 week, my lord.
Do whatever you want. I've given you
But
enough.
may I request for 23, my lord.
20 hour over 3. Prasad, your
23, great.
ರೆಡಿ ಇದ್ದೀರಾ ಹೇಳ್ರಿ ಎಲ್ಲರನ್ನು ಕಳಿಸ್ಬೋದಾ ಯು ಕ್ಯಾನ್ ಸೆಂಡ್ ಆಲ್ ದ ಲಾಯರ್ಸ್ You can tell all lawyers to leave. Can I tell all lawyers to leave?
I can't take it. I can't understand why.
ಎಲ್ಲ ಲಾಯರ್ಗಳಿಗೆ ನೀವು ಫುಲ್ ಕಂಪ್ಲೀಟ್ ಆಗುತ್ತೆ 6 ಗಂಟೆ ತನಕ ಅವ್ರನ್ನೆಲ್ಲ ಹೋಗಿ ಕೇಳಲ್ಲ.
ಇಲ್ಲ, ಬೇಕಾದ್ರೆ ಮಾಡ್ಲಿ ಅವರೇ.
ಹಾ?
Let me take tomorrow.
You're not ready. Huh?
Because some documents are misplaced.
Tomorrow. ನಾಳೆ ಆಗುತ್ತೇನ್ರಿ? ನಾಡಿದ್ದು. ಯಾವತ್ತು ಬರುತ್ತೆ? 14, Monday. I'll give you 1 week.
Oh, yeah.
Come ready.
Yeah.
Current counsel for the petition seeks time as a last chance list on Monday.
Number 43, Vijay Kumar.
Rajaram. Yes. Rajaram, Purambai.
2142 rights are covered by judgment of your lordship's judgment. Lord, the matter pertains to Lord's, the petitioner who is retired in the year 2014. Lord, he submitted his VRS application in 2014 and same has been accepted and he is permitted to retire from service. Lord, after his retirement, Lord, the notice came to be issued. And Lord, to which Lord I have submitted my explanation. Without considering the same, Lord, the procedure to straight away passed an order, Lord, so at page 37, annexure U. Chennai, here only.
Amount has been paid, my lord. I am reducing on letter, my lord.
But my instructions are, Lord, the amount of rupees,
Court of sir.
in view of the court order, Lord, the amount is paid. Lord, still, Lord, 2,81,000 rupees, which is withheld. Lord, in view of the notice which is issued to me. Lord, they say that, Lord, there is an alleged loss to the board. That incident has taken place long ago in the year 1996-97. I have submitted my reply to I have nowhere concern to that loss, my lord. And thereafter, my lord, so after my retirement, my lord, they have issued the notice and which I have submitted a reply to the same. And my lord's annexure U is the impugned order by which, my lord, they have withheld my DCRG and CVP.
My lord, we have filed
ಯಾವಾಗ ಈ allegations ಎಲ್ಲ ಯಾವಾಗ
return statement, we have filed. Return, sorry, objections.
ಸ್ಟೇಟ್ಮೆಂಟ್ ನೀವು ನೋಡಿ
Yes, ma'am.
ನೋಡಿ ಈ ರಿಕವರಿ ಯಾವಾಗ ಇಶ್ಯೂಸ್ ಆಗಿದ್ದಲ್ಲ ಯಾವಾಗ ಇದು? When did this allegations made against the petitioner happen?
My lord.
Said that some work was executed not to the satisfaction ಅದೆಲ್ಲ ಹೇಳಿದಿರಲ್ಲ.
Yes, ma'am.
There was some loss ಅಂತ. ಎಷ್ಟನೇ ಇಸ್ವಿನಲ್ಲ ಅದು?
2000.
Annexure S, page 33, may kindly be seen. Annexure S, page 33. First paragraph. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರ 1ರಲ್ಲಿ ನೀವು ಕೋರಿರುವಂತೆ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರ ವಿಭಾಗ ಶಿವಮೊಗ್ಗ ಇವರು ಉಲ್ಲೇಖಿತ ಪತ್ರ 2ರಲ್ಲಿ ನೀವು ಶಿವಮೊಗ್ಗ ವಿಭಾಗ ಕಚೇರಿಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಸಮಯದಲ್ಲಿ ಶಿವಮೊಗ್ಗ ನಗರದ ಗಾಡಿಕೊಪ್ಪ ಬಡಾವಣೆಯಲ್ಲಿ 2 ಲಕ್ಷ ಲೀಟರ್ ಸಾಮರ್ಥ್ಯದ ಮೇಲ್ಮಟ್ಟದ ಜಲಸಂಗ್ರಹಣಾಗಾರ ಕಾಮಗಾರ ನಿರ್ವಹಿಸಿ. Yes, page 33, my lord.
Annexure yes.
Annexure yes, 29/10/2014.
ಎಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ದೀರಾ ಗೊತ್ತಾಗ್ತದೆ.
First paragraph.
ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ನೀವು ಶಿವಮೊಗ್ಗ ಕಚೇರಿಯಲ್ಲಿ
ತಾವು ಶ್ರೀ ಸೋ ಸಹಾಯಕ ಅಭಿಯಂತರರು ಆದ ನಿಮ್ಮ ಹೆಸರಿನಲ್ಲಿ MAS ಲೆಕ್ಕದಲ್ಲಿ ನಮೂದಿಸಲಾಗಿದ್ದ ಮಂಡಳಿಯ ಸಾಮಗ್ರಿಗಳನ್ನು 1,64,000 ಲಕ್ಷಗಳ ಮೊತ್ತದ ಈ ಕಾಮಗಾರಿಗೆ ಟೆಂಡರ್ ಮುಖಾಂತರ ನಿರ್ವಹಿಸಿದ ಗುತ್ತಿಗೆದಾರರಿಗೆ ನೀಡಲಾಗಿದ್ದು ಈ ಕಾಮಗಾರಿಯನ್ನು ಅರ್ಧಂಬರ್ಧ ಮಾಡಿ ಪೂರ್ಣಗೊಳಿಸಿ ನಿಲ್ಲಿಸಿದ ಮೇಲೂ ಸಹ ನೀಡಿರುವುದನ್ನು ಕೇಂದ್ರ ಕಚೇರಿಯ ನಿವಾಸಿ ಲೆಕ್ಕಾಧಿಕಾರಿಗಳು RAO ಈ ಮೊತ್ತವನ್ನು ಸಂಬಂಧಪಟ್ಟ ಶಾಖಾಧಿಕಾರಿಗಳನ್ನು ವಸೂಲು ಮಾಡಲು ತಪಾಸಣಾ ಖಂಡಿಕೆ ಭಾಗ 96-97ರಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆಂದು ಕಾರ್ಯಪಾಲಕ Lords, in the year 2014, I am permitted to retire. Lords, I submitted.
We have filed objections, madam. Kindly.
Objections ನೋಡ ಹೇಳ್ರಿ.
Yes, madam.
ಸಿಂಪಲ್ ಕ್ವಶನ್ ಕೇಳ್ತಿದ್ದೀನಿ. ಈ ಅಲಿಗೇಷನ್ 96-97 ಬಂದಿರೋದು. 96-97 ಅಲಿಗೇಷನ್ ಬಂದಿರೋದು. ಇವ್ರು VRS ಕೊಟ್ಟರು 2014 ನಲ್ಲಿ. VRS ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದಿರಿ. ನಂತರ ನೀವ್ ಹೆಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ?
Yes, to
more than 4 years.
My lord, audit objections, he has to comply the audit.
ಕೊಡ್ರಿ ಅದು
Before retirement, he has to.
214 ಕೊಡ್ರಿ. 214.
I am placing your lordship.
ಜಡ್ಜ್ಮೆಂಟ್ ಇರ್ಲಿ ಅವ್ರಿಗೆ ಚೆನ್ನೈಗೌಡರಿಗೆ ರೂಲ್ 214 ತೋರಿಸಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
Yes, ma'am. This is taken in the objections also. The respondents have asked the petitioner to comply the audit objections. Until compliance, it is ordered
to withhold the pensionary benefits for the purpose of holding inquiry 214 of 2B is applicable and it is not attracted to the facts and circumstances of the present case.
ಓದಿದ್ರ 214?
Yes, ma'am.
ಓದಿ.
No, it is in the objections it is stated.
ಓದಿ.
Master and servant relationship remains even after the retirement.
214 ಓದಿ.
Yes.
214 2B ಓದಿ.
Yes, ma'am. The departmental proceedings referred to in sub-rule 1, if instituted while government servant was in service, whether before his retirement or during his re-employment, shall after the final retirement of the government servant be deemed to be proceedings under this rule and shall be continued and concluded by the authority by which they were commenced in the same manner as if the government servant had continued in service.
2B ಓದಿ.
Provided, my lord. The departmental proceedings, if not instituted while the government servant was in service, whether before his retirement or during his re-employment, shall not be instituted save with the sanction of the government, shall not be in respect of any event which took place more than 4 years before such institution.
ಏನಂಗಂದ್ರೆ? ಏನಂಗಂದ್ರೆ?
ಅದೇ 4 years ರಿಟೈರ್ಮೆಂಟ್ ಮುಂಚೆ ಈ ತರ ಆಗಿದ್ರೆ ಮಾಡಬಾರ್ದು ಅಂತ.
ನೀವೇನು ಬರ್ದಿರೋ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ?
ಎಸ್ ಮೇಡಮ್, ಅಬ್ಜೆಕ್ಷನ್ಸ್.
ಓದಿ.
ಎಸ್. The respondents have asked the petitioner to comply the audit objections. Until compliance, it is ordered to withhold the pensionary benefits for the purpose of holding inquiry 2142B is applicable and it is not attracted in the facts and circumstances of the present case. Master and servant relationship remains even after retirement. When such employee causes pecuniary loss, the no objection certificates issued is only for the purpose of voluntary retirement and it would not absolve the board from recovering pecuniary loss caused by such persons. The decision referred to by the petitioner in para 20 is not applicable to the facts and present case.
2B ಹೆಂಗ್ ಅಪ್ಲೈ ಆಗುತ್ತೆ?
My lord,
ನಿಮ್ಗೆ ಅಪ್ಲೈ ಆಗುತ್ತೆ ಅಂತ ಬರ್ದಿರಲ್ಲ, ಹೆಂಗೆ ಅಂತ? ಹೆಂಗೆ?
it is the last two, I have passed on letter. We have released every, my instructions are.
ಎಲ್ಲ ವಾಪಸ್ ಕೊಡಿ ಅವ್ರಿಗೆ.
My lord,
You have to refund the money back to him.
the amount has been released, my lord. Only 2,81,000 is withheld. That's all.
ಅದನ್ನು ವಾಪಸ್ ಕೊಡಿ ಅಂತ. ನೀವು ಅವ್ರಿಗೆ ವಾಲಂಟರಿ ರಿಟೈರ್ಮೆಂಟ್ ಕೇಳಿದ್ರು ತಾನೆ?
Yes, ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ರು. ವಾಲಂಟರಿ ರಿಟೈರ್ಮೆಂಟ್ ಕೊಟ್ರು.
Yes.
ಅಷ್ಟೊತ್ತಿಗಾಗಲೇ ನಿಮ್ಮ ಹತ್ರ ಆಡಿಟ್ ರಿಪೋರ್ಟ್ ಇತ್ತು.
Yes, ma'am.
ನೀವೇನು ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ಲ. ವಿ ಆರ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರಿ.
Yes.
ವಿ ಆರ್ ಬೆನಿಫಿಟ್ ಕೊಟ್ಬಿಟ್ರಿ. ಕೊಟ್ಟಾದ್ಮೇಲೆ ನೀವು 96-97 ಆಡಿಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು ಅಂತ ರಿಕವರ್ ಮಾಡಿದ್ರೆ ಹೆಂಗಾಗ್ತದೆ ಅದು?
96-97 ಅಂತ ಎಲ್ಲಿ
ಇದೆಯಲ್ಲ ಅಲ್ಲಿ. ಪ್ಲೀಸ್ ಕಮ್ ಟು ಪೇಜ್ 33. 33 ಬನ್ನಿ.
course, pension petition.
ತಪಾಸಣಾ ಖಂಡಿಕೆ ಭಾಗ 96-97 ಅಂದ್ರೆ ಇನ್ನು ಹಿಂದೆ ಆಗಿರೋದು ಅದು. ಆಡಿಟ್ 96-97 ಅಂದ್ರೆ ಆಡಿಟ್ ಆಗಿರೋದು 96-97. ವರ್ಕ್ ಆಗಿರೋದು ಯಾವಾಗ? ಅದ್ರ ಹಿಂದೆ.
But before retirement, he has to comply the audit objections. This is my submission.
ಕರೆಕ್ಟ್. ಯಾಕೆ ಬಿಟ್ರಿ ಅವ್ರನ್ನ? ಓಕೆ. Why did you allow him to leave?
Produce
The date of VR 23/9, huh?
Please, my lord, 1 minute.
23/9.
Lord, I applied for the VRS on 23/9/2013. Lords, on 30/12/2013, the NOC issued by the superior officers. On 31/1/2014, I am permitted to retire. And on 13/2/2014, I made representation for release of my VRS benefits.
13/2.
13/2/2014, my lords. I made a representation for release of my VR voluntary retirement benefits. On 9/7/2014, Lords, leave encashment was sanctioned. On 20th of October 2014, the notice was issued seeking explanation with regard to audit para of 96-97. On 10/11/2014, Lords, I submitted my explanation to the shockers notice. And Lords, on 4/12/2014, Lords, impugned order came to be passed, Lord, withholding my DCRG, CVP, as well as 10% of pension.
The petitioner has challenged the endorsement and the order bearing number so and so dated 4/12/2014 issued by the respondent number 2, withholding DCRG and CBP in the
Commutation value.
commutation value of pension payable to the petitioner on his retirement. He is also sought for a direction to release the withheld DCRG and CBP payable to the petitioner, amounting to a sum of rupees 10,86,046 along with interest at the rate of 12% per annum from the date of his voluntary retirement, that is 31/1/2014. Next para. The petitioner contends that while he was working as a section officer / overseer during the year 1996-97 in the office of the executive engineer, Shumaga division, certain works that were executed by the contractor were not complete. The board therefore rescinded the work, and consequently the incomplete works were executed by awarding the work to a contractor under risk and at the cost and risk of the earlier contractor. Full stop. The contractor who took over the work completed the work in all respects and the final bill was paid. Full stop. Later, the petitioner submitted his application for voluntary retirement and his application was accepted on 31/1/2014.
Yes, ma'am.
Yes, ma'am.
Full stop.
Yes, ma'am.
However, while settling the VR benefit, voluntary retirement benefit, the DCRG and the CVP payable to the petitioner was withheld. Full stop. The petitioner contends that he had obtained a no objection from all the authorities concerned before his voluntary retirement was accepted
30/12/2013.
on 30/12/2013. Full stop. He contends that the respondent has now caused a notice dated 2010/2014, demanding certain amounts payable in view of an audit objection raised in the year 1996-97. Full stop. The petition is therefore before this court challenging the order dated 4/12/2014 by which his DCRG and CVP payable were withheld. Full stop. The learned counsel for the petitioner submits that the allegations related to events that happened somewhere during the year 1996-97. Full stop. He contends that the petitioner was permitted to retire on 31/1/2014.
Yes, please.
31/1/2014. And his leave encashment was also released on 9/7/2014. Full stop. It is long thereafter that the respondent number 2 had issued the impugned order holding the DCRG and CVP payable in the light of certain audit objections raised. Full stop. He contends that under Rule 2142B of the KCSR, if the alleged incident took place 4 years prior to the date of retirement, no steps can be taken to recover the said amount. Full stop. The writ petition is opposed by the respondents who contend that the relationship of employer and employee does not terminate on mere acceptance of the VR voluntary retirement. It is contended that the petitioner was responsible for the loss caused to the respondents, and the same was evident from the audit report. And thus, steps were taken to recover the amount mentioned in the audit by withholding the DCRG and CVP. Full stop. Next para. The fact that the petitioner had submitted his application for voluntary retirement is not in dispute. On 23/9/2013, he is not in dispute. It is also not in dispute that the concerned authorities had issued appropriate NOCs allowing the petitioner to retire from service voluntarily. Full stop. The application of the petitioner for voluntary retirement was also accepted on 31/1/2014. Full stop. The petitioner submitted his application for voluntary retirement benefits on 13th February 2014, consequent to which the leave encashment was released on 9/7/2014. Full stop. When it came to release of TCRG and the commuted value of pension, the respondents issued the impugned order withholding the same on the ground that certain audit objections were raised in the year 1996-97. Full stop. Under Rule 2142B of the KCSR rules, to which is applicable to the respondents, the any recovery uh, 214 clause 2B, no departmental proceedings shall be initiated against a government servant, whether before his retirement or during his re-employment, if it is not in respect of any event which took place more than 4 years before such institution. Full stop. In the case on hand, the alleged audit report was in the year 1996-97. Full stop. The respondents proposed to recover the said amounts long after the petitioner had applied for voluntary retirement in the year 2013. Full stop. Therefore, the action of the respondents in withholding the DCRG and the CVP payable to the petitioner falls foul of Rule 2142B of the KCSR. Consequently, the impugned order passed by the respondent number 2 warrants interference. The petition is allowed. The impugned order is quashed. The respondent number 2 is directed to forthwith refund all the DCRG and the CVP and other amounts payable to the petitioner along with interest at the rate of 9%.
Interest. 30th of May 2017, Lord, this honorable court is pleased to pass order, Lord, releasing of 6,27,096 rupees. They withheld 2,81,000 rupees only in respect of the alleged amount.
To release all the balance of the DCRG and the commuted value of pension payable to the petitioners along with interest at the rate of 9% per annum.
Only 2,81,000. Interest,
2 lakhs
interest, not our fault, my lord. It is
not your fault. Your fault. Why did you allow him to?
Public, my lord.
Delay in
public, my
settling
lord.
3 years, Lord, that
No,
too
allow him to
after
retire.
approaching
interest,
this
my lord.
honorable court,
Interest,
Lord,
can-
interest is not
9% per annum.
Interest is bad, my lord.
9% per annum from the date of the acceptance of VR voluntary retirement till the date of payment. Yes, grateful. The same shall be done, complied within a period of 3 months from the date of receipt of a copy of this order. Grateful. Ah. Yavat beko tol 2025.
Serial number.
25 it can we can repeat
serial-
on Friday.
Serial number.
My lordship.
Hello, Friday becker 2025 matters we can take on Friday.
Friday, I am appearing for the institute. Friday, I have little difficulty, my lord, personal difficulty.
Yavat.
Lordship.
ಇದು ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಬರ್ತಿದೆ ಅಲ್ವಾ?
Your Lordship, in that matter,
Age is also-
any date on 20th or any date after 20th. ಅಲ್ಲ
ಆಯ್ತು, ಇಂಟ್ರಿಮ್ ಪ್ರೇ ಯಾವತ್ ಬೇಕು ಹೇಳಿ.
20 ಅಥವಾ 21 any date.
Monday 18th may not be.
18.
He is not there, Your Lordship. That's my difficulty.
ನೀವ್ ಯಾರಿಗೆ?
I am the state government, Your Lordship.
ಅಲ್ಲ ಯಾವತ್ ಬೇಕು ಹೇಳಿ. ಬೋತ್ ಆಫ್ ಯು ಡಿಸೈಡ್.
ಅಲ್ಲ 20th or 21st or 22nd, any
My
date.
lords, I appear for the private respondent in that matter. Senior counsel is being engaged in that matter. If it could be first week of April, we had- he's not available, that's why.
ರೆಸ್ಪಾಂಡ್ ಇದ್ರೆ ಮಾತ್ರ ಕನ್ವೀನಿಯಂಟ್ ಆಗಿ ಹೇಳ್ತೀರಾ 1st of April ಅಂತ. ಪಿಟಿಷನ್ ಆಗಿದ್ರೆ ಹೇಳ್ತೀರಾ ಹಂಗೆ?
No, my lords.
ಇದ್ರಲ್ಲ ಸೀನಿಯರ್ ಇದ್ರಲ್ಲ. ಇನ್ ವಾಸ್ ಹಿಯರ್.
That's it.
ಯಾವತ್ ಬೇಕು ಹೇಳಿ ಸರ್?
20th or 21st.
22nd.
22nd list on 20
Serial number 55.
Serial number 50, your lordship.
for consideration of interim prayer ಅಂತ ಹಾಕ್ರಿ. 22nd.
Serial number
56, Your Lordship. 10 days accommodation, Your Lordship. ಅಲ್ಲ ಅದು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ತಾ ಇದೀವಿ kindly, Your Lordship.
ಸುಬ್ರಹ್ಮಣ್ಯ ನೀವು ಬರೋದಿಲ್ಲ, ಯಾಕೋ 3-4 ದಿನದಿಂದ ಬರ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ, we had said that.
ಅಲ್ಲ.
I was in Dharwad. I'm sorry, I could not.
ಒಂದ್ ಕಡೆ ಇರಿ, ಎಲ್ಲಾ ಕಡೆ ಯಾಕೆ ಹೋಗ್ತೀರಾ? ಇಲ್ಲೇ ಬೇಕಾದಷ್ಟಿದೆ.
Lords, this is covered by the decision of this honorable court, my lords, more than 2 decisions on the very same issue.
ಆಯ್ತು, ಯಾವತ್ ಬೇಕು ತಗೊಳ್ಳಿ.
10 days.
ಅಲ್ಲ, ಅವ್ರು 10 days.
23
Please.
20th.
serial number 55.
20th, 19th.
ನಾವು
For 53, my lord.
ಎಲ್ಲಾರ್ಗು ಇದು ಬರೀ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ತಗೋತಾ ಇದೀವಿ. ಸೊ therefore I said we'll concentrate on old matters as also other matters. So ಒಂದೊಂದ್ ದಿನ ಒಂದೊಂದು ಕೊಟ್ಟಿದೀವಿ. ಅಲ್ಲಿ ಹಾಕಿದ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಡಿಸ್ಪ್ಲೇ ಮಾಡಿದೀವಿ ನೋಡಿ.
Would it be on 24th? Lords?
ಅಲ್ಲಿ ಯಾವ್ದಿದೆ ನೋಡಿ, ಆ ತಾರೀಖ್ ತಕೊಳ್ಳಿ, ಯಾವತ್ ಬೇಕೋ ತಗೊಳ್ಳಿ.
Serial number 55, my lordship. This is my lordship dismissed the petitioner without any notice.
24th.
My lordship, some urgency is there, my lordship, they have illegally dismissed without any notice or prayer role from the authority, my
Right.
lordship.
ಯಾವತ್
Kindly,
ಬೇಕೋ ತಗೊಳ್ಳಿ.
2:30, my lord, tomorrow. No, some urgency, my lordship, without.
2024 will not take up.
No, because my lordship, in an earlier occasion, this honorable court.
No,
is, my lordship,
2024 will not take up.
Consider the final disposal ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ last
2024
occasion.
ಯಾವತ್ ಬೇಕೋ ಕೊಡ್ರಿ, ಯಾವತ್ತಿದೆ ನೋಡ್ ಕೊಡ್ರಿ.
58, my lord. 58.
ಅನಿಸುತ್ತಲ್ರಿ, ಇವ್ರದ್ದು ಯಾರ್ದು ರಾಜ್ಕುಮಾರ್ದಾಗ್ಲಿ
55.
55
58. Agency is there, my lord.
ಯಾವತ್ತೋ ಒಂದು ಕೊಡಿ, ಡೇಟ್ ಕೊಡಿ.
24th.
20, yes.
54.
54,
Lordship,
28th March.
58, my lord, for interim, considered for interim prayer. It may
ಯಾವ್ದು?
proceed during, till number 58, my lord. That come last week and notice has been ordered for consideration of interim prayer. 58,
ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ಇಂಟ್ರಿಮ್ ಪ್ರೇಯರ್ ಅಂತ ಹಾಕಿ. ಯಾವತ್ ಬೇಕು?
Thursday or Friday this week.
ಯಾವತ್ತೋ ಒಂದು ಕೊಡಿ.
Serial number 53, my lord.
45, yes madam.
Serial number 53, my lord.
ಮಂಜುಳಾ ತೇಜಸ್ವಿ. 2015 ಕೊಡ್ರಿ, ಯಾವತ್ತು? ಮಂಡೇ. 45 ಮಂಡೇ.
My lord, serial number 53, my lord. Petitioner is without job, my lord. Regularization now. But he was appointed, she was appointed a computer operator.
ಯಾವುದು? 53.1 ಡೀಲಿಂಗ್ ಆಗಿದೆ. 20ನೇ ತಾರೀಕು ಅಂತ ಹೇಳ್ತಿದ್ರಲ್ಲ.
Please.
14, my lordship.
20.
20 lang ಆಗ್ಬಿಡುತ್ತೆ. ಅಲ್ಲ,
ಹಂಗೇನಿಲ್ಲ. 2024 ಇಂದ ಇದ್ರೆ ಇವಾಗ ಹೆಂಗೆ ಒಂದ್ ವಾರದಲ್ಲಿ ಲಾಂಗ್ ಆಗ್ಬಿಡುತ್ತೆ.
ನಾನು ಅವಾಗ್ಲೇ ಇಂಟೀರಿಯಂ ಸ್ಟೇ ಕೇಳಿದೀನಿ, ಫೈನಲ್ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದೆ.
47 ನೋಡ್ರಿ.
Serial number 49, my lord.
24.
Serial number 40.
ಯಾವುದು?
56, sir.
56. When do you want it?
24th.
24th.
Lord, serial number 50, my lord.
14.
Now, what is happening is my retirement benefit is not being disbursed, citing the pendency of this petition.
ಆಯ್ತು, ಯಾವತ್ ಬೇಕು
My
ತಗೊಳ್ಳಿ.
lords may kindly, Friday, my lords, if it is
ಫ್ರೈಡೇ ಇಲ್ಲ. 2019 ಯಾವತ್ರಿ?
Monday.
2019 Tuesday.
Tuesday.
Lordship, serial number
Yes, madam.
49, your lordship, 2019 matter.
My lords, there is an interim,
I am for the
there
respondent.
is an interim order.
All interim orders will be extended.
2019 matter, your lordship, serial number 49.
ಹಾ.
I am for the respondent, your lordship.
ಸುಬ್ರಹ್ಮಣ್ಯ 18 ಕೊಟ್ಟಿದ್ದೀನಿ.
My lordship, my matter 230.
ಅರ್ಜೆಂಟ್ ಇದೆ. ಹೇಳ್ತೀನಿ ನಾನು ಹೇಳ್ತೀನಿ. ಫೆಬ್ರವರಿ 23 2024 ಮಾಡಿರೋದು.
ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಸಾಹೇಬ್ರ ಡೈರೆಕ್ಷನ್ ಇದೆ ನೋಡಿ ಇಲ್ಲಿ.
ಹೌದು ಸಾಹೇಬ್ರ ಡೈರೆಕ್ಷನ್. ಈ ಫ್ರೈಡೆಗೆ ಬೇರೆ ಮ್ಯಾಟರ್ಗಳು ಇಷ್ಟ ಆಗ್ಬಿಟ್ಟಿದ್ದಾವೆ. ಅವತ್ತು ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ ರೀಚ್ ಆಗಲ್ಲ. ಮಧ್ಯಾಹ್ನ 2:30ಗೆ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ ಪ್ರಾಬ್ಲಮ್
ಹೌದು. ಇಲ್ಲ ಸರ್, ಅದು 19ಕ್ಕೆ ಮತ್ತೆ ತಿರ್ಗಾ ಬೇರೆ ಬರುತ್ತೆ, ಬೇರೆ ಇಯರ್ ಬರುತ್ತೆ. ಅದಕ್ಕೆ ನಾನೇನ್ ಮಾಡಿದೀನಿ ಸಾಹೇಬ್ರು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ.
Sir, serial number 5624 ಅಲ್ಲ?